Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How does the FBI find people misspelled P-E-O-O-P-L-E? Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Because he's the guy.
Good morning. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Thank you very much for being here. Happy No Pants Friday. No Pants Friday. It is a beautiful day. It is a beautiful Friday. Oh, let's see. Weather outside, 51 degrees. It's a balmy 51 degrees. Actually, it is a new shirt. This is from a gift from Tammy Dunlap, one of our good members, and it has my little logo in it. Why am I not in focus? There. It says RA on it right there. All right. Just slowly getting going. It's a Friday after all. No rush to do anything. We're here. It's a very nice shirt. I like it. Thank you, Tammy. Appreciate that.
I object.
Let's see. Britta Aller says, I voted for your son this morning when I got to work. Apparently, a computer is better than a cell phone to vote. Thank you very much. He is super excited. He's with all those votes. He is so excited about that. I'm not sure if he's going to win, but at least
sent me a video of roaches fighting. I don't know who won.
Mm-hmm. At least he is enjoying the contest. All right, we have a couple things to go over. First thing in the morning, as always, and the first one is this. Oops, let's try that again. Apparently, I need to have Wi-Fi on for my wireless connections to work.
Subject matter jurisdiction.
Learning new things every day. There we go. Now we can turn it on. Actually, I was going for this one. Britta, first person in chat this morning was Christina Lynch. Christina, you've been here. You've been a supporter here for 2 months. I can tell by the blue courthouse. So I'm not sure if you knew, but being first in chat, you've broken the silence of the morning. And by breaking the silence, you've also sort of broken the unwritten law. And because of that, we have to sentence you to internet ownership. It's a punishment that only we can dole out. And you were first in chat. You appear to, you said hi. So it's not like you were hiding the fact that you were first in chat. You were just quite blatant with it. So we are going to sentence you to internet ownership. Congratulations. All of the internet is yours. That just means that in addition to every other thing you have to do today, which I'm sure you already had a small list, you also have to maintain everything IP related worldwide. It's a little thing, but I'm sure you can do it. Everyone before you has done so successfully, so we have faith in you. Congratulations, Christina Lynch. This also goes on your permanent record, and should you so feel inclined, you may go over to the merchandise page on our YouTube account and pay the fine, the 50-cent fine, and receive your downloadable fill-in-the-blank certificate commemorating this occasion. All right, why do I sound so somber this morning? It's my voice. Oh, it's a little loud. That's why. I was just loud in my ears. That's why. All right, we have fun things to do today. It's Friday. Does anyone have a birthday? Let's see.
When are we going to break for lunch?
Lois Cox, happy Friday to you. Thank you, my good friend. I appreciate you. Let's see. Just remembered no court on Monday. Oh, Ashley, President's Day on Monday. Which means that we have to have a police chase over the weekend. I don't know what else to do on Monday because no court will be in session on Monday. So I guess if you got a birthday on Monday as well, you might want to let us know now so we can sing to you because we won't be here on Monday if there's no court. Okay. Katie says, my grandma Donna's birthday, 92 years old. So we're going to sing to Donna. That is awesome. See if there's any other birthdays. I'm not seeing a lot. Selena K, good to have you here this morning. Good morning. There's the buffer sound. Let's see. So we have Donna. Oh, I'm way behind on chat. Holy cow, let me. Okay. Okay, I've got to make notes here. Because I've got to add Donna to this one. So Mattis Grease family, Stefan, Karen, Ingo, and Rania have birthdays. Malachi, Soraya, have birthdays. Deanne. Sorry, guys. This is how fast I type. And Donna. Whew. So we have Stefan, Karen, Ingo, Rania, Malachi, Soraya, Deanne, and Donna. Whew. I'm gonna mess this one up. I know I'm gonna mess it up. I'm gonna need you guys to sing extra loud today as we do the birthday cheers or the birthday song for everyone. I will get the warm up, everyone. Deep breath with me. La 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 la. There we go. Okay. I'm a hunting peck when I can't see the keyboard, and this mouse, or not this mouse, but this, they call it a dead cat, but it's a foam cover. It blocks my keyboard. Here we go. Happy birthday to you. 2 verses. Happy birthday to you. Happy birthday, Stephanie, Karen, Ingo, and Rania. Happy birthday to you. Harmonizing in the voice of Zeus with the thunder. With the thunder. That sounded great, 6-volt. Now if you can switch to Aphrodite for the next verse, 6-volt, that would be impressive. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Malachi, Soraya, Deanne, and Donna. Happy birthday to you. Lizzie Dog, happy birthday, Lizzie Dog. Happy birthday, Lizzie Dog. Lizzie Dog, I'm sorry, you came in late. I don't know what to do here. Should we sing to Lizzie Dog? Let's do it. Here we go. Look, there's another. I got thrown off by the second intermission. It's not called an intermission. Well, we're just singing to Lizzie Dog, this one here. Anybody else? I think it's just that. Happy birthday to you. Happy birthday to you. Happy birthday, dear Lizzie Dog. Happy birthday to you. That was, I've never sung that verse, I think, before. We've always just done it in 2 verses. That's what you get for coming in late. You get your own verse. Cha-cha-cha. Thank you very much. Lots and lots of birthdays today. Happy birthday to everyone who's celebrating a birthday today. Congratulations, first of all. You've made it yet one more time around the sun. That's no small thing. And we're here to celebrate that. We realize it's your special day, and there are a million places you could be and a million people you could be celebrating with who would love to celebrate your special day with you. But no, you chose to be here with us. So your poor decisions do not no, just kidding. Welcome. We are so glad you're here. Hopefully we can make your day a little bit better. And happy birthday. Enjoy the free pancakes at Denny's. There we go. And we got the little... We rarely finish out the song. So, good. All right. It's my grandma's 92nd birthday. Happy birthday. And it was Donna. Happy birthday. That is awesome. 92nd birthday. All right. We have... if I missed anyone, I do apologize. I have poor eyesight, and the chat moves fast. And between the two, I miss a lot of things. Here's what I want to cover today. just a little bit. We're going to do a little court hopping. I think we're going to be going to. Oh, I've got Pop-Tarts on the screen. What is this for? Oh, this was from last night. Now I'm distracted a little bit. Let's see. Favorites. Bites. Yum, yum, yum. Who? You guys, if you missed the podcast last night, we did talk a little bit about Pop-Tarts and how Weather Watch eats them incorrectly. It involves butter, just so you know. So this is one I need to look at. I have not watched this yet. So we're going to hold tight on that one. Pause. There we go. That is Judge Wolf. This is a squirrel moment. There's food on the screen. I'm distracted. But Judge Wolf yesterday had a case. I think it was a civil case where he was trying to settle an estate. And like at the last minute, some unknown entity, this unknown person came out and was like, "Hello, I'm your big sister you didn't know about," which sounds exciting. For those of us who have fun little deviations in our family history from the traditional from the traditional tree that you might see if you're into doing genealogy. You might see, like, you've got husband, wife, they have kids, the kids get married to another, they have kids. It's very, sometimes there are unknown branches and kids with other parents that other kids don't know about. And I think that's what we have here. And I'm just excited to get to the bottom of it and try to figure this out, see what Judge Wolf does as he tries to divide the baby, so to speak, among the children who are fighting over the inheritance. Let's see. AJ, side note, are you on Team Volk this weekend? AJ, I'm not even sure what that means. Is it a sports thing? Kathy says, what happened with the nursing home case? We had a late-breaking verdict last night after about 50 minutes of deliberation. The jury came back with unanimous 6 votes, not guilty. Not guilty. I honestly think that the closing... Are you going to exercise, Mrs. R.A.?
Oh, yeah. You're all joining me.
Mrs. R.A., Tammy, if you're here, Mrs. R.A. is wearing the matching shirt, the one with the sparkly logo, like this right here. And she loves it because it matches her skirt, which she looks good in, if I say so myself. Good morning. Let's see. Thank you, by the way, Tammy. That's we love these. Okay, it's more like a family rose bush, thorns and all. That's what we're getting into. Thank you. Courtney says, just voted for your boy. He's wonderful. I've always wanted to learn the piano. How about Kathy? Oh, man. Love you too, Kathy. Differently. Love you as a friend. Yeah. Anyway. All right. Let's see. So we are going to Red Pen. I hear this. A lot of people felt this way. The jury got it right yesterday, as sad as the case seemed. I don't think the state had the evidence to say that it happened, the way it did. Their one witness did seem to be less than credible, and it just... Somebody just sent me a video of roaches fighting. I really hope that there wasn't anything that went on there. But I really think that the state definitely didn't prove that there had been something. All right, so we have things to do and places to go. Let me check where we're at first. Judge Wolf is live already? Oh no, that's before. Hang on, this was yesterday, right? Let me check. 2/15/24. This was yesterday. Okay, I think this is it. You guys might have to tell me if we're early. We're watching Judge Wolf here out of Tennessee. We're back with the Heavenly Wood. That's exciting. We love this display. The entire courtroom is just. It speaks to me. It speaks to my soul. We're watching The Unknown Child. Yes, this is what we're trying to watch. If I can get the audio to work, which would, that's a problem on my end. So give me I don't think he's turned it on yet. That's the problem. Give us a minute. It's Friday after all. We don't have to have everything working right when we start. That would be nice, but we're not there. We need to see the fast food 60 hours, man. That was in Judge Cedric's court, and I don't know when that happened. I thought it was supposed to happen first thing in the morning, but he didn't really have like a firm deadline. So if anyone saw that or saw when it happens, we'd love to go back and watch that. Melissa, we are in your neck of the woods. That means we need you to fill us in if we're ever in doubt or confusion as to what they're talking about, if they're using like a local slang term or something that we don't get. I'm going to need you to step up and just translate for us. Make sure you keep the burner number just on standby, so you can do that, Melissa. Glad to be visiting your part of the world here. You have beautiful courtrooms, so I love this. I love this layout. I mean, what is there not to like about this layout? You've got like little walls and dividers. It's almost like a little miniature maze. Massive podium. I call it a podium because it's bigger than a lectern. I realize they move it, but it's. I apologize. I'm pretty sure it has its own little stand you climb up onto. So that's big. The judge has his own little hidden door there in back. The woodwork is fancy, but not so ornate that it distracts from the courtroom setting. And clearly, the way that on the right-hand side, where we've got little steps in the railing over there, where the railing dips down, it like naturally just draws your eyes to the 85-inch plasma, which the judge had installed on the courtroom wall. And this is, I mean, it's got technology blended, form and function together in one place. Who could ask for more? All right. Kelly says, what type of keyboard do you have for your son? I play piano, but I'm looking for a keyboard. We have a Yamaha, I can tell you. Let's see. I bought the keyboard from a company called Sweetwater. Hang on just one second. I realize you can buy this keyboard, I think from, like, it's on Amazon, I'm pretty sure. But I really enjoy when the price is the same, purchasing from a company that's dedicated to what they do. And I love Amazon. Amazon has its place. I sell on Amazon. I love it. It's good. It's good stuff. But this company, Sweetwater, I went on their website and I'm like, oh, enter your phone number for a chance to win, $10,000 in electronics gear. And I'm like, sign me up. And then this guy called me. He says, hey, I'm Chris. I'm like, hey, Chris, why are you calling me? And he's like, well, you mentioned that you were interested in some gear, and I'm going to be your tech guy. What can I help you with? What are you interested in? What are you doing with audio, video? How can I help you on what you're doing? Can I explain how things work? Can I explain if parts will work together? What cables can we get you? And I'm like, Chris, you are speaking my language. You're speaking my language. And he calls me up every couple, probably about every 2 months. He's like, hey man, it's Chris. How's it going? I know he doesn't remember me, but he has notes. And he's like, how's the YouTube going? How many subscribers are you up to? And it's just, I'm like, a company like that means that they're very well trained staff. They know their product, and that's all they do, right? They're all about music and recording and stuff like that. So let's see. I have to log in. If I can remember my password. That's not it.
Does she still want to pursue the violation of the order protection in general section?
I remembered it. Here we go. We're going to turn them down in court just a little bit because they're noisy. Okay, I bought a Yamaha P125. I'll link it using the Amazon link, but just so you can look at it there. Give me just 1 second. And I'll tell you why I got this keyboard as well, because I did a lot of shopping around. Let's find this one. Here it is. I got it in white, but it's available in black as well. So let's link this one here. That's the white. There we go. Copy. Okay, there's the link to the piano. Now, let me tell you, this purchase was made possible, I believe, at the time by a generous gift from my wife's parents. We bought this, I think, while I was unemployed, so it was a tight moment, but the purchase was made possible. It's about $700, and I realize it's much cheaper than buying a real piano. But what I like about it is it has the keys have a real feel. It feels like you're playing a real piano. Like it feels like you're pressing the keys and the hammers are moving. It just has that same feel. The sound, the polyphony, how many keys you can press at once, everything. It's just on par. It plugs into an iPad, weighted keys. It doesn't have all the fancy light up the keys while you play. It doesn't have all those. It's not that cool. It has a couple demo songs, but really it's just a base model with a good sound, and it has a couple good voices. And it's not too heavy. It's something that's small enough that would fit in the little corner of the room we had available, and it just worked out. And it's a nice keyboard, and it has the outputs. I've used it when I was doing a venue for a function over the weekend where they needed a keyboard available, and I brought that with, and they were able to play that, and we get the full sound, and I can plug it into my audio system. So it was just a win all around on that one. There are much nicer ones. They're much nicer keyboards, and they're much cheaper ones as well. But this one just was the best model I could see that had just great reviews, that had everything we needed. So that's why we did it that way. Babs Austin says, it may sound silly, but talking to you feels like meeting a celebrity. You've created an incredible world that helps us increase our knowledge of the law. Thanks. Babs, it was great talking to you the other day. Thank you very much. Appreciate that. And I'm definitely not a celebrity. I'm just one of us. One of us, just like in the robot movie. I do see the appeal for the headphone option. We had to go with the headphone option. And this keyboard that we got for my son has dual headphones, so you can have like a teacher sitting next to them with listen to headphones, and someone else listening, and the baby sleeping in the room next door. It all works. It all works out that way. Selena K, thank you very much. Gifted a membership this morning. That one went to Kathy. Congratulations, Kathy. I'm not a person. I'm one of the people. Okay, I'm going to skip ahead through this. I like that everyone's getting to know each other in court, but this chatter is just endless. Let's see. How long? Looks like we're going to be in court for about 2 hours at least. Let's wait for the judge to sit down. There he is, right here. Come on. There we go. Right here. Okay. Let's begin with Judge Wolf. And
Guys, this Chancery Court of Dixon County is now in session. The Honorable Judge David Wolf presiding. All ye have business before this court, draw nigh, and ye shall be heard. God bless the United States, this state, and this court.
There you go.
You may be seated.
I like that the judge stays standing for that.
Good morning. We're going to start through the docket, so call the first case.
The matter of Wayne Taylor Lindstrom.
Good morning, Your Honor.
Good morning.
Jennifer Williams from the Robertson County Bar. This is a motion for default with some brief testimony on termination, and my clients will be by Zoom. Mr. and Ms.
Do you know
Yeager.
how they're coming in?
They said it's Mr. and Ms. Yeager, their last name. Does it show Yeager on their name?
I have admitted them, so we'll see if I can.
Yeah, we were teased about this briefly. We'll have a couple cases here until this.
COVID in their house this time.
Until this starts,
we were
but
here in October. I had to be by Zoom because I had it, so we can't seem to get to the courthouse at the same time. Well,
we're going to have a case involving the distribution of assets from family members who have passed away.
Well, the miracle of modern technology allows them to appear via.
Oh, wow! Look at this
Zoom,
couple.
So,
the guy looks like
if you can unmute your device, please.
Yes, sir.
Good morning.
Morning. What you want to put on your proof? Then we're going to ask Mr. and Mrs. Yeager to raise your right hand. Let me place you under oath. Do each of you solemnly swear or affirm the testimony you're about to give in this case to be the truth and nothing but the truth, so help you God?
Yes, sir.
But you are coming and going. I don't know exactly where you are. It appears that you're maybe in a Where are you?
In an automobile.
I'm not
And
exactly
now we
sure.
lost them.
And we just lost you, so.
They may have a signal issue they need to get fixed, Judge. There we go, that's
All
better.
right. Are you in a vehicle? All right, you're muted again.
Brittany and Josh.
Yes, sir. We came to the vehicle because our son was inside with the nanny eating breakfast and kind of loud.
All right, that's fine. I just wanted to make sure you're driving, so if it's.
Oh, no, sir.
No, we're in the back seat.
Well, you would think I would have to tell people that, but lawyers will come in on Zoom and they're driving down the highway because I can see the landscape passing in the background. One of whom is sitting in the courtroom today, so luckily he made it out alive. And we won't mention it.
Called him out.
Patently illegal for him to have done what he did. So I want to make sure you weren't violating the law. So, all right, I have placed you under oath.
Yes, sir.
If you would like to go ahead and approve, please.
All right, you are, we're going to start with Miss Brittany Yeager, and you are Miss Brittany Yeager, one of the petitioners, is that correct?
Yes, ma'am.
And you are married to Josh Yeager, who's there with you, is that correct?
That is correct.
We have published notice in the paper and mailed to the last known address that shows received the birth mother information about these proceedings in this hearing today, is that correct?
Correct.
Judge, we've filed notice of the publication, but here's the original. We don't present exhibit the tracking notice about today's hearing.
All right, let's mark this as an exhibit.
So it sounds like this is a family court issue.
And I
right
have
here.
with me, and you've seen a copy of your marriage certificate that shows that you're married to Mr. Josh Yeager, is that correct? You offer that as the next exhibit.
I've already got a copy
Oh,
of
you
that.
do?
It's been
Thank you,
marked as
Judge.
an exhibit on October.
They're
23rd.
seeking rights,
Thank you.
paternity rights for an adopted child.
You
or
and Mr.
something.
Yeager reside in Dixon County, is that correct?
Correct.
And the
Finalizing the
biological
adoption.
father's rights were already terminated by this court on October 31st of 2023, is that correct?
Yes, ma'am. Correct.
Judge, in the previous hearing, we also had filed the birth certificate imputed to father registry that we would ask the court to consider for this hearing. You have been the custodians for this minor child since it was 3 months old, is that right?
Yes, correct.
Custody from the Cheatham County Juvenile Court in 2023, is that correct?
Yes, ma'am. Correct.
And I've showed you a copy, and the judge may have, but these are copies of the juvenile court orders from Cheatham County, is that correct?
Correct.
Last exhibit, if Your Honor needs it, these are copies of those orders.
BG says this is exactly what I'm going through
There was a DCS case
right now with my
pending,
brother's
and
estate.
you actually ended up taking the baby shortly after the hospital release home with you by agreement with the parents, is that correct?
Yes, ma'am. Correct.
He died no will, not
DCS
married.
did a plan for the parents for reunification, but that plan never was completed, so that the child ended up staying with you, is that correct?
Yes, ma'am. Correct.
No kids
In
until
those orders, the
42-year-old males
DCS
claiming
found that
he's
the
his son.
child was
I asked for
dependent neglected
recommendations on
due to
attorney
testing
clinical.
positive
Yes.
for fentanyl, morphine, methamphetamine, aprazolam, and gabapentin at birth, diagnosing the child with NAS. Is that correct?
Correct. Yes, ma'am.
It's found the child was severely abused in that order that was never appealed and was a final order. Is that correct?
Yes, ma'am. Correct.
You filed your petition in this court July 14th of 2023, in which you allege abandonment. Has the birth mother ever paid you any child support?
No, ma'am.
Has she visited this minor child?
No, ma'am.
In the 4 months before this petition, from March to July 13th of 2023, did you get any child support, and did she visit?
No, ma'am.
Has she filed anything with the juvenile court at any time to request custody, return, or a visitation schedule?
No, ma'am.
Has she known that you are the custodians of her child?
Yes, she does.
Been more than 6 months since the adjudication of severe abuse, and the birth mother continues to remain unstable, engaging in criminal conduct. Is that correct?
That is correct, ma'am.
She's had a history in this county for theft of a motor vehicle, possession of drug paraphernalia, and possession of meth for resale. Is that correct?
Yes, correct.
Your knowledge, she's continued in that type of lifestyle and has not provided you any indication that she can be drug-free or maintain a stable home for this child. Is that correct?
Yes, ma'am. That's correct.
She's not shown you a desire or ability or willingness to assume custody or financial responsibility for this child. Is that correct?
Correct.
She has no parental attachment with this child and no bond because she's virtually a stranger. Is that right?
Yep, exactly. Yes, ma'am. Correct.
And do you believe it would be substantially harmful for this child to be returned to her care at this point?
Absolutely. Correct.
Has she demonstrated to you any awareness of this child's needs?
No, no, ma'am.
Is it true that she's not shown any urgency to do so?
That is correct.
Are you and your husband, if the court terminates her rights, willing and able to adopt this child?
Yes, ma'am.
Does this child see you and your husband as his parents?
Yes, he does. That's correct.
She's so
healthy,
happy.
attached to you, and thriving and doing well in your home?
Yes, he is. That's correct.
You're asking the court to terminate the birth mother's rights, just like the birth father's rights were already terminated, and so that you can proceed with adoption at a later date.
Yes, ma'am. That's correct.
Those are the questions I have of Ms. Yeager. I would just briefly not repeat all of that, but just have Mr. Yeager verify if that's okay, Judge. Mr. Josh Yeager, you've heard the statements.
Yes, ma'am.
You've heard the statements of your wife.
Yes.
You agree with the statements that she's made?
Yes, ma'am.
Have you been paid any child support or had any requests for visitation of this child to you?
I have not.
Do you affirm the other statements she's made and ask the court to terminate the rights of the biological mother today?
I do.
Those are the questions, Judge.
I feel like I'm watching a Japanese movie with bad dubbing in because the audio 2 seconds after what your mouth moves. So clearly the motion for default judgment should be granted, and it's in the best interest of this minor child by the clear and convincing evidence produced before the court that termination of the parental rights should occur by abandonment. The grounds have been proven of abandonment, both in the failure to visit and the failure to support, as well as the court finds that it is in the best interest of this minor child to terminate the parental rights. Now, I have a question for you, Ms. Williams. Is there a reason why you want to set a separate date for the adoption itself?
Yes, Judge, and the reason why my clients want to be able to come here in person with the baby without having to notify the parents and know that we don't have to show up with regards to that. So we didn't set that part for today so that we could be secure. The only other question I had is, Judge, we'll non-suit the non-compliance ground with a permanency plan because I don't think we had evidence. But for persistence of conditions, failure to manifest, and severe child abuse, do you make those findings as well based on the testimony that you heard?
That is fine. We'll go ahead and grant your default judgment and find that, as I said, the proof has been established that there are grounds for abandonment and it's in the best interest of the minor child by clear and convincing evidence. So the question is, when do you want to reset that adoption?
What does your honors calendar look like? What I'd like to do is
I can't use the actual terms that first come to mind, but let me say that my calendar is not exactly an open date. I'm trying to appear before a legislative committee next week to try to get us to testify that we need a fourth judge.
Yes, sir.
And I can't find an open date to appear, so I'm having to move court in order to do that.
Oh, gosh.
I will.
Wow.
I was thinking about sometime next month. We will get the order filed probably about tomorrow.
Well, let me say this. I have Dixon Chantry on the 28th, but it would have to be in the morning. I'm only going to be able to have a half a day on that day. On the March is the month I'm trying to catch up on some. March 18th would be a day I can give you.
I am out of state that week for the spring break.
Crazy Cat Queen, welcome to the gallery. Thank you so much. Good to have you.
March 28th.
That will have to be first thing in the morning.
Okay. My clients can do that March 28th, first thing in the
The
morning.
February 28th date, is that not a day?
I'm in a trial in another county, Judge. So what is that?
What about the 27th?
27th of March?
I'm sorry, February 27th.
February 27th. Yes. Well, no, I just said a motion in Robertson County on a default termination. I'm sorry.
It looks like what day is your best?
Looks like either the March 28th, unless there's something the first week of April.
I think these guys are all overworked.
I've got something I can move on March 28th if that's.
Well, I also have
Josh looks paranoid.
April 4th.
We can do April 4th. That would be best, Judge, so I don't have to move what I've got on the 28th. April 4th, Mr. Mishaker, for adoption?
Yeah, we'll make any time work.
So we'll set that for April the 4th, Judge. That'll also give us time for this order to be 30 days old, and we'll be secure in that termination.
That'll be fine.
Thank you, Judge, for
April
your
4th.
time. Yes, sir. Thank you.
Thank you.
Lizzie Dog, let me read this because it doesn't show up very well. First of all, thanks for the super chat. Happy birthday. Thank you, RA and fellow addicts, for birthday wishes. I know I'm not here all the time, but when I am, I feel welcome. RA, you've created an amazing place for addicts like me. Lizzie Dog, thank you so much. Happy birthday. Appreciate the huge, generous super chat.
All right. Mr. Vincent, right now, let's ask you to raise your right hand. Let's place you under oath.
ma'am.
So I'm gonna ask you just a few brief questions. Did you submit a petition to change your name?
Yes, ma'am.
Are you changing your name, requesting that your name be changed for any illegal purpose?
No, ma'am.
To avoid criminal prosecution?
No, ma'am.
To avoid any just debts that you owe?
It's a name change.
Judge, we would ask the request for the reasons laid out in the petition that Mr. Vincent's name be changed. I believe we've already submitted an order.
All right, Ms. Franklin has asked you all the questions I'm required to law to ask. I will grant your request for a name change, and I've signed your order.
Thank you.
Thank you.
I want to know what the new name is.
Austin Taylor Smith.
And does it have the word mullet in the name? Because he's rocking one. Katsy, welcome to the gallery.
Good morning.
Month 2. Thank you very much.
This is N. Ray Austin Taylor Smith. Ms. Smith, if you wouldn't mind standing up here beside me, raise your right hand, please.
You solemnly swear all the time to tell the truth, whole truth, nothing but the truth,
Would you please state your name for the court? And make sure you speak up because
a
I need to
little
be able to hear you. Would you state your name for the court, please?
Austin Taylor Smith.
And Ms. Smith, you came to me for a name change petition, is that correct?
Yes, ma'am.
Are you petitioning the court to change your name for any illegal purpose?
No, ma'am.
Are you changing your name to avoid criminal prosecution?
No, ma'am.
Are you changing your name to avoid any just creditors?
No, ma'am.
And you wish for your name to be changed today from Austin Taylor Smith to Taylor Austin Burnett, is that correct?
Yes, ma'am.
Your Honor?
I had family members in Texas that named all their children after cities in Texas. And one of them was named Austin, another was Tyler, and I think the third one had a name of a town in Texas as well. But I assume Austin was not named after the city of Austin, Texas, or was it?
I don't believe so.
I'm happy to grant your name change. We'll change your name to Taylor Austin Burnett.
Thank you, Your Honor. And I feel sorry for the child named Fredericksburg.
Fredericksburg would be an interesting name. I guess you could shorten it to Fred. But
I'm not sure if they'll show the adoption, Angela, with the child there. Oftentimes, when children are involved, they don't show those, but we'll see. And Mike, I did get your information about that preceding the adoption issue, where you had some inside information on that.
Good morning, Your Honor.
Good morning.
A motion for default is based on a criminal contempt motion that was based on a default from a final decree of divorce filed in December of 2022. The motion for civil contempt talks about him being behind in child support.
I have a question for you, Mr. Hawley. Excuse me for interrupting you, but the file reflects that the child support issues are presently pending before the child support magistrate, and that there's been an order that was entered November of 2023, which is after the date of your filing of your petition, which specifies that the child support magistrate has made certain findings and rulings on the issues of child support, and those have been, I believe there was an order of confirmation that's gone down on that issue too.
Oh, there is, and that's why I was bringing that up initially, right off the bat, because that's been settled in child support court. They had a separate procedure going on there, and I understand that when he was faced with the, pay or go to jail situation, that he caught all of his child support up at this point. He hasn't paid for February yet, Ms. Soto says, but other than that, the child support office was successful in those collections. What we're here today to be concerned with in the contempt petition from the divorce from December 2022 are basically two things, and that is there was in the overall scheme of the dissolution of the marriage and the equitable property distribution from a business that he has and some spousal support, two separate payments of $50,000 that were to be paid. He has paid neither one of those, and the time is well past. The second thing is he was to pay the property and get the taxes caught up on the property that Ms. Soto was to get out of the divorce, and he has failed to do that for 2 years. Ms. Soto was summoned to court at one point here for property tax delinquent notice. She came to court. She wound up paying it on that day. She has a receipt where she has made some $1,305 and some odd cents worth of payments. And then there's also the 2022 taxes, which are right now, if he was to pay them, $900 and some odd dollars, which he's prepared to testify to. So we're asking for those two things and the $100,000 total that he didn't pay out of the divorce. We did serve him with a contempt petition. Everything is timely been served, and I think we're appropriate for a default judgment. We would ask that he be either sent us to jail today or give us some appropriate time to make those payments with a report date. It is a civil contempt situation. And I can have her testify.
Ms. Valdez, if you'll raise your right hand, please.
So you're Norma Judith Soto Valdez, is that correct?
Yes, that's correct.
And you've heard everything that I've announced to the court, is that correct?
Yes, correct.
And you understand that you do have a final decree of divorce from December 2022, and that Mr. Ortega Riviera was to pay you basically two separate $50,000 sums, correct?
Correct.
And has he paid you those?
No, he hasn't.
Have you had any communication with him about that at all?
No.
Since the divorce, have you had any communication with him basically at all?
Just for furniture purposes after he was supposed to move his stuff out of the house. That was it.
Are you aware that he's still working at the business that he had while you were married to him?
Yes, that's correct.
And it was a carport business, Eagle Carports, correct?
Yes, correct.
And you lived with him for quite a while he had that business, and you're familiar with the earnings of that business, is that correct?
Yes.
During the time that he was married to you, what was his
Thank you, Crazy Cat Queen. Good to have both of your personalities here.
Annually, $350,000 to $400,000 a year.
Okay. And you've had an opportunity to see him on social media at this point. Is it true that he's got basically another girlfriend or wife? You don't know which, correct?
Correct.
And you've seen pictures of like lavish gifts, diamonds, cars, things of that nature, correct?
Correct.
Your testimony is today that he does have the ability to pay these two $50,000 payments, correct?
Correct.
And that he had the ability to pay it when the divorce was basically settled, and we entered into an agreement for the same, correct?
Yes, correct.
All right. And let's talk about the property taxes. You got a house in the divorce, correct? Mm-hmm. And the divorce decree stipulates that he was to pay get the property taxes caught up through 2022, correct?
That's correct.
And has he done that?
No, he has not.
And you heard me tell the judge you were summoned to court basically for a delinquent property tax notice.
Yes.
And there were late fees and things like that attached, correct?
Yes.
And what was the amount that you had to pay then for that when you came to court to get the property tax caught up for the year of 2021?
I paid $1,340.14.
$40.14. And the 2022 taxes are due. And what is and he's delinquent on those, correct?
Correct.
What is the amount that if you paid today that those taxes would be?
$944.
Okay. And you're asking the court basically for $1,340.14, $944, and then the two $50,000 payments, correct?
Correct, unless he pays the $944 directly to the clerk's office. I have not paid the $944.
Okay. And you heard me testify, and the judge mentioned the child support. The state of Tennessee took that over, and when he was faced with the pay or go to jail, you got a payment. How much did he get caught up on all of a sudden there?
He was making payments of $1,100 a month, and I have not received any payments yet.
Okay. Judge, that's our proof. We would ask for default judgment. Of course, I always ask that he be found in civil contempt. I'd issue a KPUCV jail today until he makes a payment. If the court gives him some time or whatever, I'll be glad to put that in the order.
All right, I find that the defendant, the default judgment is granted. The defendant is found to be in civil contempt, and he is ordered to pay the two $50,000 payments for $100,000. Plus the back taxes within 30 days, and or he will report to jail on March 18th at 5 p.m.
Yeah, Facebook will out you if you're avoiding your monetary obligations, court-ordered obligations, and you're spending big money.
He has 30 days to purge himself of contempt on this issue.
Yes, sir, and I'll put that in the order. Just for my clarity now, if he doesn't show up on March 18th nor pays it, is there a capious that you automatically
You'll
need
need
to
to
come
get
back?
the clerk, because the order will need to reflect that a capious will issue if he does not make those payments.
If that's an opportunity, I'll put that in the order for the court's consideration. Thank you, Judge.
The order needs to reflect we're going to arrest him if he does not pay. That's pressing the issue. There's a kid in court for sure.
Good morning, Your Honor. This is Miranda Lee Mitchell versus John Robert Kirby. Mr. Kirby, Your Honor, this had been is a petition for contempt. Respondent had filed an answer that was then stricken as sanctions for his failure to follow the court's order pertaining to discovery and mediation, which he did not complete and did not attend. We are here today on the motion for default judgment.
And all those who are going to testify, raise your right hand. Let's place you under oath.
Got two witnesses
Mitchell,
here.
if you would please step up and state your full name for the record, please.
Miranda Lee Mitchell.
And Ms. Mitchell, how are you related, if at all, to Mr. Kirby?
I'm his ex-wife.
Okay. You made the allegation that in 2019, he withdrew the minor children from Dixon County schools. And to the best of your knowledge, the children are not currently enrolled in any school. Is that accurate?
Yes.
Okay. Where do you believe the children are being schooled, or do you know if they're being educated at all?
I don't know if they're being educated at all.
Okay. Did you visit the Dixon County Health Department at some point to try and obtain proof of their immunization records?
Yes, ma'am, I did.
And what information did you receive from the Dixon County Health Department?
That they had not been brought in for their 7th grade immune shots.
Okay. And would that have been the first round of shots that they were due to receive after the entry of the parenting plan?
Yes, sir. Right. Yes, ma'am.
You're quite all right.
If they haven't got their shots, they won't be allowed in
since
most
2019,
schools.
Father has not consulted you on any major decisions regarding the minor children, including but not limited to educational decisions, non-emergency healthcare decisions, extracurricular decisions, and/or decisions regarding religious upbringing. Is that accurate?
Yes, ma'am.
Were you consulted at all about taking the children out of Dixon County Public Schools?
No, ma'am.
Were you consulted about the possibility of homeschooling?
No, ma'am.
Okay. Have you received any letters from TenCare about your child Kenton?
Yes, I have received brief letters over a period of time asking that he be brought in for checkups.
So it was your understanding that those letters implied that he had not been receiving his checkups?
Correct.
And how old is Kenton?
Kenton is 14.
Okay. Have you received any information from the father regarding whether or not these children have been receiving their yearly checkups?
No, ma'am.
Or their vaccinations?
No, ma'am.
Okay. Have you tried to contact the father about these issues?
Yes, ma'am.
Do you believe that he's possibly changed his phone number?
Yes, ma'am.
Has he notified you whether or not he has changed his contact information?
No, ma'am.
Okay, you also made the allegation that since September 2019, the father has refused to allow you visitation or phone calls with the minor children as allocated in the permanent parenting plan of February 2019. Is that correct?
Yes, ma'am.
Okay. Have you regularly tried to initiate the visitation which he has been ordered to afford you?
Yes, ma'am.
And you are supposed to have a 50-50 parenting plan, correct?
Yes, ma'am.
How long has it been since you've seen your children?
Since 2019.
Well, how is that possible if you have 50-50 custody that you haven't seen them in 3 or 4 years?
Because he physically withholds my right. Like they're locked up in the house and he threatens to call the police every time I come out there.
How old are these children?
14 and 15. And not only have I tried to go out there, my daughter has tried to go out there, and she's, my sister-in-law has also tried to go out there, and he threatened to shoot them if anybody else from my family come out there to see them.
What?
Ma'am, if you would please step forward.
What?
And would you state your name for the record?
Heather Ann Mitchell.
And Ms. Mitchell, how do you know the people involved in this case?
Miranda's my sister-in-law.
Okay. Did you hear everything that Ms. Miranda Mitchell said?
Yes, ma'am.
Is it accurate and correct to the best of your knowledge?
Yes, ma'am.
Have you had any experience at all trying to see these children as well?
Yes, ma'am.
If you would tell the court what that was like.
Okay. So this was back like the end of 2020, beginning of 2021. It was after Christmas. I think it was January. We took the kids some bikes. When we pulled up to his house, he's got a chain with a no trespassing sign. So we kind of pulled in a little bit. We honked the horn and he came out and he was like, "What are y'all doing here?" And we were like, "Well, we just like to see the kids. We've got them some bikes, for Christmas." And he said, "No, nobody in this family is going to see these kids. If anybody else pulls up in my driveway, I'm going to shoot them." And I had my kids with me when we went there, so we just left, and that was the last time we tried to have contact.
Thank you. Yeah. Your Honor, respondent is in civil contempt of this court as he has willfully refused or failed to comply with this court's permanent parenting plan order of February 13th, 2019. Ms. Mitchell would respectfully request that respondent be found to be in civil contempt and that he be incarcerated until he complies with this court's order, specifically but not limited to compliance with court's visitation schedule and joint major decision-making. Ms. Mitchell was also request that it be made a condition of the purging of the civil contempt that respondent provide to the court proof of the children's vaccinations, yearly checkups, and education since entry of the court's order of February 13, 2019. Ms. Mitchell would also respectfully request that a referral be made by this court to the Office of the District Attorney General for a custodial interference pursuant to Tennessee Code annotated 3913.
That's your call.
Yes.
You can make that referral to the district attorney's office if that's what you wish to do.
And that she be granted a judgment for attorney's fees in the amount of $5,200.07, which has been satisfied in full by Ms. Mitchell. Your Honor, that is a slight derivation from the affidavit that I provided to the court. In the affidavit, I said that there were still approximately $200 outstanding. That has since been satisfied by Ms. Mitchell, and I can submit a modified affidavit if the court so orders, or I would ask that it be modified on my verbal motion.
Ms. Mitchell, how do you think things are going to go when you haven't seen your children for the last 3 or 4 years, and then suddenly they are back in your life on an equal basis? How do you think things are going to work?
I know it's going to be hard, and I do know that it's going to be sensitive for them. But I also know that I'm concerned about their schooling. I'm concerned about them not going to getting checkups and stuff. And so I do have a plan. If they need to get in therapy with me, I'm willing to do whatever I need to do to help them.
Well, the proof is clear that the respondent is in violation of the court's orders, and that the finding of the court is that he is in civil contempt. Court issues a bench warrant for the defendant, the respondent. He will be incarcerated for civil contempt until such time as he purges himself of contempt. The only purging that you can do in this situation, it seems to me, is the production of the records regarding the vaccinations and proof of the schooling of the children. But I will order that he be incarcerated, and the order will enter also granting this Mitchell immediate temporary custody of the minor children, and until a hearing can be conducted before this court. That hearing will be set for February It have to be March the 18th.
One moment, Your Honor.
It's interesting that that he's not here.
I'm not available that week.
March the 4th at 1:30.
I'm already here that day, so that will work.
Pardon?
I'm already here that day, so that will work well, Your Honor.
All right. All I'm wanting to do at that point is to determine what the status is for the children and to try to rectify any problems that are existing because of the reinstitution of this prior court order. You got a court order. I'm not faulting you for the fact that you delayed because of the fear that you may have had of his actions, but that's what this court is all about. If you have a problem with a court order being enforced, you can't wait 3 or 4 years without it negatively impacting the children. I'm not fussing at you, I'm just telling you. That's why I'm concerned about the impact it's going to have on the children, and I want to set some sort of a hearing to determine that. He's going to be in jail until that time, and as soon as they pick him up. And I hope that that can be done without any danger to anyone based on these threats that have made. Police officers have a dangerous enough job, and domestic situations are one of the things that oftentimes result in violence. But an order will go from this court finding him in civil contempt and ordering that he be incarcerated until the 18th day of, the 4th day of March at 1:30. Children will be in your care and custody until that time. And on that day, we'll look at what needs to be done regarding the schedule and the therapy, if any, that the children need. So.
Attorney's fees, Your Honor?
Pardon?
Attorney's fees?
I'll award the attorney's fees
the money,
that have been incurred in bringing of this action. So. All right.
Your Honor, is there some way that Ms. Mitchell might coordinate with law enforcement or might best coordinate with law enforcement?
Contact the Sheriff's Department and the Warrants Division about serving this to determine how she can go about being present or how she wants to coordinate with the children. These children are at an age where I would think you ought to be able to, do you have a telephone number for them that you're able to contact?
No, sir, he changed his telephone number because I wouldn't quit calling and texting.
They're not in school anywhere that you know of.
No, sir.
We have no number to reach them.
No, sir.
So it would be my input. I guess the only thing I can say is that you're going to have to go ahead and have the Sheriff's Department coordinate to let you know. And the Department of Children's Services probably needs to be involved in this as well, because they are going to have to probably have some contact with the situation if they're not enrolled in school and not being properly cared for with the medical needs. So.
This escalated quickly.
Thank you.
I'll draw the order. Thank you, Your Honor.
Wow. That might be interesting.
Dan Collins, executor of the estate of Lillian Tice Thompson versus the unknown and known heirs.
Oh, the estate. Here we go. What's this one?
Morning, Judge. I'm standing in for Mr. Osborne on this. He has filed a motion for publication and a quiet title action on behalf of Mr. Collins, who's the executor of the estate of Lillian Thompson. He attached an affidavit showing the efforts made to locate the people who we believe hold an interest in this property, which are the unknown heirs of Stroud Williams and Dottie Williams.
All right, based on the affidavit, found that a motion for publication should be granted.
Thank you.
So now they're going to publish. Now they get to publish it in the newspaper. They have to do this first.
The estate of Samuel Eugene Burton.
We're working through a bunch, but the end of this this block is going to be the case we're interested in.
This is on Zoom, or at least someone, Ms. Reasoner, I think, is on Zoom. So like,
Yes, Ms. Reasoner should be on Zoom. She lives out of state.
I've admitted her, and we'll ask her to go ahead and start her video.
My mug today is also courtesy of Tammy. It says that's not relevant on one side. I have to be careful because it's full of water. And it says RA on the other. Thank you, Tammy. Are they aware there is?
Reasoner, if you can hear me, I need you to start your audio, and if you have a camera access, you need to go ahead and turn your camera on, please.
Yeah, I've accessed sound, but I do not have a camera on my computer.
All right. If you allow me to place you under oath, then would you raise? I guess it matters whether she raises her right hand or not, because I can't see her.
I'll raise the right one.
Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth and nothing but the truth? So help you God.
Yes, I do.
Ms. Knight, go ahead.
Ms. Reasoner, did you contact my office to open an estate for your nephew, Samuel Harvey?
Yes, I did.
And to your knowledge, you have not been able to locate any will that he had?
No, he did not have a will.
And are his only two heirs, two minor children?
Yes, Ayden and Cade.
Hold on a second. One of the children is a Nurel Ramadan, and they're in the waiting room. That person's in the waiting room, so I'm going to admit them.
Narelle is the boy's mom.
Well, I've admitted that there was a phone that said Nurel, and I've admitted them, so we'll see if they want to join us.
Do you see the lawyer's head
video,
snap up?
we'll let them join
They said
in.
one of the children's in
They
the waiting
should be able
room.
to hear you now, so go ahead.
Ms. Ramadan, can you hear us now? All right, Ms. Reasoner, are you asking the court to open your nephew's estate and appoint you as the administrator?
Yes, I am.
Did your nephew purchase a piece of real property shortly before his death?
Yes, he did.
And as part of the bond inventory and accounting waivers that Ms. Ramadan filed on behalf of the two minor children heirs, did she also sign a waiver for you to pay the mortgage, the property taxes and such out of the decedent's accounts until the property can be properly disposed of?
That is correct.
That is all of my questions at this time, Your Honor.
All right. The waiver has been filed by the mother of the minor heirs in the case, consenting to this appointment, so I will grant your request.
And I have an order.
I already have one order. Is there another order?
And they may be the same.
All right. Thank you. I signed your order.
Thank you.
Thank you, Ms. Reason. You may leave our hearing.
Thank you.
Judge, I believe one of my clients may be in the waiting room on Zoom. Miss Jacqueline Martin or Stephanie Shorter could be, she could be using.
Jacqueline Martin?
Yes.
I've admitted her. I've asked her to turn on her camera.
We're going to be getting to a
Martin, if you can hear
spicy
me
little,
now that you've been admitted, can you start your video and your audio?
disposition of assets case. They call that like a no will present sentence fighting over the money with an unknown child thrown in the mix.
May need to pass this and let you contact her to make sure of what problems she's having coming in. I mean, we've admitted her, but she is not responding, so.
Thomas, my good Weather Watch podcast partner.
We'll put you on the second call.
Just gifted 5 memberships. Thank you, Thomas. Thank you.
Good morning, Your Honor. This is our motion to compel the administratrix of the estate to appear and show cause why she should not be held in contempt of the court's November 30th, 2023 order entered in this matter. As the court will recall, back in November, we had a hearing on a motion to compel the administratrix to do several things. One was to as well as declare the estate insolvent, in connection with which the court ordered the administratrix to distribute to transfer the funds held in the estate account to counsel's client trust account. That was actually not part of our motion today, although we have recently discovered apparently that has not happened yet. There are also matters relating to the tax returns for the decedent. I understand that's in progress to the extent that anything involving the IRS can be said to be making progress. I understand counsel is back making progress on that. What we're specifically here today is in regard the title documents relating to a slingshot. If the court
a slingshot,
can bring itself to recall the April hearing
If I
last
can bring
year.
myself to recall. Do I have a choice to do that? Or I'm just asking if that, in your terminology, if I am to understand I am to bring myself to recall, and I either recall it or I don't, but I don't know if I
think they're talking about a three-wheeled
take some
motorcycle
steps
type
or
vehicle.
something. So.
It was a very long
Made by
day,
Polaris.
as the court will recall. We actually had several matters before the court that day. 2 claims filed by my client, and then also another claim that the administratrix had filed to compel the turnover of the slingshot. The court will recall the evidence at that hearing was that the uncontested evidence at that hearing was that the slingshot had been a gift from the decedent to Susan Lord, my client, one of my clients. There was an order entered in May granting judgment in favor of my clients on their claims. And I have to confess to oversight here.
You have an order that reflects what happened that day, correct?
Yes, but it does not address the administrator's claim for turnover of the slingshot. That was one of the reasons why we, in support of the motion that we heard back in November, we set forth that the uncontested evidence at the hearing had established that it was a gift from the decedent to Ms. Lord, and to compel the administrators to turn over those title documents appropriately endorsed. That's not happened, even though there has been, as set forth in our motion.
Who has possession of the slingshot?
Ms. Lord does. It's been sitting out of the weather in her garage. But she can't get the title documents because there actually is a title out there in the decedent's name. And those title documents are in the possession of the administrators. And she does have the ability to turn them over. And we're asking that the court compel her to appear and show cause why she should not be held in contempt of the November order, not the May order, the November order, compelling her to turn those over as she has indicated that she can.
Good morning, Your Honor.
Good morning.
And as a general update, as Mr. Ayden was saying, we are making progress with the tax returns. We do have a 2014 filed, but the 2015 tax return is still outstanding. We're waiting on some documentation from I guess, the CPA and Dixon here. When we were back here in November, as Mr. Ayden stated, we did have a hearing in April of that year, and there was testimony with regard to the slingshot. It was my recollection, as it was with Mr. Ayden, that that slingshot was addressed in the May 5th order.
That's a cow skin.
But upon further review, the personal
ceiling.
representative was never ordered to turn over the title, and it was a mistake of counsel for stating that she would, Your Honor.
Mary Ann, happy birthday.
Now, she does
happy
have
birthday.
the title.
Excuse me for interrupting. Mr. Regan's motion filed paragraph 4 says that there was an order entered November the 30th that granted the motion and said, and it quotes the order saying it's further ordered that within 10 days of the entry of this order, the administratrix shall surrender and turn over the creditor solicitor the original certificate of title to the certain 2017 slingshot motorcycle, together with all other related documentation. So is that accurate that there was an order entered in November?
That's correct, Your Honor.
So we're past 30 days from that date, past the 10 days, past 30 days. So why hasn't, if she has it, why hasn't she complied?
She was asking counsel, I apologize, Your Honor, I've been out of state on a funeral for the last, I guess, 2 weeks, but
Funeral for 2
when
weeks?
I talked to her on Monday, she just requested the underlying order from the November 30th hearing, and then upon looking into that, Your Honor, that there was no order initially compelling her to turn it over, so the motion to compel, I should have done something different at that time, Your Honor. That's my mistake.
I'm sorry, you what?
I should have argued, I guess, against the initial order from the May 5th hearing, because the May 5th hearing, Your Honor, allowed the claims of 137,000, claims for a horse, claims for, I believe, an RV, but it did not demand her to turn over anything at that time. So the motion to compel that was filed on November 30th, there was no underlying order for that aspect, and I was mistaken, Your Honor.
Well, whatever that case may be, if there's some confusion about the date of one order being entered and a motion to compel being filed before the order was entered and so forth, let's just set all of that aside. She has 10 days from today's date to produce this title, and that clarifies the situation. If she doesn't do it then I will put her in the adjoining cells of the individual who wanted his ex-wife's signature. So.
Thank you.
She doesn't pay within 10 days, or she doesn't produce the title within 10 days.
Let's go back to Ms. Franklin. I think we have your clients. Ms. Martin, can you hear me now?
Yes, but we can't hear you.
I can see you, and I appreciate that we've made that progress, but I cannot hear you. So I don't know if you need to do anything different with your equipment there to let us hear you. I'm sorry, but whenever we get Ms. Martin unmuted, I've got to ask her what animal it is that's skin is hanging on the wall.
It's a cow. It's a cow.
It's too small to be a cowhide that I've seen, so it's got to be something else. I'm gonna.
She can hear us. We just can't hear her. I'll have my office call her and help her through it.
I think it's a cow.
Well, let's pass it one more time and let you see if you can get it to where we can hear her. So, all right.
The estate of Jordan Blair Wood.
Your Honor, this is our presentation of the final accounting in that estate, as well as a motion for instructions. Jordan Wood was killed in September.
I show that Jason Quarles is joining us by Zoom.
Okay.
That's your client, correct?
Yes, Your Honor. He is the administrator.
Let's see if we have any more luck with Mr.
Are we going to kick Jacqueline out and let Jason in? There we go. Welcome, Jason.
All right, we have Mr. Quarles in our meeting, but
no camera.
We need to turn his camera on and to unmute. Are you going to have him testify in any way?
I had not anticipated that,
All right,
Your Honor.
Mr. Quarles can hear what we're going on, so let's go forward with your hearing.
Okay. Mr. Quarles, by the way, is the decedent's father. The decedent died in a motorcycle accident in September of 2019. He had 4 children at the time, all very young. In fact, his 5th child was born shortly after his death. There have been determinations of paternity made. Those are exhibited to the final counting. Mr. Mark Odell was engaged to prosecute the wrongful death action. The facts of the case were fairly straightforward. What made getting the wrongful death action squared away a bit more complicated than usual was there was a fairly significant 10-care subrogation claim that had to be disposed of. Mr. Odell was able to beat the state of Tennessee down, and they waived subrogation at all. The unfortunate thing is that the defendant only had minimum statutory coverage. So there was, in fact, eventually a check issued for $25,000, even though technically that's not part of the estate because Mr. Quarles was the named plaintiff. Those funds have been placed in the estate account for purposes of administrative simplicity since the beneficiaries of the wrongful death action and the beneficiaries of the estate are identical. Mr. Odell, his retainer agreement, which is exhibited to the accounting, provided for a 1/3 contingency fee. That is part of the proposed final accounting. I think that comes to $83,3333. The rest of the estate has been fairly straightforward. There was some insurance proceeds on the motorcycle. Those were largely consumed in paying for the funeral. There have been just minimal interest income since then. All the estate has been disposed of, leaving a very small amount of money to distribute to 5 very young children. I think the oldest is 8. That gets us into our motion for instructions.
4 kids under 8, and he died on a motorcycle crash.
If we are suggesting that the court permit distribution to be made to the children's mothers as custodians for their use and benefit under the Tennessee Uniform Transfers to Minors Act.
Children's mothers.
Because any more formal arrangement is going to consume these children's inheritances. I really don't see any other practical way to safeguard that these children get anything from the father that quite a few of them will never be able to remember. And so we're asking that the court approve the proposed final accounting. There's an affidavit in there in respect of my attorney's fees, and also to authorize, and by the way, Mr. Quarles has transferred the entire estate account to my client trust account, and I would ask that the court also approve making disbursement from that trust account to the mothers as custodians, and there, of course, receipts will reflect that they are accepting distribution in a fiduciary capacity as such custodians.
Anyone here that has any objections to that? All right, then the final accounting will be approved. Your proposed distribution of the assets and payment of those expenses will also be approved, and I see no reason that it can't be paid to the mother of the minor children based on the amount. Whoever has the minor child in the courtroom is going to have to step outside with the child until such time as your case is called, please.
Thank you, Your Honor.
Where's the minor child? The judge has just told you to leave the courtroom with the kid. Oh, there we go.
Oh, looks good.
The estate of Willard Nelson Cummings.
It's the first time that kid's been thrown out of court.
Guess I'll start with my motions, Judge. I think I have filed 3 motions in this. Ms. Roberts has filed a motion and Mr. Odell has filed a motion as well. I'll bring up Mr. Trice if that's okay as well. I'm going to start with a motion to approve the contract for the sale of real property located at 111 and 113 East Acres Drive in Dixon, Tennessee. Can we go ahead and have Mr. Trice placed under oath?
I do.
Okay, Mr. Trice, I believe the court's well familiar with you, but would you go ahead for the record and just state your profession?
I'm an auctioneer and realtor licensed in Tennessee.
Judge, we stipulate to his credentials. He's testified before.
He's an auctioneer. I want to hear him testify at full speed, please.
And I don't think it's necessary to waste the court's time on establishing his expertise.
Well, I know he likes to quote his experience and his expertise anyway, so it may not do us any good. He may just volunteer it, but we know Mr. Trice, and we'll go ahead and, everyone knows Mr. Trice, so we'll go ahead and qualify him as an expert in real estate, and especially in auctioneering.
Okay, and Mr. Trice, did you prepare a contract for, I believe, Terry and Barbara Odell to purchase this property in Waverly, Tennessee?
Yes.
And the purchase price of this property is $20,000?
Yes.
Can you describe to the court the condition of this property?
The house was in the flood zone, very close to the school that flooded in Waverly. And
Which side of the road?
It would be on, when you turn off of 70, it'd be on the left, and then it's right beside the little strip mall there in Waverly, convenience store on this end. So it would be on the east side of the road on Acre Drive. The house was gutted about knee high all through it to cut the sheetrock out. There's a corner of the house that was actually knocked out during the flood. A lot of mold in the house.
I go to Waverly, that's the way I drive. I drive down that road every way, and I'm aware of the fact that a lot of those houses, a lot of them have been demolished, and some of them have been repaired, and there are some that still lack repair. So this is one of those that lacks repair.
Correct, sir. They started on it. They stopped. The lot beside it, we had 111 East Acres Drive and 113 East Acres Drive. The lot beside it has been cleaned. There's no house on it anymore. But the house was a definite tear down.
And based on the condition of the house and the work that has to be done to remove that structure, do you believe that this contract price is fair and equitable?
Absolutely.
Judge, we'd ask that you approve this contract.
Ms. Roberts, you have any?
No, Your Honor, we think it's a fair value for the property and ask that you approve it.
It's a good deal.
We'll approve the sale.
The auctioneer called sold, and now he has to go to court to get them to approve the deal. Alicia, 8 months. Thank you very much. Congratulations.
Judge, my next motion in this is to authorize myself to retain the service of Mr. Neil Trice and Charles Woodard and Associates to conduct an auction of the decedent's firearms and ammunition. I believe I've attached an itemized list of the decedent's firearms that we have located to date within the transmission shop. There could be other ones, although myself and Mr. Trice have both made a thorough search and have not located any other firearms. We're asking, given the state of that this estate is in, I just want to be safe and make sure I have a court order authorizing me to retain his services to conduct this auction.
And Your Honor, if you'll recall, this
Anybody want to buy a pew-pew? Apparently they're doing it by auction in Tennessee.
Because of the problems associated with this estate. Started out with conservatorship, and then Mr. Cummings passed. Technically, my client are the two heirs of the estate, as it's now an intestate estate, and they have no objection to this. If there is going to be somebody come forward, the last will and testament that court did not allow left the entirety of the estate to St. Jude's, absent a life estate to a elderly lady in Hickman County who is now retained Stan Reynolds to represent her. But at this point in time, this is an intestate estate with only heirs, 2 children. And so we certainly approve this, and Mr. Trice is successfully going to merge this with another sale that will defray the cost of the sale because there will be with another estate that will be splitting the cost associated with renting a facility to do that. And so we ask that this be approved and that Mr. Trice be vested with the authority to sell these things according to
sold. Thank you, Melody. Congrats on 6 months.
You were the conservator, is that correct?
No, Your Honor, I was the guardian ad litem during the conservatorship, and I just have a motion for fees.
Well, my experience in attending some of these auctions where firearms are involved is that they almost uniformly and in every instance bring more than what I would have thought they would have brought. And so I think it's clearly the best way for this number of weapons involved.
So apparently you're not going to get a good deal if you
Most
bid.
advantageous for the heirs or any heir to have them sold in such fashion, so I will approve that.
Lots of bidders, lots of demand, drives up the price of the auction. Melanie, congratulations
Judge,
on
my
6 months.
last
Thank you so
motion in
much.
this is a motion to approve a survey of certain real property located at 850 Hawkins Road. This court previously entered an agreed order to authorize me to sell certain pieces of real property that were vacant. In conducting a title search of this property, our office determined that the legal description is deficient and has defects in it, and in order to issue title insurance through a sale, we'll be required to obtain a survey. I attached a quote from Excel Survey. They have quoted $1,500 for a boundary line survey. The survey is necessary in order to sell the property, and I do believe that is a reasonable price for the survey.
Hey, let me bring one thing to your attention. I just been looking through the file, noticed that on February the 12th, Stan Reynolds filed a notice of appearance that he was representing beneficiary Velma Adele Lozano, who divides a life estate in a property located at 6860 Oak Hill Road, Lyles, Tennessee.
She was copied on the certificate of service, and I did email Mr. Reynolds a courtesy copy of all of these pleadings.
And technically, she's not. He's made an appearance on behalf of, in a will that's not being admitted to probate, so.
Well, I thought that was the case, but I wanted to bring it to the attention that it does contain that in the file, so.
Yes, and she was included on the certificate of service, and I did email Mr. Reynolds a copy of all of these motions. Those are the motions that I have in this estate. I think Ms. Roberts has one as well.
Your Honor, I represent the children of Mr. Willard Bill Cummings and John Cummings. On his behalf, we had filed a request to retrieve certain items that are owned by Mr. Cummings, and there hasn't been any objection to this, so we would just
I
ask.
reviewed your motion. There's no objection voiced by any party, so therefore your motion will be granted.
Thank you, Your Honor.
So,
I filed an application for guardian ad litem fees incurred during the conservatorship prior to Mr. Cummings' death. Just rely upon the application of my affidavit and my itemized
I
bill.
reviewed your affidavit and I found it to be reasonable, so therefore I will approve your motion as well.
Thank you.
Okay, we're getting rapidly to the big case we want to watch. Lots of people still in the courtroom.
I told you all how glad I am that Chancery got probate transferred over to it out of the juvenile court. And if you cannot tell the sarcasm in my voice, let me clarify that. Go ahead, I'm sorry.
Your Honor, Trustee Counsel, on behalf of Mr. Smith, Your Honor, there's two matters before the court today. There's a 2020 tort action and a 2009 probate action. The former administrator, Tony Smith, passed after we did an accounting here in court for a good part of the day. He didn't take issue with anything on that day except for the real property. The real property action that he filed is the second matter on the docket today for the court. When that action was filed, the statute of limitations had already been stale. It's over a decade old. It's our position, Lord, and that the estate's insolvent. There's nothing here. My client is he's on Social Security. He's way up in his years. He's been patient, but Your Honor, there's nothing left to do in this case. I prepared orders. Counsel for the estate and the new administrator review the orders, and I would ask that the probate estate be closed and the tort matter be dismissed.
Your Honor, I was retained to review the tort action, consult by Tony Brown. I did that. Mr. Brown passed away some time back, and then that necessitated the appointment of Mr. Spratt's administrator. Based on my review, it appears that on any fraudulent conveyances could have been the basis of the the basis of the pending tort action statute. That should have been filed sometime back. So that's, I don't, I would think that we have the best to expect limitations.
Judge, I've reviewed that action, and I concur with Mr. Odell's opinion on that. I believe there also could be a res judicata issue with that action as well.
But both of you having been involved in representing the concerned parties, then that would indicate that and we're referring in that instance to the action that was set to try to set aside a fraudulent conveyance of property.
Those conveyances have, I believe.
And Mr. Pianto, I'm sorry, Mr. Pianto, you have a motion to, is that where the motion to dismiss or an alternative for judgment on the pleadings comes in?
That's right.
The motion to dismiss will be granted. And there was a petition to close the estate, and based on my ruling on your motion to dismiss, we said to me there's no reason not to close the estate, correct?
That's right.
Estate will be closed.
Thank you, Amanda. Anything interesting happening in that one today? Before we might jump to that next. Still waiting for the spicy battle, estate battle.
I represent Ms. Hartsook. We filed a divorce complaint in this matter. Mr. Hartsook was served. We filed a motion for default judgment against Mr. Hartsook. It was granted back in November. We were still within the 60-day period at that time, and so the court set it for final hearing in December. In December, Mr. Hartsook appeared with Mr. Lockner, who asked for a continuance, and it was granted over our objection. And we're here today for the final hearing in this matter. No, Mr. Hartsook is here with Mr. Lockhart, but there's not been any plea of any sort like that filed or any, seeking to set aside our default. So we're ready to proceed on a final hearing for this divorce.
Your Honor, he does not oppose the default. The court set it today so that he and his witnesses could be heard in regard to his interest in the marital home, so that there could be an equitable division of that property. I have two witnesses.
Well, the judgment by default that was entered, I think, was signed by Judge Larry Wallace.
Yes, Your Honor.
Signed and filed on December the 27th. And it just basically said that it was set for a judgment by default was entered against the defendant, and they set for a final hearing, and we'll conduct a final hearing.
Yes, Your Honor.
Are you ready to proceed on that, Your Honor?
Let me run through the rest of the cases and find out, get a time estimate on what we have left. Next case on the docket is Christopher Wayne Claiborne versus Amy Lee Childress Claiborne, rather. Mr. Holly, that's your case, is that correct?
It is, Judge. I don't think she's here, so I don't think it will take very long. I know we've had some issues. I did my best to draft an order, and I think the court wants to go over that and maybe give some instructions on what to do to amend that. There might be order protection I need, or some other things that she's actually filed that I need to clean up as well. So.
All right. 2023 CV2 in a matter of Arias Malachi Jacoby March et al. And that's a motion to, it's a hearing on an ex parte order suspending visitation.
Your Honor, Ms. Honeycutt and Ms. Bashir's not in here, and I'm not sure if Ms. Preston's here yet, but that's probably going to be a hearing. If we get to it, there may be a motion to continue, but we'll need to take that up. I don't know how long it's going to take. If we have a full hearing, it may take a while. If we don't, it'll take probably about 30 minutes.
Yvette Hernandez Myers versus Thomas Clay Myers. Ms. Roberts, Mr. Sanders.
If you could mark that for discussion. If we needed a hearing, it would be I believe, just our clients.
2 hours.
Mark Allen Gilchrist versus Caitlin Elizabeth Gilchrist, Mr. Hawley and Mr. Walsh.
Judge, Mr. Walsh had sent over some discovery to me about 2 days ago that I haven't had a chance to look at. My office is looking at that now, supposedly getting back with me a little bit. I need a little time to look at that. I got a motion to compel some discovery. You got a motion to sell the marital residence, which we definitely oppose. I would say that if we can't reach an agreement, if we can pass it for discussion, if we can't reach an agreement, I would say an hour and a half, maybe 2 hours at the most.
I would think much less, Your Honor. We had a motion for default that'll be off because they responded to the counter petition. The House, it doesn't seem that it would take that long. And then we've asked, the biggest thing, Your Honor, the most important thing to my client is that we've asked for a scheduling order. We would like to leave with that today, but I can't imagine that would take very long either.
Right. Michael Andrew Betts versus Jane Eudora Myatt.
Your Honor, that's the Richard Myatt and the last two are all together.
They're all having to do with whether or not I'm going to declare Catherine Rundle to be an heir at law of Richard Omar Myatt.
Yes, the actual hearing, I understand, is going to occur.
We have, let me admit into the hearing, we have Michael Betts. Is that one of the parties?
Yes.
He's the plaintiff in the partition action and one of the heirs at law in the probate. He's my client.
There must be some money here because look how many lawyers stood up.
Tell me what you want to do.
5 people there.
I'm just trying to get right now a time estimate.
2 hours at the minimum.
2 hours at the minimum.
2 hours, right?
Yes, Your Honor, you're probably going to have Mr. Knowles' client testify who should be on the Zoom, who is the child or purported child that
2 hours.
Ms. Rundle.
Ms. Rundle, she is there. He's arranged to have somebody there to assist her to get that. I think Mr.
Would y'all have about 4 or 5 witnesses?
And Your Honor, my motion, since it's the identical issue, identical parties, and identical consequences, my motion is simply to make the same determination for purposes of the parallel partition action on the same basis as it makes that determination in the probate proceeding.
If I rule one way in one case, it's going to carry over to the other, so it makes sense to do it all. All right, well, you're last on the docket. It will likely be after lunch, but we'll see how it goes. So.
Thank you, Your Honor.
Thank you.
So we're going to be coming back to them. That was the
All
tease.
Right. We will now take up Hartsook versus Hartsook.
All the lawyers are involved in that one. There's got to be money there.
Before we start, may I ask the court for a bit of direction? Mr. Hartsook was obviously found in default previously. I'm just asking the court to what level his involvement will be in today's proceeding.
Technically, he has not yet appeared before this court, other than the fact that he has appeared through his lawyer. He hadn't filed anything, which has made him of record. The court has to make an equitable division of the property, and therefore, Mr. Lockhart is here today representing his client, and I will allow him to be heard to a limited basis, but without having filed any documentation or pleadings on the issue, I will consider it to the level that the court allows.
Yes, Your Honor.
Your Honor, my understanding that Judge Wallace said this, we have not opposed the default, but it was said so that my client could be heard in regard to the equitable division of the property. So that's all we'll put on testimony.
Well, there may be a difference of opinion in that, but Mr. Sanders' position is that the motion for default was granted before the 60 days had elapsed for the court to be able to grant a divorce, which is required by statute. The 60 days have to elapse from the date of filing where no minor children are involved. And that's what the order says, that he was served with a motion for default. He's failed to appear at the hearing, and they awarded a judgment by default against him, but it was set for a final hearing on December the 18th. So it's a fine point, but I will make it again. Person who does not appear by filing an answer or any sort of document or even a motion to set aside the default judgment is not necessarily even properly before the court. Out of consideration for the fact that the court has to make an equitable division of the property and to avoid motions to set aside the default judgment and a hearing that would necessarily have followed it without allowing him to be heard, I'm allowing you and your client to have participation in this case.
Yes, sir.
All right.
Loki.
Mr. Sanders, you may call your first witness.
I call Ms. Hartsook, Your Honor.
Ms. Hartsook, if you'll come around, and I'm going to ask you to step around where the witness stand is. You're going to come this way. Pardon? All right. We're going to have you come over here instead.
We'll get there.
We're doing family law, probate court.
Ms. Hartsook, would you please state your name for the court?
Stephanie Annette Hartsook.
And you are married to Mr. Isaac Thomas Hartsook Jr., is that correct?
Yes.
And you provided to my office certain statistical information with respect to your marriage in a complaint for divorce, is that correct?
Yes.
And is all that information true and correct?
Yes.
When were you and your husband married?
We were married on, the second time, October 9th, 2006.
Okay. So you were previously married to Mr. Hartsook, you divorced, and then you remarried Mr. Hartsook?
Yes.
Okay.
This is round 2 on the divorce from the same person.
If you would, just briefly tell the court why it is that you're seeking a divorce here today.
We've been at this a while, about 30 years with a break, and I'm just financially, emotionally exhausted.
Does Mr. Hartsook work?
No,
Has he ever worked during the marriage?
at times.
When you say at times, are we talking that he's had years of employment?
It's been quite a while.
When is the last time that he had a job?
I believe it was 2009.
2009? Okay. Now, during the course of your marriage, has Mr. Hartsook suffered from various substance abuse problems?
Yes.
And what has been the nature of his substance abuse problems? What does he struggle with?
We've kind of been the gamut. So from opioids to alcohol to pills to kind of ran the gamut.
And during the course of your marriage, has Mr. Hartsook, has he been to rehabilitations?
I believe over 33 times.
Since your marriage?
33?
I believe it's more than that, but yes.
I'm
And
just going to say it
each time
sounds like
that he
it's not
goes
working.
to rehab, who pays for that?
I've always been the one that carried insurance.
And is that what's covered it?
Yes.
What about anything that had to be paid out of pocket related to that? Who pays that?
It's either been myself or unpaid.
Now, you all do not have any minor children, correct?
No.
You all have any children at all together?
We do. He is now 30 years old.
I'd like to talk to you briefly about your property and your debts, okay? Do you own a home?
Yes.
And what's the address of your home?
997 East Iron Hill Road, Burns, Tennessee, 37029.
And do you recall when you purchased that home?
Yes. I purchased it unmarried in 2003.
And you said that you and your husband married in 2006.
Yes.
Whose name is the property in?
It is in my name.
Whose name is the mortgage in?
It is in my name.
Okay. Who pays the mortgage?
I do from an account that's only in my name.
Has your husband ever contributed toward the mortgage at all?
No, I mean, I sold stock to be able to purchase my home.
And how much stock did you sell to purchase your home?
A little over 10,000.
Was that a sort of a down payment?
It was an award at a stock option that I was given with my employer.
Since since you and your husband have been married the second time, has he done anything around the house or provided any upkeep or maintenance?
He does mow the yard, and we both kind of separately do our own. Like I do my laundry, he does his laundry. I do my stuff.
Does he
Have
help
yourself
toward
a
any of the
roommate.
bills at the house?
No.
Since the time that you've been married, have you refinanced the mortgage on the real property?
Yes, multiple times.
I mean, each time when you do a refinance, what type of a refinance are you doing?
Cash out.
And will you please tell the court what that means?
Yes. I purchased.
I know what it means,
Okay, but I mean.
Let her explain it to me in case my understanding is somehow deficient, Mr. Sanders.
I'm happy to, but.
No, I wonder, her version of cash out of the equity in a house by taking out a loan against her house that gives her the equity out of the home might be different than my interpretation. Is that what you're talking about?
I think what we're referring to is my purchase price was originally $127,000. I've been paying on it now for 17 years, and I'm embarrassed to say at this point, I now owe like $188,000.
And Ms. Hartsook, you've done 2 cash out refinances, is that correct?
Yes.
And may I approach, Your Honor?
You may.
It's preferred to always have the loan amount go down over the years.
Your
So
initial
that
purchase
hurts.
price, you've been paying on it all these years, but you borrowed against it for expenses or whatever you're saying, and getting home equity loans is what bumped the price back up.
One of the refis was to pay off a home equity loan.
Pay off what?
A home equity loan. And the other was just straight cash out.
May I approach, Your Honor?
You may.
Ms. Hartsook, I'm going to hand you a document here and ask, did you prepare that document?
Yes.
I notice here at the top, you've noted what the purchase price is, correct?
Yes.
And then you have 2 separate cash out refinances that you did, is that correct?
Yes.
And what is the total amount of cash that you received from those cash out refinances?
$67,120.95.
And each time that you did a cash out refinance, what is it that you were doing, or what is it that you and your husband were doing with that income, with that money?
Paying bills. I mean, some of it went to our child, not this particular one, but in years past, I'd taken out money to pay for college expenses. It either benefited the household or benefited our child.
And you've answered that question, but did Mr. Hartsook enjoy the benefit of that money like
Yes.
you did?
Yes, he did.
Okay. And there at the bottom, I think you have a balance. What did you say that you owe on your house now?
It's $186,977.35.
And you're making those payments.
Yes.
I think you also have said, have you paid your taxes yet for this year on the property?
No, I'm actually behind on my taxes for 2 years.
Has Mr. Hartsook ever paid anything toward the real property taxes?
No.
And I'd like to make that document an exhibit to our testimony.
We'll mark it as Exhibit 1 to this hearing.
So So this is the reason for
Ms.
divorce.
Hartsook, at one point in time, during this marriage, did you have a 401k account with the Bank of America?
Yes.
And over the years, have you taken money out of that 401k?
Multiple times. It's no longer has a balance.
And each time that you do that,
That gets taxed heavily.
Are you penalized and taxed on that income?
Yes.
Yeah, approach again, Your Honor.
Right.
Ms. Hartsook, I'm going to show you a document here and ask you to prepare this document.
Yes.
And does it reflect by year the amounts that you withdrew from your 401k?
Yes, and this was only as far back as I could go with records from 2017. So prior to that, there was activity also.
So at least from 2017 until now, how much did you withdraw from your 401k?
$80,164.66.
And how much is in your 401k account?
It's zero. It's closed.
Each time that you made those withdrawals, where did the money go?
Into household expenses.
Did Mr. Hartsook enjoy the benefit of that money in the house?
Yes.
Yeah, I'd like to make that Exhibit 2, please.
Exhibit 2.
Ms. Hartsook, have you also incurred debt during this marriage?
Yes.
Aside from what we've talked about?
Yes.
Okay. Do you have credit cards?
Yes.
Okay. May I approach again, Your Honor?
Right.
Ms. Hartsook, ask if you can identify that document, please.
Yes, it was my credit card balances as of August 29th, 2023.
And have those numbers gone down?
No, they've gone up. I've not been able to make payments.
And what is the total amount of credit card debt that you have, at least as of this date?
At that date, it was $32,258.75.
And looking at that list, those are various credit cards. Are those credit cards in your name?
Yes.
What sorts of things did you purchase to create that debt obligation?
It would either be household expenses or things other than Ulta, which that's under $1,000, but that benefited both of us directly.
The other things that you've spent on there, did you expend that money to buy things for the house? And Mr. Hartsook, the two of you still live together, correct?
Yes.
And he has continued to enjoy the benefit of those?
I'm sorry, he still lives there?
Yes. They
In
still
the
live.
house?
They still live together, Your Honor.
The judge is like, excuse me? He's still there? What is
Your Honor, I'd
Ulta?
like to make that credit card debt summary an exhibit to her testimony, please.
All right, mark it Exhibit 3.
So, Ms. Hartsook, you're here today, obviously, you're seeking a divorce, correct?
Yes.
Based on the grounds that you've testified to, the actions of Mr. Hartsook. As far as a fair and appropriate division of your property and your debts, well,
I haven't heard anything about marital property thus far. I've heard a separate property. The house was acquired prior to the marriage. It's in her name only. Marital property can include
Vehicles.
the increase in separately owned property if it's shown that it was contributed to by both parties. But this is not increased. The marital property or this separately owned piece of real property that she has actually decreased in value. It's more in
Because
debt
of the
now
debt,
than
yes.
it was. So I guess my question is, what is there other than that we're talking about? You got a ton load of debt, but
well,
are there other items of property?
that's our position with respect to that, Your Honor, but from talking with,
Are there personal property items that we need to deal with?
I mean,
Not to our knowledge, Your Honor.
Well, I interrupted you. I don't want to cut you short from putting on whatever proof you want. I just wanted to make sure I was understanding where we were with the proof, so. Go ahead.
Does Mr. Hartsook have a car?
he has his car and I have my car.
Are the two of you connected at all with respect to your automobiles?
Not at all.
He has it in his name, he pays the insurance, or he has insurance on it? Do you know?
I don't know. I mean, I pay my car payment and my insurance.
And are you fine with him keeping that car and
Yes.
being responsible for that? And you would like your car?
Yes. Now we'll continue to pay for it.
What about things in your house?
Even though it's been a while, we pretty much, the things that would be important, I think, to both of us would be things that his family gave him that have been generationally passed down, and things that that I have acquired that would be important to me, but I don't foresee any argument over anything material.
Are you okay with him taking things when he leaves that are of a personal nature to him, or gifts from his
Yes.
family? Or
Absolutely.
And as far as the house, you would like to obviously keep your house, is that correct?
Yes.
And be responsible for it,
I'm
like
trying.
you have been?
Yes.
Okay. With respect to those debts, the credit card debts that were listed there, do you feel that those should be equitably divided by the court? Did he enjoy the benefit of those debts like you did?
He did.
Okay. And you think he should be equally responsible for those?
I mean, I don't anticipate changes in his financial, so I'm not,
She's
I'd
willing to
just
keep the
rather
debt.
just move on.
That's all the questions I had, Your Honor.
She's willing to keep the
Walker,
debt.
do you have any questions?
Wow.
Just briefly, Your Honor.
Was a house of Mr. Hartsook sold in East Tennessee to help purchase this house?
He has never owned property that I'm aware of.
So you don't recall, while he was in the penitentiary, a house of his being sold in East Tennessee?
While he was
No.
in pen.
Okay.
This story is growing.
The house that you're in now, has he and his mother not contributed financially toward your expenses?
I think she's given him money through the years for sure.
Has she made deposits into your account?
She has to, because he doesn't have a bank account. And so my account is used like a funnel.
All right, and so you're saying that money that's been deposited just went to him?
In a large part.
Okay. Did he spend $12,000 to put a roof on this house?
No.
No?
I mean, our roof needs repair from the damage. We still have open damage from the tornado.
Okay. And just to clarify, you're not asking the court to order him to pay the debt that you have?
Well, I don't anticipate, because I think he still owes me child support from the first time, so I've never collected on that, and I don't anticipate this to be any different.
So you're not asking for that?
Oh, no.
No, I don't anticipate any financial changes.
How much child support does he owe you from before?
3 or 4 years.
You don't know how much?
No.
You know that never goes away, right?
Good to know, yeah. Jennifer Roberts.
The judge is like, what, you said child support? I think she's definitely in a situation she needs to get out of. I'm not a huge fan of divorce, just because you want to, or you're like, it's not as fun as it used to be. I'm a big fan of Through Sickness and Health.
I'm sorry, I was waiting on you to finish.
I figured you were going to start talking when you're ready. I apologize.
I'm sorry, I thought you were making notes.
But this is
I
a
am
bad
making
situation.
notes.
Yes, Your Honor. And Your Honor can do two things at once, I understand. So is it your testimony that he has not contributed toward the house or household expenses pretty much at all?
No, sir.
Okay. I mean, that is your testimony?
Yes.
Okay. Nothing further.
Thank you, ma'am. You may sit down. Mr. Sanders, do you have any other proof?
That's the only proof that I have, Your Honor.
Mr. Lockhart, the plaintiff has rested their case and their proof. As I explained, your client has not actually appeared, but if you want to put any proof on, I'll consider it in my ruling. So.
Mr. Hartson.
Mr. Hartson, if you'll come right around here, please. I'm going to ask you to raise your right hand and be placed under oath.
Do you solemnly swear or affirm to tell the truth, all truth, nothing but the truth, so help you God?
So this is not the husband. Possibly the husband's dad?
If you would state your full name for the court.
Isaac Thomas Hartsook Jr.
And
move up there to the microphone, Mr. Hartsook,
Yes,
so
sir.
he could be picked up.
Yes, sir, I'm sorry.
I'll just be brief. Have you contributed toward
This is him.
this home and household expenses?
Yes, sir, I have.
Did you pay to have a roof put on the house?
Yes, sir, I did, every penny, $12,000 in 2011.
In 2011?
Yes, sir.
Have you paid property taxes on this house?
I have.
When was the last time you paid property
2
taxes?
years, a year before last, I caught up, I paid 2 years,
And ballpark, how much did you pay?
about $1,700.
This must be him.
Have you contributed any type of income to this household?
I do all the yard work, I do all the maintenance. Actually, I was told she would prefer that I didn't work if I would continue to do what I was doing around the house. I've been told that repeatedly. I can have that verified by another witness. I was blindsided. This initial hearing that actually culminated with the judgment by default, I was never aware of.
Mr. Hartsook, we're not here to contest that.
I understand.
You contacted me after that default went down. Judge is just giving you an opportunity to be heard on the financial aspect, so.
I'm sorry, yes, sir.
What type of income have you contributed? Not mowing the yard or doing laundry?
Various jobs I do. Currently I work for my son, our son. But through the years I've done I was declared medically disabled in 2012. And I have severe back, my back's a mess. It's hard for me to work, to maintain a job. I either have to sit or stand. I can't do both. I can't sit for a long period of time. I can't stand for a long period of time. I have to go back and forth. So but I do work. Yes, sir, I do work.
Primarily your contribution is at your wife's request, you stayed home and kept the house, is that correct?
Yes, sir, that's correct.
That's all the questions I have.
Mr. Sanders?
This one's getting interesting.
You said that you paid to have a roof put on your house in the house in 2011?
979 Hill Road, yes, I do.
And where did you get that money?
And you shield from insurance settlement.
I'm sorry?
From insurance settlement.
Okay, so it was insurance money that paid for the roof?
Yes.
Okay, and who?
It was from the injuries I'd incurred in a car accident.
And it's your testimony here today that your wife has indicated that she would like for you to be a stay-at-home husband and not work? Is that your testimony?
That's what she had told me in the past.
Okay. And you mentioned, or Mr. Lockhart mentioned, that you've been to the penitentiary, is that correct?
Yes, I have, unfortunately.
And what crime or what conviction resulted in you being in the penitentiary?
Forgery.
And
what was it?
Forgery.
Forgery.
Okay.
Oh, no.
And what did you forge?
My mother's signature, my wife's signature.
Oh,
Identity theft situation?
No, actually, it was really a malicious prosecution situation. It was okay for me to sign checks for legitimate bills and legitimate expenses, but I made some bad choices. I signed some checks for cash money. I'm a drug addict, and I was buying drugs with the money.
So you forged your mom's signature. She was one of the victims, and you forged your wife's signature. She was one of the victims.
Yes, sir.
How long did you go to prison for that?
Almost 3 years.
It was a malicious prosecution.
You've never paid a mortgage payment, have you, at the house?
I have.
You have?
I have.
When did you pay a mortgage payment?
I don't know the exact date and time. It would come up in our expenses, and it would be a debt. It would be an expense that had to be paid, and I would pay it. Our money, but I thought we were, I was under the impression it was a team kind of situation. We seemed to work some things together. At least that's what I thought our intentions were.
That's all I have, Your Honor.
Mr. Lockard, any other questions?
Nothing further, Your Honor.
Thank you, sir. You may stand down and have a seat with your lawyer. Anything else?
Just one moment.
Oh.
Wow. He had me right up until forgery. And I forged his wife's signature and his mom's signature.
Nothing further.
His two sources of income.
This is a case that's set for final hearing, and I'm not going to even necessarily need any sort of closing argument because I think the proof is pretty crystal clear in this case. Under 36-4-121, that's the statute that controls the division, distribution, and assignment of marital property and the allocation of marital debt. In this particular case, the default judgment was granted, and although Mr. Hartsook has not filed anything to set aside that or even to appear technically in the court, I've allowed him to participate in this hearing so as in the interest of fairness. And based on the proof before the court, clearly Mrs. Hartsook is entitled to an absolute divorce on the grounds of inappropriate marital conduct, and she has granted that divorce. Mrs. Hartsook is awarded the marital real property. The court finds that under 36-4-121, that marital property is defined as all property, real and personal, acquired by either party, either spouse during the course of the marriage. This was acquired by Mrs. Hartsook prior to the marriage. Proof has been that the mortgage is in her name, the title's in her name, and therefore there's no evidence before me to indicate that it is anything but her separate property. There is a statute, or part of that statute rather, that's under subsection 2B small or subsection I. Marital property includes income from and any increase in the value during the marriage of property determined to be the separate property in accordance with subdivision B4 if each party substantially contributed to its preservation and appreciation. And normally that would be the subsection under which we would be operating as to whether or not Mr. Hartsook's testimony should be credited that he has done things that would have increased the value. However, the problem is that the burden is on the party claiming to share in the separate property to prove that, number one, there's been an increase in the value of that separate property. Mr. Hartsook has produced no evidence to substantiate that there's been an increase in value of this separately owned property. Therefore, the court can only accept the testimony of Mrs. Hartsook that the property was purchased for $129,000 at the time she purchased it, and that the mortgage debt has increased due to her withdrawing money. So I do not find that there's any evidence regarding the value of the property other than the fact that the debt has increased substantially during the time of the marriage. So there is no evidence to show that there is an increase in value of the separately owned property of Mrs. Hartsook. The debt, marital debt is also defined under that, and marital debt is debt that's acquired during the marriage, and I have to look to what it was used for. And marital debt, in this case, was clearly used for payment of debts. Mrs. Hartsook's testimony was that Mr. Hartsook had gone through rehabilitation programs 33 times during the course of their marriage. That may not all be during the second marriage, but it certainly is clearly established that there are a lot of debts that they have incurred and that they have used money from her 401k and from the refinancing of the house to try to satisfy some of those debts. And for living expenses, since Mr. Hartsook has not substantially worked outside of the home. Based on all of these factors, the court finds that Mr. Hartsook should be awarded his vehicle and shall be responsible for the payment of any debt owing thereon and shall be responsible for the insurance on that vehicle, which I understand is already separated out. He will get those items that Mrs. Hartsook identified as being items that were family heirlooms or items that were passed down to him through his family. She will be awarded all of the items of personal property that she has acquired during the course of this marriage. And Mr. Hartsook shall have 30 days to vacate the marital residence, and Mrs. Hartsook is awarded that a marital residence as her separate property. Anything I have not dealt with, she'll be awarded all the remaining personal property, her vehicle, and she'll be responsible for it and any insurance.
She won.
I was trying to write, but those credit card that she testified.
Credit card debt, she indicated it was a, I mean, these are technically marital debts, but she's indicated that she doesn't believe he's ever going to be in a position to pay anything towards them. And it's another, I'm allotting those debts to her, but it also is an offset against any claim that he may have for equity in the marital residence. So, anything else?
So she gets the debt, she gets the
We're
house.
going to take our mid-morning recess. We'll be a recess for 15 minutes.
He walks away.
All right.
He walks away free of everything.
What's the recess?
And he still hasn't paid child support for the 4 years that was owed. We're going to skip this break. Let me run back to where I belong.
I gotta prepare the pickles.
Let's turn it down here a little bit. Why did she get the debt? Because he wouldn't pay it, and she's joint on it. So if she says if he's on it as well, it's just going to go back and affect her credit anyway. So she's going to try to pay that down, I guess, or possibly. I'm not sure if a bankruptcy is an option. He has to pay for his own car. All right, let's skip ahead just a wee bit because we've got a break we can get through because we've got our big case coming up. Little 15-minute break. Oop, there's the judge. Here we go. Boom. Okay. It's offset to his claim to marital assets like the house. Yeah. But she got the debt, the house, which it's not worth anything. I mean, sadly, it's convenient to have, but if it's fully mortgaged, there's no money in it. It's not worth it. If she sold it, it would go straight to the debt. She would get nothing from it. So a house is a house, but yeah. And I guess it will, in theory, it will continue to go up in value.
The case on the docket is Christopher Wayne Claiborne versus Amy Lee Childers Claiborne. Mr. Hawley?
Yes, sir. Judge, this was very much a contentious case.
Oh, goody.
No court remembers it. We were at the fifth.
This one I have no problem in remembering.
Fifth hearing that we were out on Halloween, and that moment the court granted a default judgment. I went back and listened to the court's ruling, and he granted a default judgment on the complaint for divorce, as well as stated that the motion for contempt dealt with the statutory injunction violation. There should have been a response to that, and I got a default judgment on the motion for contempt as well.
The child's going to have to be taken outside.
Judges, somewhat of a little history. The Miss Claiborne, or Miss Childers, I think is what she wanted to be called. We had always issues after that trying to locate her, trying to get her things and whatnot. I can tell you that, from the mail folks, and I'll be glad to give these to the court if you need them, but that's just all returned to senders. We had 2 addresses for her for the order, for the notice for today, and all of these things, and there's some 7 or 8 envelopes here that have been returned. I've got Also, there is a notice that we filed December 28th, setting it for the 15th from the court's direction today, the 15th of February. There was a letter that she had sent to the DA that was requesting everything be dismissed on a certain amount of money that Mr. Claiborne would pay to her. And the DA had given me that letter because it dealt with the divorce. She didn't really know how to treat that letter. I knew how to treat that letter, but she was going to look into it. I don't know what they ever did with that. It kind of goes with the criminal case. But I got an email address off of that where she had sent it to the DA, and I've been sending all this stuff to her email address as well. And I've got a confirmation that where we sent that to her if the court needs it. And that's all to say that I think she had ample notice that the court had set this on February 15th for a review of the order that I sent into the court. From the default judgment, I kind of did the best I could. If you will recall, when it was granted, she was yelled something at me, and the bailiff told her to leave. And it's one of those things we just kind of broke camp and took off as quick as we could. We didn't have a chance really to clarify a lot of things that were in the order. And I think that the court was wanting us to come here today to basically have some instructions on this order for me to possibly revise the order and do some things differently without any, without any direction from the court. I guess on that, I'd said that she was, it was civil contempt. He was granted a divorce on the grounds that were in the complaint, for divorce. Who will recall, we went through testimony with Mr. Claiborne. We introduced as Exhibit 1, or Exhibit A, I think it's marked, a sheet of items, several sheets of items that were dealing with the divorce and that she had absconded with, and we had a value on there. And he took a couple of hours to testify to all of those that, we had pictures where they were there in the home at one point, then they were gone from the home, and what a value of all that was. And in the order, we were from the contempt default asking for all of that, or the value of that to come back to Mr. Claiborne. That she be jailed on civil contempt, immediately held until such time as she returned all of those. If the court wants to give her 30 days or whatever the court wants to do, honestly, it's.
Well, my problem with your order is that a great majority of the order was accurate as to what the court's ruling was, but in the body of your order, she was found to be in civil contempt, and my recollection was that I was awarding your client the value of the property that was set forth, the items that were set forth. And without going into too much detail about it, it seems to me that there's two options you have on a civil contempt. Civil contempt, she can be incarcerated until such time if she purges herself by returning those items, or that I can give him a judgment, a money judgment against her for the value of the items that he said. I have no idea whether or not she ever will be able to be located or, to even incarcerate her, but giving him a judgment for the value of the items was what I had in mind on the day of the hearing. You had proven a value, and I don't recall, it was some $40,000, it seems like, maybe more.
Everything on that list, I think, was more like over 6 figures, was it not?
Okay.
Yes, sir. It was like over 6 figures.
Whoa, 6 figures.
Well, from our standpoint, I think what we would request, as there is a.
I think he's singing a Toby Keith song in his head. Should have been a cowboy. That's what he's saying.
Yeah.
Should have been a cowboy.
And I may need to talk with Mr. Claiborne a little bit if that's our option at hand. But I think what he would ask for is that if the court's direction is to give her a certain amount of time to return the items or be incarcerated with a capias, I think that's probably what he would request, other than a monetary judgment, and she can purge herself by paying him, that amount or whatnot.
You had included in there that there was an arrest warrant to be issued immediately for her, and the clerk was directed to issue that capias in a body attachment, and that she would be released on the issuance of a signature cash bond not to exceed $100,000, et cetera. And the court never ordered any of those things.
Yes.
So I think that clearly she was found to be in contempt for having removed those items, and the court is of the opinion that a finding of contempt in giving her some reasonable period of time to return those items, being 30 days. And at the conclusion of that, if she has not complied with the court's order, then a capias would be issued for civil contempt. So I think that would be the appropriate way to handle it. The only other thing that I wanted to address is the fact that there was an order of protection that had been transferred, I think, from General Sessions to this court, and that was never dealt with in the hearing in this court. But obviously, this court is based on the information and the fact that it was never pursued within the 15 days for a hearing, that order of protection had expired by its terms and by statute, but I declined to issue an additional order of protection. And this order needs to reflect that.
I will, if it's okay with the court, I may put that in a separate order since it is the order of protection. The reason why she filed that order of protection and got it, that we appealed that. So it was really her. I'll draft the order with what the court is saying here and send it to the court. And if it's okay, I'll put that in a separate order. I will say that we did discuss that. I remember that one time in court when she was present, and you did let her know that it had expired by its own terms. So I'll draft the order.
I thought I had, but we just need to have it clear in the record. So.
You had. And may I put in there, Judge, that if she is arrested, she has a right to either return the items or pay the monetary amount that he put on the side that he testified to was that. So
return the items or pay the dollar value. Either of those would purge herself. So.
Yes, sir. And I'll make those changes in the order, and everything else in the order was satisfactory?
Yes.
Okay. Thank you, Judge. I'll make the changes. That's what you want? Thank you, Judge.
All right.
We might have a spicy one coming up in Thurston as well.
March. We heard that, I'm sorry. No, I'm sorry, that is for hearings. Ms. Franklin, we have Miss Jackie Martin back in the waiting room. Do you want to try her again to see if we're able to proceed?
I will. Let me go get Miss Coffenberry.
Right.
Yeah, do you want to approach?
Hey, Jackie Martin, we need to know what's on the wall behind your head.
Which case was called?
Ms. Martin, can you hear me? Let's try your audio to see if we're able to hear you.
I'm still going cow skin. Maybe something from like exotic.
Ms. Martin, can you say something to see if I can hear you?
And she's gone.
All right, well, we'll move on to the next.
I think I can identify everything on the bailiff's duty belt. He does have 2 pairs of handcuffs. I believe he has mace, a baton, a taser.
Yes, sir. Can you hear? Can you hear me, sir?
I can hear you now.
He's got a firearm, but that's a low ride.
I apologize, sir.
Okay.
What's on the wall?
What's on the wall? So let me see, Ms. Franklin, we have Ms. Martin, and she is able to participate.
Miss Coffenberry. I've got her cell number.
Can you say something to see if I can hear you?
Yes, sir. Can you hear? Can you hear me, sir?
I can hear you now.
Okay. I apologize, sir.
Okay. We have a loop going where it's an echo.
They're using the phone to dial in, and the audio is being picked up on her mic.
Frankly, are we waiting for this?
Got a double connection. It can't be an elk, because elk don't have the white belly, I don't think. Do they? Do elk have the white belly?
Ms. Martin, what is the animal skin that's on your wall so that I can satisfy my curiosity?
It is a cow.
It's a cow.
A cow.
It must be far away from the camera because it looks small by comparison. So.
Yeah, it is. It's on the
away.
big wall up there, yeah. But yeah, it's a cow skin, yes. Yes.
It's a teeny cow.
It piques a lot of people's interest.
I would like to I would like to go and get this case heard while we have her online. What is Ms. Coffenberry's role?
She has filed a notice of appearance on behalf of 3 of the purported beneficiaries of this estate.
They can't find her? Got attorneys running all over the place. I'm just taking a peek at just how much is involved here. What are we fighting over? Oh, that.
All the time. I mean, see, Ms. Franklin, we have Ms. Martin, and
She's watching YouTube as well. She's got YouTube going while she's on Zoom. Yeah, Zoom and YouTube are different. They look very similar on your screen.
Ms. Franklin, is there any real dispute about, there's Ms. Coffenberry. Ms. Coffenberry, we're on the estate of Gregory Joe McCann. This is the motion to determine the heirs, and we have Ms. Martin who is here, able to hear us, and we can hear her.
Yes. So Judge, I filed this estate on behalf of Ms. Martin to open her brother Gregory Joe McCann's ancillary estate in the state of Tennessee. He passed away and was a resident of the state of Arizona. He had an interest in property that vested in him after his mother passed away, and some of that property was held in Dixon County. At the time he passed away, it was believed that he had another set of half-siblings. Miss Martin, Miss Decker, and Miss Dodson are his half-sisters through his mother, and there was a little bit of a rush to get this estate open in order to allow us to close on some real estate. So we have filed a motion for this court to actually legitimize and determine the heirs of this estate. Mr. Brown was previously appointed as the guardian ad litem for any unknown heirs, and he submitted his report as well.
Right. My understanding is that a birth certificate's been submitted which shows or substantiates that the 3 individuals in question are legitimate heirs of this estate. Is that correct? So yes, we're all in agreement. All you're really needing is for me to sign off on it?
Yes, Your Honor, that's basically it. I've entered a notice of appearance for them, and I've spoken to them that they are the heirs, and I think everyone's just in agreement. We just do need an order. That's all. Then I will find that they are, in fact, the 3 individuals that were shown to be potential heirs are, in fact, legitimate heirs of the estate, and they will be included in the distribution. All right. Thank you, Ms. Martin.
Thank you, Your Honor.
Your cowhide may go on about your business.
You and your cowhide.
Thank you. Needs dusting.
Tona, is that what I understand?
No. She's in Houston County, Judge.
Oh, I'm sorry. Never mind. I thought
Thank you.
And she's gone.
All right.
Now do we get to do the spicy one, Judge?
In the matter of Aries Malachi Jacoby March et al.
Your Honor, that's still in discussion. We're trying to see if we can.
We'll pass that and come back to it.
You might be able to settle that. I don't know what's going on out in the hall.
Yvette Hernandez Myers versus Thomas Clay Myers.
Sure. Before we start that hearing regarding that case, but before the hearing, I have
$10,000 donation. I'm not joking. I can't think of that.
I think we have.
We got some audio from Zoom, but no video.
Ms. Martin is still with us, but she's out now. So.
Eric, the Myers versus Hernandez Myers case, it was essentially began as a parental relocation case. My client filed a petition in opposition to that relocation, containing a modification and a request to reduce child support. Ms. Hernandez, based on recent circumstances, is no longer desiring to relocate. So the relocation has gone away. There are still things that my client would like to request of this court with respect to parenting time. However, that would require an amended pleading to be filed on his behalf, because the pleading that we filed to request the modification was based solely on the fact that she was relocating, which is no longer the case. So I'm asking the court to continue this hearing and allow me leave of court to amend my pleading in this case to ask for the request on behalf of my client.
Ms. Roberts?
Your Honor, it's our position. I represent Mrs. Hernandez, Ms. Yvette Hernandez, who's here in the courtroom. The parties have 3 minor children. They were divorced approximately 3 years ago when I represented Mrs. Hernandez in the divorce. He has 90 days of visitation. She had sent notice pursuant to the parental relocation statute that she was moving, and then after it was sent, she elected not to move. He filed the petition in opposition to the move. The only basis in the petition to modify anything was because the children were going to move to the Huntsville, Alabama area. That's no longer the case, and there's no pleadings, and there's nothing that is before the court to modify anything at this point in time. Our counter petition that we filed, again, includes some other additional things, that Mr. Myers was supposed to keep health and hospitalization insurance on the children. He was supposed to pay uncovered medical expenses. He was supposed to keep life insurance, none of which he has done. And so we're ready to proceed. But again, with all due candor to the court, I would have been objecting to everything that Mr. Myers said because it was outside of his pleadings and outside the discovery request. There's no pleading to ask for additional time, even based on the move. So Mr. Sanders is correct in the fact that the sole basis of his objection was because of the move, and my client has long since decided not to relocate with the children. So if you're going to grant I can't agree with the continuance. If you're going to grant the continuance, I would just ask the issue of attorney's fees be reserved, that my client be allowed to petition the court for the attorney's fees. Certainly we've prepared for this hearing, ready to go forward today. She's expended funds, and now we're going to have to go back, get new pleadings filed. We'll have to re-answer those pleadings, and then at that point in time, we'll have to do new discovery, all duplicitous. So effectively, we want to be able to ask for attorney's fees based on the fact that.
Well, the standard practice before the court is, not just this court, but all courts, is that amendments to pleadings are to be liberally granted. So the issues that are between the parties can be litigated without having to file separate proceedings. And so this court is of the opinion that Mr. Sanders' motion to continue to allow him a reasonable period of time. How long do you need to file your amended pleadings?
I'll have it filed within 30 days, but if 30 days is appropriate, I'm planning to have it filed.
File your amended pleadings within 30 days. The issue of attorney's fees for this preparation for this hearing today will be reserved until such time as we're able to determine the final hearing. So.
And rather than assigning a court date, would the court rather us set it once these things have been completed?
Yeah, we don't even know. I mean, Ms. Roberts is going to have the right to then file an answer and perhaps additional issues in her counterclaim. So I think you're a ways away from having a court date. So.
And Your Honor, I understand. I just want to make sure that the ruling, the attorney's fees for the preparation of this hearing is reserved. But again, we're going to, because they're amending, we will be able to ask. We've already had to do discovery. We're going to have to redo discovery. So may I add the preparation of this hearing and any new matters?
Well, I think the question, the main thing is that you were asking for attorney's fees having to do with the hearing being ready to go forward today, and that's the issue I've reserved. Okay. Any other litigation would depend on the outcome of that case and whether or not the evidence warrants an award of attorney's fees to either parties.
Right. And we've made that request in our pleading as well, the fact that she's now decided to divorce her new husband and not relocate. We've made the same request for attorney's fees, so all that's
Well,
for the court.
the issue that Ms. Roberts raised about the attorney's fees for this hearing is reserved by the court. Any future request for attorney's fees is obviously something that will have to be brought at that time.
Yes, Your Honor.
Thank you. Thank you, Judge.
Mark Allen Gilchrist versus Caitlin Elizabeth Gilchrist. Mr. Holly and Mr. Walsh.
Judge, my office has just sent to me what they looked at with his revisions that I got sent about 2 days ago, but I had a chance to look at it. If we pass this till after lunch, I'll have a chance to look at it and talk to Mr. Walsh about it a little bit.
You put it after lunch.
Thank you, Judge.
That brings us to Michael Andrew Betts versus Jamie Eudora Myatt.
We're ready to proceed, Your Honor. It's going to, do you want to get started on, everybody get started on it?
I'd like to get something done this morning before we break for lunch, but I'm going to have a little bit longer of a lunch period today, probably about an hour and a half. So if you want to take your lunch right now and then come back and start, we can resume at 1 o'clock.
And that's good. Yeah, again, I'm just being selfish here. It's not, we're going to be next.
You're next.
I didn't want, that was directed at Ms. Cottonberry sitting over there. If she tries to sneak in, or Mr. Holly over here, they've asked to be passed. You've granted that. We're ready.
That's right. As Judge Birch used to always tell me, you are passed to the tail of the docket. So.
Okay, they're passed to the tail. We're next. Thank you, Your Honor.
To senior.
Oh, thank you. And Ms. Cottonberry, I just have to note, Mrs. Cottonberry just denoted that since I am now the senior member of the bar, that I get the discretion to do that. So
well, we try to take.
I'll take that up with her at the break.
We try to take you as the senior member up quickly because your memory is not as good as it used to be. And good stay with age comes wisdom.
Okay, so apparently we're going to get a lunch before this thing starts. I love watching Judge Wolf, but man, he's got a lot of cases on his docket today.
We're behind you.
How long are you going to take?
2 or 3 hours.
He's coming back at 1:30?
No, it's 11:30. He's taking an hour and a half.
Oh, he's leaving now.
He's leaving now.
Okay.
That's why I just wanted to start, so we're next. So we need to start now. We'll take a break now. We're back at 1.
Okay, so everyone's going to lunch. Everyone's going to lunch. We don't need lunch, do we? Lunch is for the week, right? Just kidding. I'm just kidding about that.
Motion, I think I filed.
Oops, hang on. Let's back it up just a little bit. Don't want to miss any of this. We skipped lunch.
And nobody's refiled.
Bailiff just shut off the mics. Now we can't hear anything, Bailiff. Are you going to turn it back on? Here we go. There we go. Bailiff hits the button. 3, 2, 1. Boom.
We lose our clerk in the interim. She may be in there talking to them about the new date for that case.
I'm sorry.
They're going to talk to you about on that, matter of Aries, Malachi, Jacoby. They're going to be talking to you about a new date for that. So. All right, we are now ready on Michael Andrew Betts versus Janie Eudora Myatt et al. In the estate of Richard Omar Myatt. Anyone want to tell me who's the moving party in this case?
I think we all are. Ms. Roberts had filed the initial motion. I think I filed the second motion.
I just want to know who's going to get to go first. So.
I think probably the appropriate matter would be is Mr. Knowles is now representing the potential heir of the estate.
Here it is.
And I think probably from that standpoint, she's here to make as I understand Your Honor's ruling, is she had a certain time limit to come forward to establish her claim. She did not do that within the time frame. And so then we had a concern about service and whether or not proper notice was done. So we resent it. And then she is here making a claim now. So I think my motion and everybody else's motions were predicated on whether she was going to come forward. She has now come forward. And so I think appropriately, Mr. Knowles, as her representative, would go first to establish her claim, and then we would refute that or substantiate it, depending on each of our clients' positions.
This is the claim of Kathy Rundle, is that correct?
That's correct.
Your Honor. We filed an answer and counter motion.
Ms. Rundle is on Zoom with us, and she is in this hearing. She has not yet turned her video on, but is she going to be testifying, honestly?
She will. There should also be Miss Janie Myatt.
I have a Stephanie Lowe is the only other person that's in.
That's correct, Judge.
She's at Mr. Odell's office meeting us with assistance. She's my client.
Okay. So do I need to admit Ms. Lowe as well?
Please.
Yes, Judge.
All right.
It's going to be crowded in
So
here.
do you wish to make an opening statement? The issue that's before the court is whether or not Ms. Kathy Rundle, who is the person seeking to establish herself as an heir, is or is not a legitimate heir of this estate. Is that correct?
That's correct. And I would ask for the rule as well.
Rule has been requested. That means that I need to put Ms. You say Ms. Lowe is a party?
Well, Ms. Lowe is an attorney in Mr. Odell's office.
Oh.
Janie Myatt, my client, who is an heir, is actually there to testify.
So she needs to go
All
out.
right, so that doesn't matter.
So
Ms. Rundle is a party, so I just didn't know if I need to put any of those people back in the waiting area. So.
Well, and in calling for the rule, I just want some clarification too, because many of the people who are here are heirs.
Anyone who's an heir is a party.
So I know Mr. Vandervoort just sent some of them out. Some are just
I think all are heirs.
relatives of heirs, but we need to announce and put them on there and have their genealogies, verify who their
Got the whole
common
family
ancestor
reunion
was.
happening in court today.
Back in and they can verify.
Right. I just didn't want anybody to be excluded who is actually technically a party.
It's no problem. I've got a headache already.
You're welcome.
Okay, so everybody in court is an heir. Everybody has their own lawyers. We're all fighting over money. And there's this new, hey, guess what? I'm your long-lost sister you didn't know about person as well. I think that's the setup for
March
today.
28th was the day that I got notified that you were only going to take a half day.
Yeah.
Here come the heirs.
February 28th is today.
February 28th is okay. March 28th is the day I can only be here till noon.
5 more heirs just filed in.
I'm sure you must be mistaken.
February 28th is when he's doing both Dixon County and Stewart County.
And we have leap day, but it's the 29th, leap year day, but it's right now set for criminal cases.
I think the heirs are not fighting over the money.
Judge, if I may have
The heirs are
witnesses that we
disputing.
have here step up and down, we can all ask, and then we can be on the record. If everybody will
They're
step up.
disputing this other
Going to be testifying or?
new claimant.
If you would, just state your name.
Philip Estes.
And Mr. Estes, okay, got it. Okay.
So, Mr. Estes, tell you, Philip Estes, who is your parent that was a relative to either Richard and/or Charlie?
Kate Myatt Estes, sister.
Sister, okay, you step back.
And she's deceased.
Yes, deceased. State your name?
Similarities.
James Buchanan,
And who is your parent?
Edith Myatt Buchanan.
And she's deceased.
Right.
Okay.
Maurice Estes,
And who's your parent?
Kate Myatt Estes.
And she's deceased?
Deceased.
Sister of Richard Omar and Charlie?
Yes, sir.
Myatt. You have a seat. State your name?
Sheila Woodard,
And who's your parent?
Edith Myatt Buchanan,
And she is a sibling of Richard and/or Charlie
Yes.
Myatt. And she's deceased.
she's deceased.
Okay.
Larry Byram, my mother's, Martha Elizabeth Myatt, sister of Richard.
And she was deceased? Yes.
So all of these people are potential heirs of the estate and therefore parties to the action, so none of them should be excluded from the courtroom.
That's correct, John.
That's correct.
All right.
Thank you.
Wow. Okay, this is going to
We
get fun.
are ready. Now, would you like to, Mr. Knowles, make an opening statement?
Briefly, Your Honor, I would. This matter is before the court upon the request for Miss Catherine Rundle.
Going up to the podium.
For Miss Catherine Rundle to come and establish her right as an heir of her father, who was Charlie Might, who was the brother of Richard Might. The issue in this case is Miss Rundle is the child of Charlie Might, as shown on her birth certificate, which is recorded with the state of Tennessee, which creates a finding of parentage. So, beginning with, it's our position that this parentage is already established. She should not even be here today, as she is the legal child. That legal parentage could only be set aside after 5 years by showing fraud, undue influence, or duress, which was never filed by Charlie Might prior to his death, nor has it been filed now. Judge, I would submit there's been no other parties that have had to file any form of birth certificates or establish any kind of parental marriage at the time of birth. The proof that we're going to put on will show that Mr. Charlie Might held Miss Rundle out to be his daughter. They lived together, her mother and him, at the time of birth, and she is a rightful heir under this estate.
All right. Any of the other parties, counsel, wish to make an opening statement?
Judge, we would submit that this is controlled by 31-2-105, and the court looks at that. This was a child that was born out of wedlock. The parties never married prior to this, according to the statute, the parties were never married. It was not established prior to the father's death. The child was born in 1960, April, I think it was April 24th, 1960, and I think the court has to look at that time period and look at the statute and look what was going on prior to that. There was no requirement of voluntary acknowledgement of parentage. And at that time, the proof that would have been required is clear and convincing evidence. And Judge, we would submit there is not clear and convincing evidence, but she does have a burden of coming forward and establishing that she is the child. She's had that burden, and first off, she has not met that. There's a specific part of that statute says it's according to the creditor's notice, or a year. And certainly he's been deceased longer than a year. She has never come forth and asserted. Moreover, I think proof's going to show that no one in this family had any idea, ever heard of this person until these proceedings. So Judge, we think that the burden she has, one, she has failed to meet the time frame. The case law is all clear on that. Two, I don't think that she can clear the hurdle of clear and convincing proof. And so, Judge, we believe that's what the proof will show, is that, in fact, she is not the child. She's never been held out to be the child. Charlie Might, brother of Richard Omar, never held her out to be a child. None of the family members who had close ties to her, to Charlie, never heard of this person. So we believe that's what's going to prove going to show.
Ms. Roberts, you have anything?
No, Your Honor.
Mr. Region?
No, Your Honor.
Ms. Franklin?
No, Your Honor.
Ms. Rose?
No, Your Honor.
Mr. Holly, I know you're sitting back there. Surely you're not involved in this case, too.
I'm not, sir, no, or the Gilchrist. I think we've got the Gilchrist worked out, please the court. If we leave, can we just send the court an agreed order?
That's fine. All right. Mr. Knowles, it is your burden. You may call your first witness.
I would call Janie Myatt.
Janie Myatt?
Yes, sir.
She is on Zoom. I'm going to ask her to unmute and turn her camera on. You are Janie Myatt, is that correct?
Yes, sir.
If you'll raise your right hand, let me place you under oath. You solemnly swear or affirm the testimony you're about to give in this case to be the truth and nothing but the truth, so help you God.
Yes.
Thank you. Go ahead, Mr. Knowles.
Could you state your full name for the record?
Janie Myatt.
And Miss Myatt, are you the sibling of Richard Myatt?
Yes.
Are you also the sibling of Charlie Myatt?
Yes.
Do you know Miss Kathy Rundle?
She was born here in Dixon. I seen her for about 6 weeks here in Dixon, but I talked to her all the time.
Now, do you know when she was born?
I think it was in maybe April of 60.
Do you know who her father is?
Charlie says it's his daughter, and her and Dee was together at the time, and Charlie always told me Kathy was his daughter.
Ma'am, if you'll hold on for a second, please.
Object to hearsay and object that statute.
Objection is as to hearsay, Mr. Knowles.
Well, Your Honor, this is family history. There's an exception to family history. This is also under the dead man statute. Charlie is not a party to this action. Charlie's not the plaintiff or defendant.
Which certainly is, in as much as these claimed heirs are. So I would submit if these are party opponents. These are interested parties.
Well, if that's the case, it's a statement against interest, Your Honor. That would allow the hearsay into the record.
Well, not necessarily.
It's not necessarily hearsay. It's a statement outside of court.
I think that she can testify at this point regarding how her knowledge of how he reacted towards this child without having to quote what he said. So I'm going to sustain the objection as to the actual words, and you can have your client or your witness testify about any other matters that might be directly on point.
Your Honor, as administrator of the estate, I think that testimony would go to the distribution of the estate. That's what would be relevant to it.
May be relevant, but how is that an exception? Lots of relevant information is objectionable as hearsay. Mr. Vandervoort has objected to it coming in as hearsay, so I'm trying to determine is there an exception to the hearsay rule?
I don't know if the dead man statute would apply if it is to the allocation and distribution of the estate.
You don't think the dead man statute would apply?
It doesn't, Your Honor, with all due respect, it doesn't apply because it's dealing, the dead man statute only deals with statements about a decedent and dealing with the person who's testifying when they had a business dealing. And this was not a business dealing, it's family history, which is an exception to the hearsay rule, and establishing lineage. And then number two, this is not dealing with a transaction that Mrs. Janie Myatt had with the decedent. And so the dead man statute prohibits a person who was in the transaction making a statement about what the decedent said about that specific transaction. So that's what the dead man statute covers.
Mr. Reason?
The dead man statute applies only to actions in which a judgment may be rendered for or against the personal representative.
I'm not so concerned about the dead man statute as I am about the hearsay. And this, you're claiming, or it proposed that family history is an exception to the hearsay rule.
I believe it is.
That was more than a sneeze. I think we had a combo there. I think the sneeze was covered, Vicky.
Number 19 of the rules of evidence exceptions to the hearsay rules states the following. reputation among members of a person's family by blood, adoption, or marriage, or among associates or in the community concerning a person's birth, adoption, marriage, divorce, death, legitimacy, relationship by blood, adoption, or marriage, ancestry, or other similar fact of personal or family history. Therefore, it would fall clearly within that exception to the hearsay rule. Your objection is overruled. You may continue. Ms. Myatt, the question had been posed to you about what you knew about Ms. Rundle, and you were quoting what your brother Charlie had said about this lady.
Yes.
You may want to re-ask your question.
Ms. Myatt, were you present when Kathy Rundle came home from the hospital?
I did not see her come home from the hospital, but I was at their apartment within a few hours after she got out of the hospital.
And when you say you were at their apartment, whose apartment were you at?
Charlie's and Dee's.
Dee being Miss Kathy Rundle's mother?
Yes, over on Center Avenue.
That's where the apartment was?
Yes.
Okay, so you were present when they brought Miss Rundle home from the hospital. Was your brother holding Kathy Rundle out to be his child?
He told me to come in and see his little girl. He had a little girl and wanted me to see her, and I helped her, and I was at their apartment.
And did he continue to reside there with Miss Rundle and her mother?
For probably about 6 weeks. And then they left and went to Illinois. I think it's Illinois or Indiana one.
Illinois.
And they was up there till 1962.
And when you say they left and went to Illinois, are you referring to Miss Rundle, your brother Charlie Myatt, and Miss Rundle's mother?
Yes.
To your knowledge, did they live together as a family?
Yes.
Now, throughout your lifetime, did your brother make any statements stating that he was the father of Catherine Rundle?
Up until he died, he wanted me to find his daughter, Kathy. He wanted me to find her.
And were you ever able to locate her?
No, I didn't know where she lived or what her last name was, and there's no way I could find her.
Now, who cared for Mr. Charlie Myatt before his death?
I did.
And during that time, did he discuss Kathy Myatt with you?
Many, many times.
And was he claiming her to be his daughter?
Yes.
After Mr. Charlie Myatt passed, did you go through his personal affairs? His personal...
Yes. Yes, and found Kathy's birth certificate.
And did you provide that birth certificate to anyone?
I sent it to Kathy.
And did he have any other documents showing Miss Rundle as his daughter?
There was a family Bible that belonged, I think it must have belonged to Dee, and it had their names in it. And it had Kathy's name in it and her half-brother's name in the Bible. And I sent it to Kathy.
Okay. At any point, did Charlie Myatt state Kathy was not his daughter?
No.
I believe in Tennessee, the family Bible
Your Honor,
carries
that's
more
all the
weight than the
questions
birth
I have.
certificate.
We'll start with Mr. Van Voort. Mr. Van Voort, do you have questions?
Yes, I do. So, Ms. Myatt, I'm Kurt Van Voort. I represent Sam Myatt. Can you hear me?
Yes.
So, you had just testified that you sent a certificate of birth to Kathy Rundle upon his death, correct?
Not till Kathy notified my brother and I got her address.
Okay, because that's what I was going to ask you, because you said earlier you didn't have her address. You didn't know how to look.
Okay, when Kathy's grandmother passed away, Kathy did not know what her daddy's name was all these years. And when Kathy's grandmother passed away, she found Charlie's name on a piece of paper from Dixon, Tennessee. And she went down, her daughter got the Dixon County phone book and went down and called every Mike in that phone book, and she got a hold of Eugene Myatt. That's my brother. And
I'm not asking all that. I'm just saying, you earlier said you didn't have her address.
I was trying to tell you how I got it, but okay.
But is that correct? You did not have her address at the time your brother was deceased?
No.
Because that's what I was going to ask. Now, you're saying that you literally were there for the birth?
I was in Dixon. I wasn't in the room with her when she was born, but I was there at the hospital and in their apartment.
And you're saying that you visited them at the apartment?
After the birth, yes.
And then you in fact, held Miss Rundle?
Yes.
And as a matter of fact, thereafter, within 6 weeks, they all left, and this was in 1960, about April of 1960, I believe. You're saying that thereafter is when they left and went to either Illinois or Indiana?
Yes.
And so your brother Charlie was living in Burns at the time, correct?
No, he was in Indiana, Illinois with Kathy and Dee.
Okay, but at the time prior to that, he was living in Burns with your parents, correct?
I think him and Dee left at the same time and went to Illinois.
Okay, but my question to you is, he was living in Burns? You remember that?
Him and Dee was living in Dixon on Center Avenue.
Living in Dixon Center Avenue. Well, the birth certificate, which hasn't been introduced, but it shows an address. Do you remember the P.O. Box 206, Burns, Tennessee, back when there were just boxes, Box 206?
I don't remember whose address that is. I remember the boxes, but I don't know whose address.
Do you recall your parents' address?
It might have been their address. I don't remember their box number.
Okay, so if it shows that on the birth certificate, you just don't recall?
No.
Okay. But you recall specifically visiting, you recall them going to Illinois in 1960, April, and spending until 62. Is that your statement?
Yes.
And as I understand further, your statement is that upon your brother's passing, or you took care of him before his passing, he wanted you to have contact with Kathy Rundle?
Yes.
Okay, that's your statement?
Yes.
It was very important to him, is what you're saying?
Yes.
And then he passed away?
Yes.
He passed away, I believe, in, let's see, he passed away in April the 24th of 2009. Do you recall that?
Yes.
And you're saying his daughter was very important to him?
Yes.
I mean, and you recognize that as a fact?
Probably, all in all, he probably asked about 100 times to find her for him.
100 times?
Mm-hmm.
Ma'am, you, in fact, took care of the funeral arrangements for your brother, didn't you?
Yes.
And you went to Span Funeral Home and you were the informant for your brother's passing, correct?
Me and my sister went together.
You and your sister. Which sister?
Elizabeth.
Elizabeth. And who were her children? Who are the children of Elizabeth Myatt?
Larry and Glenda and Judy and Earl and Donald Ray.
And so she went with you?
Yes.
But you provided all the information to the funeral home, correct?
Me and her both did, I guess. We both talked.
And you were there, correct?
Yes, yes.
Judge, if I may, just 1 second, pass out. Ms. Maya, you, as you said, you were the informant for the information for the funeral home. Your name is listed on Charlie Myatt's certificate of death. You familiar with that?
I don't remember, I guess.
You guess, but you did make the arrangements.
Me and my sister did, yes.
Of course, you're not a judge. I don't know how the court wants to handle this. Normally I would hand it to her, but she's not here.
I know, I don't have any advice for you other than the fact that if you want to hand it to me, I will demonstrate it in front of the camera on my computer.
Right there.
Right.
So we have an estate case here.
So what are you asking her to look at?
This is, Your Honor, this is an affidavit of custodian of records on the front. Jake Beard, he was a custodian of record for Span Funeral Home. And I would represent to Ms. Myatt, Janie Myatt, that the first page consists of Charlie Myatt's obituary, and it does not reflect the name of Kathy Rundle or Kathy Myatt within that obituary.
For the purposes of expediting it, it says what it says, and Miss Rundle is not listed. So again, whether or not again, she's not listed as an heir in a document through the newspaper on an obituary that Span Funeral Home prepared. We'll be happy to stipulate to that fact.
Well, thank you for that. But moreover, she and her sister are the ones who provided the information. Judge,
it's been established, but if you want to ask for that specific question, there's a stipulation that Kathy Rundle is not listed in the obituary that Span Funeral Home provided for the publication, nor in the obituary notice form that Span Funeral Home utilizes. And if you want to ask her about that, it's been stipulated that the information is not there, and you can ask her who provided that information for preparation of those things.
Yes, sir, and that is the question. But Ms. Myatt, you provided this information, correct?
Yes.
And as a matter of fact, on the last page here, it shows that you are responsible for the funeral arrangements, correct?
Yes.
And her name was not listed, correct?
I guess if you say so, I don't remember.
Well, if your attorney has said that her name is not listed, and you all are stipulating that, I'll verify that you understand that.
It's actually, I don't think you represent this lady, is that correct?
I represent Miss Myatt.
You represent Miss Janie Myatt?
Yes, Your Honor.
Okay, I'm sorry.
And again, the document speaks for itself.
Ms. Myatt, your lawyer here in the courtroom, in order to try to expedite things, has agreed that the documents speak for themselves, and will tell you that the documents do not contain Kathy Rundle's name in the obituary that was published, nor in the obituary notice that was prepared for Span Funeral Home. So you can take that as a fact.
Right. And ma'am, this is despite your brother telling you this hundreds of times, correct?
Yes.
Okay. And ma'am, you never mentioned this to any of the other family, correct?
Oh, yeah. I talked to Richard about it, Eugene about it, Lisbeth about it. In fact, after Lisbeth and I made the funeral arrangements, Eugene and Richard went down and looked things over and said everything I'd done suited them and it was okay with them. I didn't make all the decisions by myself. They backed me on everything.
Yes, ma'am, but I'm talking about specifically about this child. this child, you never spoke with any of the other family members about it?
Oh, yeah.
Okay.
He would call me and I'd tell Richard, well, Kathy called me today. Charlie's daughter called me today. I talked to her. I would talk to him and tell him I heard from Kathy.
Your brother Sam would have known about it.
No, because me and him don't speak.
But you actually do not like, and is it fair to say you despise Sam?
No, I don't despise him. I just don't like his actions and his mouth.
So Elizabeth, who is your sister, was present at the time, and you would have talked to her about it, and her children would have known about it, correct?
Oh, yeah, they knew we done it.
Speculation. She can't know what the other people's children know.
Ma'am?
Sustained.
Ma'am, you never took steps in opening your brother's estate to establish who his children were, despite his request for you to find his daughter, correct?
Yes, I was just under a lot of pressure, and I didn't even know what her last name was at the time. I mean, 60 years later. It was just an oversight on my part, but I recognized her as being Charlie's daughter, and Richard and Eugene did, and Elizabeth did. We talked about it.
Judge, I would ask that be made an exhibit. I have the originals here, if I may, approach. Judge, I have it. That's in both cases. I just did affidavits for both cases.
So Rich and Eugene now are saying...
Ma'am, just to be clear, you don't recall the address where your parents resided?
Yes, right. It was Mike Luke, Burns, Tennessee.
Okay.
Ed and Martha Mike, Burns, Tennessee. But I don't recall the post office box because it seemed to me like this is around.
You don't remember the box. Okay. Judge, I have no other questions.
Your Honor, I have some questions.
All right.
Hey, Miss Janie.
Yes.
What's your mom and daddy's name? What were their names?
Martha Elizabeth Lowe Myatt, and Daddy's name was Edward Omer Myatt.
And then how many children did they have?
12.
12 children.
Mm-hmm.
You have 11 siblings.
Yes. Well, the last one was just born dead, but there was 11 of us living, yes.
11 living children.
Yes.
And were y'all close family growing up?
Well, yeah.
And as y'all aged, most of y'all continue to reside in this area, is that right?
Yes.
Now, Charlie, what was Charlie's vocation? What was his trade? What did he do for a living?
He retired from I think it was the state of Tennessee, the fire tower. He worked for the fire tower there in Burns.
Okay.
He worked for the state.
Okay. And at some part in time, did he start traveling?
He went with the carnival. He went with the fair. That's when he left here. He went with the fair. That's when he met Kathy's mother. Was with when the fair was here in Dixon. He left and went with them.
So he became, I guess what you would call a carny at some point in his later life. Is that right?
Yes. Uh-huh.
He would travel around from different events and where these carnivals would put on county fairs.
Yes.
Travel with them. Is that correct?
Yes.
And to your understanding, that's where he became acquainted with, I think you call her Dee?
Yeah.
And Dee is Miss Kathy Rundle's mother. Is that right?
Yes.
And so did Mr. Charlie Roy Mike, did he own any property, any land, anything?
No.
So when he passed away, was there any assets of his estate? Did he have anything that had to be probated, or did you have to deal with anything?
No, I took care of it, was Elizabeth and Richard and Eugene's help, and he ended up in the nursing home, and everything he had was taken up in the nursing home. Time I paid for his funeral and everything out of it.
Right, so there was no need to probate his estate, to open it up, to find out who his heirs were, because there was nothing left to give to anybody, was there?
No, there wasn't.
And the at the time of of Charlie's death, how long had he been in the nursing home?
Really, I can't remember, but offhand, I would say he had a stroke. Maybe a year. I really don't know, Jennifer. I really don't remember, but I'd say maybe a year.
And his health declined steadily for a bigger period of time. It wasn't something, his death didn't come imminent. He didn't have a stroke and die a few days later.
No, he laid in the house for about 3 or 4 days with a stroke before anybody found him. And then he was taken to the hospital, and then he was in the hospital, and from there he went to the nursing home.
And what house did he lay in, ma'am?
He rented an apartment there in the alley from the Underhills. He had an upstairs apartment. He rented from Edwin and
Robbie
Underhill.
Edwin and Robbie Underhill owned some property over there, and he lived upstairs.
And over a garage.
And so they found him there, and then he lasted for a while, but had to be taken care of. And you were the one that took care of him in the nursing home, right?
Yes, me and my sister.
So at the time of his death, from the time in 1960 when Miss Kathy Rundle was born, and you said they left about 6 weeks later. And were they, where they were going? Were they re-going and doing their carnival stuff at that point in time, or were they moving somewhere? Do you know?
We thought with the carnival, but my mother, I don't know if I'm supposed to say this, but my mother came to Michigan to see me through a birth. And when she left there, she went back to Illinois and hunted around and found Charlie and Dee, and he was sharecropping on a farm in Illinois. And that was 2 years later.
Okay. And so, and then when did Charlie come back to Dixon?
Say maybe within a year after that. He came back and he's been there, was there ever since.
Okay. So he met Dee doing carnival stuff. They came back here.
Mm-hmm.
And gave birth.
Mm-hmm.
And they left and went to Illinois doing some sharecropping.
Mm-hmm. That's where my mother found him.
Okay, and your mother found him. And then he came back here a year later. Did he come back alone?
Yes.
Were there conversations about what happened or where Dee was and where Kathy was?
Well, I asked him on many times where the baby was, and he said, I don't know where she took her. I don't know where she's at. I don't know where she took her. So I can't fill in the details on that because I don't know.
You don't know?
Sorry, hold on.
Mm-mm.
Say on that doesn't have anything to do with family lineage.
Well, Your Honor, it from a standpoint of Mr. Vandervoort, ask her about the location and when she knew where Miss Kathy Rundle was, and it was just foundational getting to that. I'll move on. So from that would have been 1962, 1963 was when he came back?
Yes.
Okay. And so from 1963 until he passed, in what year? You remember what year he passed? 2009?
Yes.
2009. Had you been successful, or did you even know where to start looking for this daughter he was asking for?
I didn't know where to start looking. I didn't know what her name was, what state, or nothing. But he asked about her many, many times, but I didn't know how to start looking.
In your did you know any family history of Miss Kathy's mother?
No.
Where her people were from, where she
Nothing. Nothing.
So you wouldn't even know where to start looking?
No.
So when did you, at Charlie's death, did you even know if there was a child by the name on this birth certificate, Catherine Jean Myatt?
I didn't see the birth certificate until after Charlie passed away.
So you just know you saw a baby that he held out as his. Did you know her name was Kathy?
Yes.
That's what they had given her the name at birth.
Uh-huh. But I didn't see the birth certificate after Charlie passed away.
And you found that?
Yes.
Going through his personal effects?
Yes.
And that would have been in 2009, correct? Or
Yes.
sometime after his death. He died in April. So how long from 2009 was it until you had contact with Kathy Rundle?
I think Charlie had been passed away about 3 months, and Eugene Mike got a phone call from somebody and wanted to know if they knew a Charlie Roy Mike. And Eugene was kind of rude, and he said, yeah. Well, how can I find him?
Hold on just a second.
Miss Janie, hang on. Mr. Vandervoort's got to speak up in the microphone. He objected. Okay. So hang on.
Judge, my objection is the hearsay as to what Eugene Myatt may have relayed to her or didn't relay.
Your Honor, we're not offering for the truth of the matter asserted. We're
Overruled. I don't think it's being offered for the truth of the matter. It's being shown as to how contact came into to play. Overruled.
All right, Miss Janie, that means you can go on and tell me what you were saying. There was some phone call that came that prompted you to do something. So what happened?
No, this lady called Eugene Mike and asked Eugene Mike if he knew where Charlie Roy Mike was or did he know him. And Eugene thought it was a bill I had forgotten to pay. And he said, yeah, he's over in Hall Cemetery, dead and buried. And she said, well, I'm Charlie's granddaughter.
Dead and buried.
And we have just found Charlie's name on a piece of paper. My grandmother passed away, and this is the first time my mama knew her daddy's name. And that was about 3 months after Charlie passed away, that her grandmother passed away.
Maya, if you'll hold for just a second. Is his microphone on at that table?
It is now, Judge. I renew my objection, Your Honor, on this testimony that she just provided. Clearly, it has a whole long list.
We'll move on, Your Honor.
Well, Judge, is moving on, but if I can get a ruling on the objection, in as much as she just testified that what that person said about a long line of family trying to establish that, in fact, Charlie was, quote, the father. So,
Judge, that goes to family history.
But it's hearsay.
This is the lineage.
It's hearsay, Judge.
Which is a hearsay exception.
The whole point of the hearsay exception is it is not hearsay if it's accepted under the rules. And I will repeat, reputation concerning personal or family history, reputation among members of a person's family by blood, adoption, or marriage, or among associates in the community concerning a person's birth, adoption, marriage, divorce, death, legitimacy, relationship by blood, adoption or marriage, ancestry, or other similar fact of personal or family history, all of which encompasses what we're talking about.
And so,
go ahead, Mr. Vanderbilt.
Judge, but it isn't, because this phone call was from somebody that didn't know, that wasn't in the community. They lived out wherever. It wasn't somebody in the community. She's repeating what was told.
It's reputation among members of a person's family.
It's a relative.
That's the point. At this point, it's being offered as a member of the family, the grandchild of Charlie. This would be Miss Kathy Rundle's daughter, I assume. And it's being offered by someone who purports to be a member of the family. So that is, in my opinion, and my ruling is it's squarely within the exception to the hearsay rule concerning personal and family history. So overrule the objection.
Ms. Janie, I just want to cut to the chase. Because of a phone call that was received first by Eugene, and then when you were talking to to some individual out there, did you rummage through Charlie's things and find that birth certificate?
Yes, I done had it, yes.
I mean, wherever you had just put it up somewhere and you got it out. And is that when you first, because of the information that you gleaned from that telephone conversation, did you reach out to Kathy Rundle, or did Kathy Rundle herself reach out to you?
Yes, for the last 10 years, we've came in close contact.
And at some point after that communication, that phone call after about 3 months after your brother Charlie died, is that when you sent her that birth certificate?
I sent her the birth certificate, and she said she had no idea what her daddy looked like. And I sent her some pictures of Charlie, and I sent her the family Bible, and quite a few things of Charlie's that she wanted. Yes, I sent it to her.
Okay. And then you've continued to have communication with her since that time?
Yes, regular basis.
Now, of the 11 living siblings that your mom and daddy had, after Mr. Richard died, there was 3 of y'all left, is that correct? You,
yes.
Eugene, and Mr. Willie Sam, is that correct?
Yes.
And so you have a financial stake as a sibling to take from Mr. Richard Myatt's estate, correct?
Yes.
And you also are a party to a partition suit where the Myatt family farm out there was sold for a considerable amount of money. Isn't that right?
There's the money. The farm.
And
was
you
sold.
understand that if Miss Rundle would be the only child of Charlie, your brother, correct?
Yes, yes.
So she stands in place instead to take the same amount of money that you and both Mr. Myatts would take, because she would take your full brother's portion. Is that right?
Yes.
And if she's denied taking that, and if she's declared by this court not to be a sibling, that would be financially beneficial to you, because I think if we've got the exactly right, Mr. Regent's statement is, you would take a percentage of Charlie's money.
It's not about money. It's what about it's honest and fair.
And that's what I was going to ask you. Is it about money?
No, it's not about money. It's about what's honest and fair.
Okay, that's all I needed, Ms. Cheney. Thank you very much. Now, somebody else may have some more questions for you, okay?
Ms. Franklin, you have questions?
Good afternoon, Ms. Myatt. My name is Sydney Franklin. I'm the attorney for your brother, guardian ad litem for your brother, Henry Eugene Myatt. I just have a few questions I just want to clarify. So after Ms. Rundle was born, you said that your brother and her mother, Dee, lived in Dixon for about 6 weeks?
Yes.
And then they traveled, correct?
Yes, to my knowledge.
What was the time period from the time they left Dixon until your brother returned?
Probably a little over 2 years.
And during that time, did you speak with your brother, Charlie Myatt?
No, we didn't know where he was. My mother found him. We didn't know where he was either. They were together, but we didn't know. My mother didn't know where he was. We didn't hear from him.
Okay, but during that time period, is it your understanding he was acting as Miss Rundle's father?
Yes, they were living together. My mother said they was living together at a sheriff's farm crop when she left Michigan and found him.
Okay, I have no further questions, Judge.
Mr. Reason?
No, Your Honor, I have no questions. Thank you.
No questions. All right, thank you. Mr. Knowles, do you have any redirect?
Briefly, Your Honor. I think everybody's seen a copy of the birth certificate. I think it's attached to everybody's pleadings.
He's got the birth certificate out. Lots of lawyers here selling the family farm, especially back in the day. The family
Your
farms
Honor,
were
could you
large.
hold this in your camera as we discussed earlier, so I can ask Miss Janie Myatt if this appears to be a true and accurate copy of the document she found in Kathy Rundle's birth certificate. Could you hear my question, Miss Janie?
I could, but I can't see very well and I can't read what's on there.
Can you scoot up close to the computer and see if you can see? Does that appear to be the birth certificate that you found, or a true and accurate copy of it for Miss Catherine Jean Myatt?
Yes.
Judge, I'd move that be Exhibit 2.
Mark it as the next exhibit.
We would need to mark it in both cases.
We're trying these cases jointly, at least on the motion portions. So you would mark it as an exhibit in both cases.
That's all I have, Your Honor.
Any recross?
May I see Exhibit 2?
Birth certificate.
I imagine we're talking about millions of dollars here.
Ms. Myatt, the birth certificate that has been admitted reflects a box 206 as the address, apparently it appears on here, for Beatrice Jean Hammond. That's in Burns, Tennessee. Do you recognize that address?
I don't know if that was Mom and Daddy's address. I do not know of them ever living in Burns, so I can't testify to that.
Okay. Ms. Roberts, your attorney, had circulated to all the parties, I'll pass it around, a certificate of live birth that had been requested, looks like, and there's a certification in March the 5th of 1990. And it was sent out, looks like, to Central Point Branch, United States National of Oregon. Do you have any idea from where that came?
Dee lives in Oregon, and Kathy lives in Oregon, and that's all I know. It must be something Kathy sent her. I didn't have anything to do with that.
And it says 1990, March the 5th of 1990. Is that something you would have supplied to your attorney?
The only birth certificate I know about is the one that I sent Kathy, and that's the one I can testify for.
Okay. Judge, I'll pass this around.
So there's a request for a certificate of live birth dated 1990, well before this woman who's testifying.
Ma'am, your earlier testimony is that you had no way of contacting her, Miss Kathy Rundle, because you didn't know her name.
Correct.
But you knew her name was Kathy. You knew her mother's name. You knew Beatrice Jean Hammond, correct?
Not till I got my brother's stuff and seen it on the birth certificate.
And you knew, so you didn't know it. You didn't know the mother's name before that.
All I've ever heard Charlie call her was Dee.
Okay, you did not know her last name?
No, I guess no.
Did you
All
know,
I ever heard Charlie call her was Dee.
Did you know Kathy's name?
Well, I knew Kathy's name was Kathy Jean Knight on her birth certificate.
Yes, ma'am. And so you did have some information to try and track her down in 2009.
Well, I guess I did, but I didn't see it. At the time I was upset, I didn't see the point in it. There was nothing left. There was nothing to divide out. There was nothing left, and I had no idea to find her. And I asked Kathy, I said, Kathy, after I found her, I said, Kathy, what name did you go by? She said, just whatever man my mama was living with that month. She said she never had a birth certificate until I sent her that one.
Okay. I'm sorry. I didn't interrupt. Go right ahead.
So she went by several different names. Whoever her mother was living with, there was no way of me tracking her down. But there was no reason to track her down because there was nothing left.
Okay.
I think that the attorney who's at the lectern right now is the only one who's fighting to not let this lady have her take. It seems like all the other attorneys are their clients are good with it. So we've got one son who's the outlier.
This is a certified record or document that was circulated by Miss Janie's counsel. And Judge, it appears to be certified. This was in 1990. It was sent out to Oregon at the time. I'm asking that it be admitted as the next exhibit.
Your Honor, I'm not certain if that's an original document. I don't know where that stamp come from the Bank of Oregon. It's not certified by any bank or where this record even originated from. We don't know. So I would object to that document as it's not
well,
original.
This witness has not authenticated this document. She's not established that the document is one that she's familiar with, if I understood her testimony. So I don't think it would be proper to introduce it through this witness. You may have another witness who can introduce it, but not, if I'm understanding her testimony, it's not something that she remembered or acknowledged or knew anything about. So.
Okay, Your Honor.
The introduction of a document during the questioning of this witness that she has no knowledge of would not be appropriate. I'll sustain the objection at this time, subject to you finding another way of introducing it if you choose to. So.
Ms. Myatt, where were you living in 1960?
Lincoln Park, Michigan.
I'm sorry, you were living in Michigan?
Lincoln Park, Michigan.
Okay, and at the time of the birth, you were living in Lincoln Park, Michigan.
Lincoln Park.
Yes,
Okay. And were you married and living there?
yes.
And you're
When Kathy was born, we was home. We came home on vacation, is the reason I know about Kathy. We was home on vacation.
And you were married at the time?
Yes.
Had children? How many children do you have?
Well, I had 4, but I lost 1 with brain cancer, so I've only got 3 left.
And were your children, you were living up there in that part of Michigan at the time?
Lincoln Park, Michigan, just off of Dix. They're in Lincoln Park, Michigan.
Okay. But those are all the questions I have.
Anybody else have any other questions?
Again, I don't know that it's necessary, Your Honor, but Miss Janie.
Yes,
You not remembering the box number that your parents' house was. Back in the day, back in the 60s, we had a different mailing system in Dixon County, did we not?
I think it was Route 1 or I think we lived on Route 1, Dixon, Burns, Tennessee is all I remember.
And again, back in the day when you had boxed something, that wasn't necessarily referencing a P.O. box that Mr. Vandervoort said. It wasn't a post office box.
No, it's a box on the mailbox. It was a number on the mailbox, I guess, but I don't remember what it was because it seemed like back then we had Route 1 and Route 2, Burns, Tennessee.
And that was just because the number of mail carriers you either on Route 1 or Route 2.
Yes.
And then the box number was not Mr. Vandervoort, and again, he's a lot younger than we are, but he referenced a P.O. box, being a post office box. It was
No, my mother and daddy, as I know of, never had a post office box.
That's all. Thank you.
Anything else? All right, thank you. Are we going to allow her to? Ms. Myatt, you are a party to this, so you may turn off your I'm going to turn off your camera, but you can stay in the hearing if you like. Okay.
Okay, I'll get his receptionist to come in here and do it. Okay, thank you, David.
She calls him David. The judge smiles. Thank you, young man. Appreciate that. Thank you, son. Oh,
Judge,
love that.
Catherine Rundle.
And she's on Zoom as well, correct?
Yes, Your Honor.
So the one who's coming in on Kathy Rundle, this is the child, the disputed child. Janie did great. What a great witness. She's like, if this is validated, if this extra child is validated, it takes away a cut of all of our inheritance from this huge farm sale. But it's not about the money; it's what's right. And this lady is
Rundle, I need you to unmute your device, please.
Where can I live? I can live in the top right-hand corner, right? Is that okay? Go up here for a bit. That's
there it is.
There you go.
They can see you and hear you now.
Thank you, Ms. Myatt. Ms. Rundle, if you will raise your right hand, let me place you under oath. You solemnly swear from the testimony about to give in this case to be the truth and nothing but the truth, so help you God.
Yes, I do.
Thank you. Mr. Knowles?
Could you state your full name for the court, please?
With my married last name?
Your legal name, yes, ma'am.
Catherine Jean Rundle.
And Ms. Rundle, could you tell the court your parents' names?
Beatrice Jean Hammond was my mother. And I found out that Charlie Ray Myatt was my father.
And when did you discover that Mr. Charlie Myatt was your father?
When my daughter, my youngest daughter, her and I were talking, and I don't know where she got the stuff from, but she came in where I was sitting one night and told me that she had somebody on the phone that I needed to talk to. And that's when first time I talked to my Aunt Janie.
And at that time, did you learn from your Aunt Janie that your father, Charlie, had been looking for you?
Yes, as well as I was looking for him.
And had you had trouble trying to find him?
Yes, because the Hammonds, they were going to make sure I did not find him.
Oh.
Do you know why?
The only thing I know is my grandfather was extremely rude, and if I ask him or my grandmother about my dad, they would just tell me to look in the mirror and you'll see him.
When did you first see your birth certificate?
When Aunt Janie sent it to me.
You never seen your birth certificate prior to that?
No, and I asked my grandmother about it, and she said she didn't know anything about it.
Okay. Now, do you or did you actually know anything about your father?
No.
Prior to this time?
No, not until I started talking to Aunt Janie.
Okay. Now, Ms. Rundle, you don't drive, is that correct?
That's right.
You don't have a computer?
No.
Would you say you're very good with technology?
No.
And has that limited your ability to know and come to court?
Yeah. And I'm sorry, but I'm like extremely nervous and scared.
Yes, ma'am. I understand. Well, it's okay. We're just trying to get information, okay? Now, Judge, are you familiar with your birth certificate?
I am now.
Okay, and who does your birth certificate list as your father?
Charles Ray Myatt.
I think it's Roy.
And do you believe him to be your father?
Yes. After Aunt Janie sent me some pictures of him, and my grandson was here one evening spending the night with me, and I cannot believe how much he looks like my father.
So you've noticed a lot of family resemblance?
Yeah. And even my granddaughter is the one that pointed out to me that my Aunt Janie and I look a lot alike.
Your Honor, could we show the witness a copy of Exhibit 2?
Exhibit 2 being the birth certificate?
The birth certificate.
We'll do our best.
Thank you, Judge.
Has to say Roy.
You're dealing with someone who can't back up a trailer, much less get a...
Does this appear to be your birth certificate?
I'm not seeing a birth certificate at all.
You haven't seen your birth certificate?
No, the one that you have somewhere, I can't see it.
Oh, you can't see it?
Okay. No.
Well,
our point of view right now is like the full courtroom, and we can kind of see the monitor on the back wall. That's what we're seeing right now.
You've pinned the courtroom. Judge, pin your own.
Let's see if that helps. Nope, can't do it. Turning my camera off means you can't see this at all. All right.
If you pin your
if
own
it does
camera,
help, I do have a copy of her right now with the Exhibit 2 sticker on it from one of the letters that has been sent to us.
Ms. Mike, could you take the document that you have and purport to be your birth certificate and tell us the number in the top right corner?
should say 143-60-06723.
The one that's 143
5060
dash 60 dash 60 excuse me 06723.
It's the same number on this Exhibit 2.
And do you believe that document to be a true copy of your birth certificate?
Yes.
Have you learned or do you know of that birth certificate ever being modified?
No.
Do you know of Mr. Charlie Might ever claiming not to be your father?
No, like I said, I didn't know anything about him. I wasn't allowed to know anything about him.
Did you want to know him?
Oh, I gave anything in the world to know him.
Do you communicate with any of your other family here in Tennessee besides Miss Janie Might?
No, I don't have the phone number to any of them, and I'm not sure if they want to talk to me. I don't know.
Would you like to talk to them, though?
Well, yeah, if they want to talk to me, I'll talk to them.
Okay. Now, your health, you have medical issues that don't allow you to fly, is that correct?
Yes.
Would you be, you don't drive, but would you be able to come ride all the way to Tennessee?
Yeah, I could ride.
Could Uber it.
If my granddaughter could drive me there.
Okay. But you haven't been here. You haven't been to Tennessee.
No.
Long time. Do you know anything about where you lived when you were born?
No.
Do you know anything about where you lived when you were 2?
No.
Did your mother work for the carnival at one time? Do you know?
This is the first time that I'd heard anything about that. Her and I did not get along. She made it very clear that she hated me from the day I was born. So I was only there for her welfare check and in and out of foster homes.
Yes, ma'am. So you had a very, very limited resource to find out information about your family.
Yeah, there's no way that anybody would talk about my dad's side of the family.
Your Honor, that's all the questions I have for Ms. Kathy.
Landlord, do you have questions?
So this is the bad guy. If the attorney was wearing a hat, it would be a black one at this point. The black hat versus the white hat.
I represent Sam Myatt, who was Charlie Myatt's brother. And you had mentioned that he was Charles, but it's Charlie Myatt on the birth certificate. Is that correct?
Yes.
I'm sorry?
Yes.
And to be clear, you never met Charlie Myatt?
No, because I was just a baby when she took off with me.
And you never met any of the Myatt family?
No, it wasn't allowed.
Okay. And therefore, you wouldn't have lived with Mr. Myatt, to your recollection?
Well, I guess if B was with him, then yeah.
Well, if she was, yes, ma'am, I understand that, but you don't have any recollection of that, I guess, to be clear.
Right.
Okay. And there was no contact by Charlie Myatt with you?
He didn't know where I was.
Okay. He didn't know where you were? Who has told you that?
As much as he wanted to find me, and I wanted to find him, I just feel that if this is true, we would have ran into each other. And she made a point to keep changing our names, our state, schools, everything. And so did my grandfather.
So if in 2009, when Charlie Myatt passed away, if it had been stated that he would want 100 times that he would want somebody to track you down, it might be important at that time to track you down. Is that fair to say?
Oh, yeah.
Okay. But no, to your knowledge, no one ever tracked you down in 2009.
True.
And just to be clear, what year was it that you said you received, your daughter received some type of phone call?
It was after he had passed away. Do you remember what year it was?
Ms. Rondo, you can't ask someone else when you're testifying. You just have to ask what your best.
Oh, I'm sorry.
She has a hard time talking sometimes, and so I'm one of her caregivers, I guess. I'm her granddaughter, so I probably know about as much as she does. Sorry, I'm just trying to help her.
Just listen to me for a moment, and all I want to tell you is she and only she can answer the questions, and she cannot have information given to her by anyone else, even you as a caregiver. So just let her answer. And Ms. Rundle, if you answer the questions, if you know the answer, then you can answer it. If you don't recall or you don't know, then you just answer it that way, okay?
Okay. Sorry.
That's all right. I'm assuming you don't testify on a regular basis.
No.
Ms. Rundle, in 1990, where were you living?
In Eagle Point.
Okay. Is that in Oregon?
Yes.
And in 1990, would you have had a cause to seek out your birth certificate?
I didn't even know where to begin anymore.
Okay, you didn't know where to start. Just to be clear, are you saying you've never had your birth certificate?
Right, because my grandmother told me that she didn't have one, and then after she passed away, and my daughter found something that got her going on locating the family, and I couldn't believe it.
Okay. So up until that point, you said you're saying you never had a birth certificate up until it was your granddaughter obtained it.
And my daughter found the family, and Aunt Janie sent me the birth certificate, which was the first birth certificate I'd ever seen. And I was just like, wow. And I asked Aunt Jane if I could talk to my dad, and that's when she told me that he passed away.
Okay. Any other family members? Have you had any other contact with any of the other Myatt family members?
No, I don't have anybody else's phone numbers.
Okay. It was just Jane. All your information, is it coming from Miss Janie Myatt?
Yeah, her and I talk a lot.
Okay. No other questions, Your Honor?
If I could just have a minute.
you applied for that.
Hey, Miss Kathy, my name is Jennifer Roberts, and I'm one of the attorneys involved in this case. Can you tell me over the course of your childhood up to when you settled there where you are now, do you recall how many states and places that you lived over your childhood?
I know we have been around the world. My grandfather moved us a lot because my half brother, which is 3 years older than me, him and I would go back and forth to living with my grandparents, back to be in the foster homes, and then grandpa would go get us out of the foster homes and give us back to her.
So your mother, who you call B, is that right?
Yeah.
Okay, so B traveled all over.
Oh, yeah.
Did she stay? Where were your grandparents? Where were they living?
They were traveling all the time too, which I found out about 6 years ago. The reason we were moving around so much is because my grandfather was wanted by the FBI.
Whoa.
Okay.
What?
So you would flop back and forth, if I understand correctly. You'd be in the custody of your mama for a while. She might get in trouble something, and the state would come take you away, put you in a foster home.
Yep.
Then your grandparents would show up, take you for a while, and then put you back with your mama.
Yep.
And then the whole cycle started again over how long a period of time?
Until I was 17.
And what happened when you were 17?
Well, here in Oregon, when you get that close to 18 years old, you're no longer considered to be in foster homes.
So at 17, you were kicked out of the system, basically.
Yeah.
And then were you on your own, or were you still going back and forth between mama and your granddaddy?
No, I had absolutely nothing to do with her. The last time I seen B was back in '86 when my husband finally talked me into allowing him to meet her. And she came over to our house and proceeded to tell him that she had bought all of her kids their Christmas gifts. And he goes, well, where's Kathy's? And she goes, I hate the grounds that she walks on, and I'm not buying her anything. I just bought my boys stuff.
How many siblings?
4 brothers.
And they're all younger than you. You were her first child?
No, Ronnie was.
Ronnie was the first child.
Yeah, which I just learned is my grandfather's son.
So your father fathered a child with his daughter?
Her dad and her mated.
Okay.
It's really a messed up family.
The judge has a
When
headache.
did your grandmother pass?
Oh,
Beg pardon?
You asked when her grandmother passed?
Yes, Your Honor. What I understand is when her grandmother passed was when her daughter or her granddaughter found Charlie Myatt's name written somewhere. So I was just trying to establish a time frame. When did you?
We were talking about B, and that's why I wanted to make sure who we were talking
Yeah.
about. So,
If I understand it, Miss Kathy, Ms. Rundle, what had happened is that after your grandmother died, somebody was going through some things and found Charlie Myatt's name. Is that right?
yes. My aunt and uncle found some stuff and gave it to my daughter. And my daughter wanted to surprise me by finding my dad.
Okay. So she would have been the one that would, I think maybe Ms. Janie testified earlier that she got the phone book, the Burns phone book, and started calling all the Myatts.
Yeah.
Happened upon Mr. Eugene.
Yes.
And then that's the first contact that you would have had.
Yes.
Okay. All right. That's all. Thank you, ma'am. I appreciate it.
You're welcome.
Wow. Wow, wow, wow.
Ms. Franklin, do you have any questions?
I do not, Judge.
Ms. Vandal, do you have anything else?
Judge, I didn't redirect. I didn't redirect. I don't have any redirect, so I don't know if he can recross.
Well, I think that's true. I think you asked Mr. Vandervoort on cross, and then Ms. Roberts asked, and Mr. So it would appear that you don't have standing to ask any additional questions because there's no other redirect. All right. Then, ma'am, you can remain in the hearing, but right now we won't be asking you any other questions, all right?
Okay, thank you.
Knowles?
I have no further witnesses, Your Honor.
The petitioner has, on behalf of Ms. Rundle, he has rested his proof. Do you have any proof you wish to offer, Mr. Vandervoort?
I do, Your Honor.
Well, let's take our afternoon recess, then allow that. We'll take a 15-minute recess.
Okay.
All rise.
I don't know.
Court is now in recess for 15 minutes.
15 minutes. We're going to skip this break. I don't understand how this works. Oh my goodness. That was some good lawyering there to prevent the Mr. Overall's lawyer, who's the he's the family member that seems to be fighting this. It seems the other family members, some of them like don't know what's going on or aren't involved, don't have a dog in the fight, don't care. But Kathy, okay, she's the lady that testified first. She's like on board. Hey, this is the right thing to do. She is a child, illegitimate child, but a child that has a right to this inheritance as well. And she's had a miserable life. She's literally been bounced around from foster home to foster home, had a mom who hates her, and just treats her awfully, and bouncing from grandparents. Grandparents are wanted by the FBI. What? Just all over the country, never in the same place. Didn't even have a birth certificate until she's, I don't know, a few years ago, a couple years ago. And this finally gets sorted out. This is like the storyline of a rags to riches type scenario where somebody has just had a miserable life and lived just barely scraping by an existence, finds out that they have actually the rich uncle who just died. And in this case, it's literally true. There's this situation where, and don't get me into the family relationships part, because the tree has branches that grow back on themselves. It's all twisted. This is if this goes through, then she has the same right to inheritance that Kathy does to this. Yeah. Wow. All right. So we're going to skip through just a little bit of this because we're almost done. Let's see. Judge comes back here in just a moment. Nope, there he is. Okay. We're going to pick this up. All right, here's the judge. Here we go. Let's see how this thing plays out. Ohio Palm Mom. Nobody's mentioned DNA. I'm not even sure if a DNA test can sort this out. This has loops and things that just get really confusing.
Mr. Vandervoort, are you ready to call your first witness?
Yes, Your Honor. Call Sam Myatt.
Here's Sam. Mr. Overalls. Sam versus the fam, I think is the style of this case.
He's going to come around here.
Other way.
That's where the microphone is.
Okay.
Over here? We had a criminal docket the other day, and they moved it over here. And we have another criminal docket next week on Tuesday that's going to have to be over there. So
You solemnly swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God.
Yes, I do. State your name for the court.
My full name is Willie Sam Mike. I go with Sam.
Sam, how many siblings do you have?
There were 12 born, but one passed away shortly after. 11 had raised.
One of your siblings was Charlie Myatt?
Yeah.
How did he spell his name?
My spelling bad.
Okay. But he's your brother was Charlie Myatt?
Yes.
Okay. And did you ever know him to have any, was he married, ever married?
No, not that I know of.
Okay. Do you know if he had any children?
Not the ones claimed to be.
Okay. So, but to your knowledge, did he have any children?
Well, I've always thought he had two there in Burns.
Okay.
They don't claim him, nobody ever claimed him.
Okay. So, I want to go back to 1960. Where were you in 1960?
Well, I came home out of the Navy and got discharged on January the 6th. I had some leave built up, so I got out early.
Okay. And that was in 1960?
Yes.
And where did you say come back home? What was the address that you came back home to?
It was either 208 or 206.
Was it a box?
Yeah, the box.
Miss Roberts had made a lot out to do
But we
about
didn't
that.
have no, it was just a route number, wasn't no my circle, nothing then, way up later.
Right. It was just a box number,
Yes.
correct? Because I had a box number in my house.
Yeah.
As young as I am. So, at any rate, but there was a box number, and you believe it to be, you think it could have been 206?
Could be what?
206.
It could have been a 208, because they changed it according, somebody moved in, you know.
Understand.
We had 208 at one time.
Gotcha. So you came back home, and who was living at your home?
Me and Richard and Charlie, Mom and Daddy.
Okay. So there is a certificate of birth that has been introduced, and it shows that there was a birth by Kathy Jean Myatt, February the 23rd of 1960. Do you recall your brother being involved with a childbirth?
No, I can't remember Mama neither.
Okay. Did your brother, did he live in Dixon to your knowledge?
He was living at home, sleeping at home. Now, what he done all the rest of the time, I don't know.
Okay.
What he did the rest of the time, I don't know.
Did he ever tell you that I have a child, her name is Kathy Myatt, and I had her with Beatrice Hammond?
I didn't hear the last part of it.
Yes, sir. Did your brother ever tell you that he had a child by the name of Kathy Myatt, and that he had her with Beatrice Hammond?
No.
Okay. Did your family, to your knowledge, ever have any information about generally, like relationship-wise, with a Kathy Rundle?
Well, best thing I can remember telling you, in 1953, my brother Charlie brought home a girl.
Okay.
She was 13-year-old.
Okay.
And stayed there about 6, 7, 8 months, and Daddy and Mama got tired of her and brought her a bus ticket and sent her back to Oregon. Her name was Jean, but I don't remember the rest of it.
Okay. So sent her back to Oregon?
Yes.
Okay. So at some point, it has been said that your brother moved to Illinois. Do you ever remember your brother moving to Illinois?
Well, he'd be gone 6, 8 months at a time during the fairground. The fair's moving. The car is moving.
Did you ever know him to be a sharecropper?
No.
Okay. Did he talk to you about sharecropping up in Illinois? I'm sorry?
No, not that I know of. I hear it mentioned.
Okay. Did your brother, when he would come, you said he would travel for a while, then he would come back. Was he always living in Burns?
Yeah.
Okay. So your brother, he passed away in 2009. Charlie passed away in 2009. Do you recall that?
Yes.
And there's been an obituary that has been introduced. Have you seen that obituary?
Yes, I seen him passed away, and he didn't have no children listed, nothing on it.
Okay. Did you make the funeral arrangements?
No.
Who made the funeral arrangements?
Janie.
Let me ask you, did you have a close relationship with your brother Charlie?
Well, we got along real good together.
Okay. Did he have your confidence and you have his?
Well, not near as close as
I'm
Richard.
going to object as to what that, I don't know what, did he have your confidence? Makes cause for speculation, conclusion, innuendo.
Innuendo.
Meaning you're asking this witness to, or Mr. Vander was asking this witness to speculate as to whether or not
his brother
Charlie has his confidence or had confidence in him.
And I'm assuming confidence means secret. I don't know, again, the definition of confidence.
Mr. Vanderbilt, I think that does call for speculation. Rephrase your question. I understand what you're trying to
yes, sir.
ask.
But, Mr. Bynum, would you and your brother share information with personal information with one another?
Not with Charlie as much as Richard.
Okay. But would you talk with your brother,
yeah.
Charlie? Okay. Would he talk to you if he had a child? Would he talk to you about a child?
I'm sure he would.
Okay.
Again, Your Honor, I'm going to object to that.
Speculation.
Seems to me that would call for speculation on his part for him to speculate that if his brother had a child, he would tell him about it. That's an assumption on his part.
Well, Judge, we've already gone down the trail of allowing the exception you're saying about a family lineage and history, and that's what this is going towards, whether he told him.
I understand this, but you're asking him a non-hearsay question. You're asking him to state whether or not his brother would have told him instead of what he actually told him. Had he told him something, then that might be admissible under that exception.
Lawyering 101.
Mr. Bynum, did your brother ever tell you he had a child with Miss
Asked and
Davis?
answered.
Staying to believe it has been asked and answered.
Up to his death?
No.
Was there a family understanding, relationally wise, relationship wise, of who had what children?
Yes.
Okay. And was it ever a scenario where Kathy Rundle was part of that family dynamic?
No.
Did your sister Janie Myatt, did she ever share any of that type of information with you?
No.
To your knowledge, did she share it with anyone else?
I must not even share it with my mama, because my mama never talked about it neither.
Okay. Was your mother close with Charlie?
Yeah. Took up to him more than anybody else, because he had a kind of rough life.
Okay. How so?
Well, you didn't know it. You've been around people can't always tell the truth, and they're not a good worker. And
okay, but she never mentioned it to you?
No.
So those are all the questions I had.
No.
Mr. Knight, what's your date of birth?
Mine?
Yes, sir.
My mama told me June 17th, 1937. That's what my mama told me.
1937?
That's right. My brother Charlie was 5 years older than I was, like in 1 month. He was born in May 17th, and I was born in June 17th.
What year did you go into the military?
The what?
What year did you go into the military?
1956.
1956. How many years did you serve?
How many years?
Yes, sir.
4.
4?
Turn that microphone towards you, Mr. Knowles, so that he can hear
Sorry.
you better.
I apologize. Can you hear me better
My hearing's
now?
a little bit weak, but I despise wearing a hearing aid.
Well, I understand that. So, you testified you got out of the military in 1960.
January the 6th, I think, the day I got home, or either I got my discharge, I don't know which one.
Okay. And were you living permanently with your parents at that time?
No, I wasn't in the Navy until I lived with them another 3 years after I got out of the Navy, though.
Yes, sir. Were you living with your parents permanently in 1960?
Yes, when I come out of the Navy, I lived with them permanently.
Okay.
And my brother Charlie was there too. So was Richard.
Now, you testified that your address, what was your address?
Well, it's been 206, 208, and box 8. And what time I was there till I come back from the Navy.
Do you know how that address could have got on Kathy Rundle's birth certificate?
Well, I don't have no idea.
If your brother didn't know her or have nothing to do with her, do you know how she would know his address or how any party would?
We had known her mother years before. That's what it said. She came home and let's say for the 6, 7, 8 months back in 53. That's the reason I didn't know the whole name, but it was Morgan. Her name was Jean.
So you're testifying that Miss Kathy Rundle's mother, Beatrice, came and stayed with y'all in 53.
Yeah, and Daddy and Mama said bought her a ticket and sent her back to Oregon.
And do you know if she came back?
I do not know. I was in the Navy for 4 years, and I've heard all this information. It shocks me.
Do you know how old Miss Beatrice was at the?
Well, according to the birth certificate, it backs me up what I was saying. She's 13 in 53. She was 20 when this girl was born. So that backs up my statement. She was, and everybody heard me make the statement. She was 13 when they brought her home.
Okay.
With it.
So have you seen Miss Kathy Rundle's birth certificate?
Not until I got it from Miss Robertson.
Can we pass the witness exhibit 2, please?
But I've seen it. Miss Robertson sent us all one in the mail. But that's one that sent out.
That wasn't the one they sent out. The judge just put something in my cup here.
Your Honor,
a
may
little
I
stronger than
approach
water.
the witness?
Oh man.
Did you tell the court what state issued this birth certificate?
Well, according to that, the state of Tennessee did.
Okay. Now, who does it list as the father of Catherine?
Well, it listed Charlie Roy Mike.
Okay. Could you read the address shown on that document for Charlie Mike?
Where I seen it the other day with that, let me see what it's at now.
If you would direct you to line 18.
Okay, that's what I say, box 206, Burns, Tennessee. Well, that's Burns, Tennessee, where he's living, it backs up. He was at home.
Your Honor, I don't mean to object, but that's the mother's address. That's where the mother lived. It's not the father's address. It's the mother's address.
Well, she wasn't there that time in history.
Your Honor, that's where I was headed with this question, but I agree with.
They said earlier that she should have lived in Dixon. Now,
well, to the extent that that was an objection, it's not in proper form, so I will allow you to question the witness at the appropriate time. But I agree that that is the address that's shown on the birth certificate for the mother of the child.
Yeah, where the mother's living at.
Right. So the mother of the child is shown to be at box 206.
Yeah, in Burns.
Right.
Well, my sister said he's living in Dixon.
I'm not asking the questions. I'm just simply.
I'm just saying.
I do not have a dog.
But that's your address too.
Well, yeah, I'm gonna tell you, yeah.
Okay.
Yeah.
Now, I would also direct you to. Could you testify to the place of birth of the child?
Well, it says Bill Crosby Clinic.
Okay. Do you know where that was?
Yeah.
Where?
Down here in Dixon.
You're in Dixon?
Yeah. Just other side of Dixon Fuel Home a little bit.
Do you have any knowledge or information if this document is incorrect in any way?
No, I don't. But back in them days, when my 5 girls were born, I didn't sign the birth certificate. My wife put them whatever name wanted to. I got 5 daughters, and I didn't put my name on none of them. They didn't ask me. My wife put the name on them and they wanted to put on there. I wouldn't have no way of knowing. They didn't ask me without a daddy.
Just let it go.
What I'm saying?
Whenever Mr. Charlie Mike would leave, where was he going? You said he was gone for months.
He'd go with a fire bunch, came through the Dixie, they called him Carnation.
Is that what Kathy Rundle's mother did?
Yes. When she came home in 53, I didn't know her after 53. She lived that stage with us, I don't know, 6, 7, 8 months.
So you don't know what your brother and Miss Rundle's mother were doing when they were gone with the fair?
No, they weren't fair. Some of her people on the ride or something that traveled.
But you don't know if they were living together and he was
Well, I know they
raising
lived together
them.
when he brought her home. At least they sleeping together. I guess you call that living. Mom was doing all the cooking and feeding.
At least they were sleeping together.
To your knowledge, did Charlie might have any input on his obituary?
Yeah, brother and sisters and niece and nephew.
Yeah, but did Charlie put any of that information on there?
Jamie made the arrangement for it, I know.
Yes, sir. That's not what I'm asking.
They called me and asked me if I wanted to do it, and I told them I'll let Jamie do it.
Okay, yes, sir. But what I'm asking is, did Charlie have any input in it?
No, he was dead at the time, so I don't see how he could.
So he didn't fill out that paperwork.
He was dead at the
didn't.
time.
Nope.
Oh my God.
And it's your testimony here today that he never told you he had a daughter.
Nope.
Did he ever tell you he had a kid?
No, not that much.
Did he ever tell you he was looking for one of his children?
Nope.
You stand to gain extra money by testifying here today, don't you?
Let's don't get any extra money, because you're going to bring my sister in. She's spied, he told you. How did I know she's not splitting the money with that woman to claim she is?
Sir, that's not what I asked. I said you stand
It's going to be money anywhere you go. There's money involved.
You stand to inherit more money if Catherine runs.
Hey, the money ain't the issue. I promised my brother that I'd try to do it right. I feel like I'm interested in the whole family, not just myself. All I want things that's done right.
Does Catherine Rundle favor your family?
I couldn't tell she did.
So you didn't feel like she looked like your family members?
I guess they don't believe in DNA. I don't know. Nobody has mentioned it. No one's mentioned DNA.
You said that you and your brother talked. How often did y'all talk?
Well, we drank beer together and got drunk together, slept in the same little room, had put up a bed, but it was a small place.
Okay. Well,
and you didn't have a big house, so you sat by the fire, you talked.
Okay. Well, once he become an adult and you become an adult and you moved out, how often did y'all talk?
Well, I came back home and talked pretty much. 4 years I was gone. Well, I lived in Michigan a while, and so I was off and on time I was 16 until I went to the Navy.
All right, so he died in 2009.
All right.
Let's say for the 10 years prior to that, how often did y'all talk?
Well, we quit talking, and you don't want probably a family history. Mom was about 87-year-old. Charlie worked a fire tire, and he came home with dinner. Mama was gone, didn't have his dinner, and he was gonna whip Mama. Well, Mama was telling Richard, and Richard told Mama, I don't want to hear about it. You can live with me, or you can live with Charlie. One of us is leaving. So, after that, we didn't talk.
When was that?
Well, that had to be about 89, 88, 87. Mom was born in 2001. I mean, 1901.
So you didn't talk to him for the last 20 years of his life?
If I won't whip my mom, I ain't gonna have nothing to do with him no more.
So you didn't talk to your brother for the last 20 years of his life?
Well,
is that correct?
Yeah, about the last 10, 12 years.
Well, from 89 to 2009 is about 20 years.
Well, whatever.
Is that correct?
I figured it out, yeah.
Okay. All right, so from 79 to 89, how often did y'all talk before?
After I got married, didn't talk very little bit because I had a wife, had families raised.
When did you get married?
1964.
1964. And after that, you didn't talk to him very often. So wouldn't it be fair to say he might very well not talk to you about having a daughter?
Well, it could have been.
If he wasn't talking to you?
Well, he bound to talk to somebody about it. The word got to me. Why would he really talk about it neither?
Why would word got back to you?
Well, Mama always talked about it. Mama didn't know she'd had a granddaughter. She'd have been doing something to help her.
Did you and your mama, did your mama know you and Charlie did not get along?
Well, yeah, whole time we growed up, I reckon, because I'd get on to him because he wouldn't do the fair share of work. And Mom would take up for him.
So wouldn't it be fair to say your mama wouldn't talk to you about Charlie?
No, Mom talked to me.
But she favored him.
She was always wanting to do better. Yeah, Mama wanted Charlie to do better. I don't mind telling you.
Did your mama ever go to get Charlie or find Charlie from the carnival?
The only time she seen him, been gone a while, and we were starved, dead, dirty, Dad spared him, talked to coming back home.
Was that when he was up in Illinois?
Like I said, he'd stay gone, and they'd move around, so I didn't know what they're moving to. That bunch move every week.
That's all the questions I have.
Robert?
Mr. Mike, so if I understand it, in 1953, your then 20-year-old brother, Charlie Myatt, brought home a 13-year-old child and brought her into your mom and daddy's house.
Yep.
And they lived together.
Yeah, they sleep together anyway.
Okay, until your mom and daddy got tired of it and they bought a bus ticket and they shipped her off.
Yep.
But then your brother was going back and forth, leaving the home and going and traveling during this time?
A couple more years he was.
And in 1956, you joined the military.
Yep.
And you were gone for 4 years and you didn't come home until January. You don't know whether you got your discharge January 6th of 1960 or whether you got home January 6th of 1960.
Well, I think the day I got discharged, and I rode a bus home.
Okay, so you would have gotten.
It might have been the 7th day, and I got home.
So this Beatrice Jean Harmon, who is the mother of Miss Kathy Rundle, you said she was the 13-year-old.
When first met her, yes.
But then this birth certificate that was registered in the state of Tennessee says that Beatrice Jean Harmon and Charlie Ray Myatt, a laborer in Dixon County, and she's a housewife in Dixon County, and that she lived at Box 206, Burns, Tennessee. Her date of birth is February 23rd of 1960. So within just less than a month after you got home, this baby was born.
Yeah.
And you're saying you have no clue about it?
Well, she wasn't living at home. She wasn't there at the house I moved back into.
Okay.
Charlie was there, but she wasn't.
But didn't you tell me, sir, that you could have fathered Kathy Rundle? Didn't you stand right there?
I don't mind telling you, yes. Everybody wanted to have sex with that 13-year-old girl.
Well, again, so how old were you? You older than your brother Charlie?
No, he's 5 years older than I am.
He's 5 years older,
I was going on, I was 15, something like that, when she brought her home. He was 20.
So again, I don't mean to air your family's dirty laundry as much as we have, but so that you and both Charlie were being serviced by this 13-year-old child he brought home?
Yep.
And then you stood right here in this court and told me that Charlie was sleeping with her.
Yeah.
And that you were sleeping with her, having sex with her. You were having sex with her. Excuse me. I was trying to use it in polite terms. You were having sex with her at 13.
Yeah.
In your mom and daddy's house.
Well, Mom was working, Richard was working, Henry Ice Eagle, Daddy carried a load of wood to burn. We had a free house most of the time.
Okay. And this brother that you said you were going to make it done right, that wasn't Charlie, because you and Charlie didn't speak. Y'all were not on good terms for 20 plus years, were you?
Well, that was later on in life, though. That was in the 80s.
Well, you were talking about Richard when you said you would make sure it was done right. You were talking about your brother Richard.
That's right. I try to get Richard's point, somebody to take care of everything. He said, if they want to fight over it, let them fight over it. If you outlive me, you try to make sure it's done right. And that's all I'm doing.
And that's what we've already established, and we've had numerous hearings about where you went and you took control, locked up the house.
Well, that's another thing. Now, if we're going to get into that, let me tell you really what happened.
Let's don't get into that.
All right, we'll move on.
There was a non-Irish sitting down and heard her tell stories about me liquidating Richard's wealth when she knows it wasn't right to take a non-Irish word. It's been messed up since day one. And Mr. Odell told me, you don't understand, I'm an executive. I can do what I want to. I can take and believe anybody I want to believe. And I said, surely we got some laws that make you do it right. It's been a mess, I'll tell you.
But Charlie was
made out to be the worst guy on earth.
Charlie was close with his sister Janie, wasn't he?
The what?
Charlie and Janie were close.
Not that I ever knew of.
Well, she took care of him in his dying years.
Well, I got the call to do it first, and I give it to Janie.
And you didn't want to do it. You told Janie to do it.
Well, because I'd waited on Mama. And she might not know nothing about that.
Okay.
But she told you they living in Dixon. The address you're telling me she living in Burns. I don't know what's going on.
And that's exactly right. You don't, do you?
No, I don't, because
You don't know whether Charlie fathered this child, this young lady?
I don't know neither.
Don't know a thing about it, do you?
No.
That's all. Thank you, sir.
His lawyer is looking at him
Franklin, you have questions?
Shut your pie hole. You just talked us out of the case. Oh my goodness.
Mr. Myatt, you testified earlier that you believed your brother Charlie had 2 other children in Burns.
I know what now?
You testified earlier you believe your brother Charlie had 2 other children in Burns.
Well, they don't claim it, and they never claim them.
Okay, but you believe he fathered 2 other children.
I do.
And you never notified the court of this?
Do what?
You never notified the court that there are other heirs out there?
If they won't be known, they take a DNA test.
But you're aware, you believe that he had other children, and you haven't made the court aware of that, correct, until today?
Well, they don't claim it.
What are their names? What are their names?
I ain't gonna say it in court.
You have to answer the question.
You have to answer the question.
Bill, maiden name or married name?
Their current names.
Huh?
Their current legal names.
The name married now?
Yes.
Okay, it'll be May Chandler, and the other one was a boy with Mark Moran.
What was that last name? The last name?
Moran.
Guess
I
what?
never heard that.
We're going to get 2 more heirs in
Was
here.
verified. This died a couple weeks ago, so I can't get it verified. But they get a DNA test done, they can sue me.
Look at the judge.
Is the reason that you haven't told anybody about these children is because
I've told a lot of people about them.
Well, because you want to increase the amount of money you receive from this estate?
Do what?
You want to increase the amount of money that you receive?
I don't want to increase no more money nobody's getting.
I have no further questions.
I'm pretty sure you're aware of what they offered me the other day, ain't you? If a judge wants to know, I'll tell him.
I'm sorry, what are you saying?
Huh?
What are you saying?
They offered.
Judge, I'd object to
If I was
any
dropped
kind of
this
settlement
case,
discussions that was made.
That's an offer of settlement. Sustain the objection. You can't talk about that.
Okay, I don't figure.
You said something about DNA tests. Is somebody taking the DNA test?
Well, if anybody wants to know the truth, they can.
You're willing to take one yourself?
Hey, I volunteered a long time ago. I tell you, that statute of limitations should run out. I told everybody a long time ago. They say, you want your body resumed? I said, no, I'll donate my DNA if they want to compare it. But everybody tell me now, well, the time's done run out and it shouldn't be nothing.
All right. Anything further, Mr. Vanderbilt?
Judge of the Father. Nothing for this witness.
All right, thank you. You can step down. All right, next witness.
Thank you, Your Honor. Putting up with me. I just had a lot of stuff I want to get off my chest.
And boy, did you. Oh my goodness. Oh my goodness. Someone bring the swab. Everyone line up. Line up. I'll pay for them. I'll pay for everyone's DNA test in the room there that's claiming to be an heir, and Kathy's. I'll do it. Oh my goodness. Sam's sitting there. In his overalls.
Big Judge would call Philip Estes.
Just thrilled that he was able to say everything he wanted to say, and his lawyer is like, how do I rescue this sinking ship that my client delivered to me? Oh man, I think
raise your right hand. Let the clerk place you under oath.
I'm gonna do the swab as well. I might be an heir too. Y'all might be heirs. You know, we should all do DNA tests just to see if we might also be long lost heirs here.
State your name.
Philip Dean Estes.
Mr. Estes, who is your parent that is related to Charlie Myatt?
Kate Myatt Estes.
Kate Myatt, that's your mother.
That's my mother.
And she is deceased. And sir, are you familiar with the family, the
yes.
Myatt family? And have you ever known that Catherine Rundle Myatt was a member of the family?
No.
Did your mother Ms. Estes, did she ever bring that to your attention as being a family member?
No.
Discussions with you about it?
No.
When were you born?
59.
Where?
Dixon.
And during that time period, was there ever a engagement with you that you were told about, or otherwise at a family reunion where somebody by the name of Kathy Rundle or Myatt was brought up?
No.
Has that family history that you know about, has it ever included a Kathy Rundle Myatt?
No.
When did you come to learn this?
November 16th of 21, when I got the papers with her name on it.
I think this is a cousin of Sam.
You have a close relationship with your mother?
Yes.
Who was your sibling? You have siblings?
I've got 5.
5 siblings?
Yes.
Okay. You were close with your mother?
Yes.
Would you all share that family history together?
Yes.
Okay. Is this something that was ever brought to your attention?
No.
Did she have a relationship, your mother have a relationship with your Uncle Charlie?
Yes.
Okay. Is he someone that would, that they would, do you have knowledge that they would discuss the family history?
That I wouldn't know.
Okay. Is this something that is ever brought to your attention?
No.
Ever generally known or specifically known that he had a child?
No.
That's all the questions I have, guys.
No, you may cross.
My middle name is Underhill. 23andMe, make me rich. Allison, love it.
Would you state your name again?
Philip Dean Estes.
Mr. Estes, did you have a relationship with Charlie Myatt?
In younger years, yes.
And what does that mean, in younger years?
60s, 70s. Till I got married, then you live in your own life.
Okay, what kind of relationship did y'all have?
We didn't live very far away. So what I guess under 10, going to grandma's.
You was a child during that time.
Right, and then teenager another time, we'd run into him in town.
Would he have ever, do you have any knowledge of why he would have ever talked to you about a child he had that he was looking for?
Those days, our uncles would talk to us about a lot of things.
Okay. Do you know of any reason why he would talk to you as a kid about another kid?
Not as a kid, but as a teenager.
Now, was Charlie gone a lot?
Not in my childhood.
I'm gonna guess you don't remember 1960 through 1964.
No, that I won't remember.
He was 1 to 5 years old.
But in the late 60s, we used to see him over at the fire tower when our grandmother would take us over, or some of our uncles or aunts. There'd be a bunch of us cousins, and we'd go climb the fire tower and visit him.
In the last 20 years before Charlie Myatt's death, how often did y'all speak?
None.
None. What about 30 years before his death? Did y'all speak?
If we run into each other somewhere, yeah, we spoke.
Say hi.
Yeah.
Most just gave each other the bird.
There was no ill feelings there. You just don't see that many whenever you're raising kids. You got your own family.
Yes, sir. No further questions.
Roberts?
Was there discussion with your Uncle Sam Myatt about these other two, what he believed was your uncle's kids that lived here in Dixon that would be?
I hear a lot of stuff and I don't pay no attention.
Well, I just wondered, again, you talked about whether or not was it ever discussed that Charlie had kids?
No.
Including the ones including the two that are well-known individuals here in Dixon?
All my life, 3 of the uncles had no children. All of my life.
Right.
That was Edward, Richard, and Charlie.
Right.
There was never no children.
And there wasn't any.
If there's any unknown, I'm not going to know it.
Well, but and that's it. But it wasn't the.
I'm gonna refer
when
you all
were talking
to
when we got
23andMe.
teenagers, our uncles talked to
They was
you
our
a lot.
uncles, and we was teenage boys and out running around chasing women. What boy you do and go at
This is my referral
dances,
code.
whatever we did at 16, 17, 18.
There wasn't conversation about,
No.
It doesn't cost any more for you to use
playing
that,
ball
but
with
if you
one
do
of my-
use that
one of my
code to do
kids or-
23andMe, they do give me a little a thank you So maybe I'll be able
Franklin,
to purchase
any questions?
referral or
Read
23andMe's for all this family.
Thank you, sir. You may stand down.
Okay,
Have a seat
thank
in the
you.
courtroom.
But if you do want to do a DNA test, that's a link that can get you there.
Buchanan.
Do recommend it.
Stand here, face the clerk, raise your right hand, be sworn.
You are James Buchanan?
Yes.
And who is your parent that's related to Charlie?
Edith Buchanan.
Okay. And has she passed away?
Yes.
And do you know the family history of your family, the Myatt family?
A lot of it.
Okay.
I can't say I know it all.
Sure. And to your knowledge, you've heard testimony from your cousin Philip that your uncles had no children. Is that what your understanding is?
I never heard of it.
Okay. Did you have a relationship with your mother that was close where you would talk about those things?
Oh, yeah.
And did your mother ever disclose to you that you have a cousin through your Uncle Charlie?
No.
Did they have a relationship, to your knowledge, Charlie and your mother?
Yes, as far as I know.
Okay. And was that family relations, would they have talked about that?
I would have thought they would have. I mean, I wouldn't. She never mentioned anything about it. And
When you were living, what year were you born?
53.
And where were you born?
Michigan.
Okay. Did you move here at any point?
We moved back in 59, I think it was.
Okay. So you moved back in 59. You would have been how old? 7? 6
Cameron's
years
having
old.
a hard time focusing on
And
the
do you
beard.
remember that time period?
Bits and pieces, off and on, just.
Growing up, have there ever been conversations with your uncle Charlie that he had a child?
No.
Okay. Any ever mention of it?
Not to me. We never discussed anything like that.
Okay. Did you have a relationship where he would discuss things like that with you, personal things?
I wouldn't say we had a relationship. We never talked anything like that. We talked just stuff in general.
Ever disclosed to you throughout his lifetime that he had a child?
No.
Those are all the questions I have.
Mr. Knowles, you have any questions?
Briefly. Mr. Buchanan, could you tell me about your mother and Mr. Charlie's relationship?
Brother-sister relationship.
Did they talk often?
I couldn't say how often they talked. I knew they talked. I couldn't say how often.
Did he come over to your house?
When I was a teenager or younger, oh yeah, I've seen him some.
How often is some?
Well, like I say, when I was growing up, on Saturday night, a lot of times we'd all go to the square dances, and he was there.
Square dances. Bingo.
Like I said, we'd go on hay rides, and he'd be over at the fire tire and stuff like that when I seen him. Went camping once, he come picked us up.
How many times did you talk to him in the last 20 years of his life?
I don't remember even talking to him, because I don't remember seeing him.
Okay. What about the last 30 years of his life?
Last time I remember exactly I might have talked to him was when grandmother passed.
Okay.
I can't remember exactly when that was.
Okay. Of course, those times wouldn't have been in a setting where y'all would have ever discussed something like this.
No.
No further questions.
I don't have anything, Your Honor.
Ms. Franklin? You redirect?
Just very briefly, the conversations that you had with your uncle, again, there was never a conversation about having a child.
No.
Any conversations with Janie about having a child?
No.
Is she someone that would have shared that with you or your mother?
No. Well, we never had any conversation, anything.
Is Janie Lewis Myatt the type of person that would have shared that information with family members if she had known it?
Oh, yeah.
Was it shared to your knowledge?
I don't know what she might have shared because it never was shared with me.
Okay.
And nothing was ever told to me about Charlie.
Does she and your mother, Janie, and your mother have that type of relationship where they would have shared that type of information?
Oh, yes, yes.
Okay. Would your mother have shared that with you if that had been information she'd received?
Yes.
No speculation.
Was it ever received?
Objection.
No.
Miss Janie Myatt, was she you've heard her testimony?
Yes.
And was any of that ever shared, any portion of it shared with you or shared with your mother, to your knowledge, about a family history?
Well, my mother never shared it with me. It was shared with her. Okay. She never brought it up, and we talked about Charlie and Uncle Richard, and this, that, and other, and it was never brought up anything about Charlie having a kid.
Is that something your mom would have mentioned to you?
Oh, yes.
Okay. No other questions, John?
Briefly. So is it your testimony that Janie Myatt's just lying?
No. I didn't say she was lying. I said that information never was shared that I know of with my mother, and my mother didn't share it with me.
Do you believe her to be a truthful person?
No.
So you believe she was lying today?
I can't say what she's doing.
Is it true that she would receive less money if Miss Catherine Rundle is declared an heir by this court?
What now?
Is it true that she would receive less money if Miss Catherine Rundle is declared an heir by this court?
Who would receive less money?
Miss Janie Myatt.
I guess.
You would receive more if she is declared not to be an heir, is that correct?
I guess. I haven't done the math. That's all.
If math is involved, it's probably a bigger number. Because I realized that I told you
They call Larry Byram.
I shared a link for 23andMe. They did have a data breach in December. I used to work in this field. They had about 0.1% of their accounts accessed, which was 14,000. They emailed all 23 million customers to tell them about it and to make them change their passwords. I'm confident in their security, especially after a breach, that they've fixed any problems. So I don't have any problems.
Mr. Byram, state your name, full name.
Larry Byram.
And who's your parent that is related to Charlie Myatt?
Elizabeth Myatt.
Elizabeth Myatt.
I'm sorry.
She goes by Martha for a while and Elizabeth, but yeah, Martha Elizabeth.
What was the relationship between your mother Elizabeth and Charlie? They have a good relationship?
Yeah.
And between your mother and Charlie, did you all talk about a family history?
Sorry, I said 23 million. They have 5.5 million.
Okay. As far as your uncle Charlie, did he ever disclose to you that he had a child?
No.
To your knowledge, did your mother ever disclose to you that your Uncle Charlie had a child?
No.
Did they have the type of relationship where he would have shared that with her?
I think it would.
Okay. And in fact, your Aunt Janie Myatt, did she ever disclose anything like that to you? Did your mother and Janie Myatt, did they have the type of relationship where they would have the conversations about Charlie?
They talked a lot, yeah.
Great. You heard the testimony of Miss Janie Myatt.
Party members.
And in fact, was it your mother that was at she says was part of making the funeral arrangements?
Yes.
Do you recall that?
Yes.
Do you recall having discussions with your mother about the family
I didn't
arrangements?
discuss the funeral, but her and Janie did that.
Okay. And you've seen the obituary for Charlie Myatt?
Yes.
Okay. And is that your understanding of the family of Charlie Myatt?
Yes.
Did you ever know of during Charlie Myatt's lifetime of him having a child?
No.
When were you born?
53.
Where were you living? Okay.
I was born in Michigan.
Born in Michigan, but you grew up in Burns. When did you move back to Burns?
I was about 2 years old, I was told.
Okay, okay. Obviously your mother and your father were living there?
Yes.
Okay. Did they live in the Myatt Loop area, the area that's called Myatt Loop now?
Buddy Road.
Okay. So is that a close-knit area?
Yeah.
Okay. Has there ever been a understanding in your family dynamic that your Uncle Charlie had a child?
I didn't hear it public till lately. So.
Okay. Thank you, sir.
No.
Mr. Byron, could you tell me about your relationship with Mr. Charlie Myatt?
When I see him, we got along pretty good. But
Okay.
several years you didn't see him.
Okay. Well, in the last 20 years of his life, how many times did you talk to him?
A few times. I'd see him at Captain D's every now and then. But
And was those conversations just, hi, how are you doing?
pretty much, talked a few minutes.
Wouldn't have been a setting where y'all would have talked about as child Catherine Myatt.
Probably not.
And how often did you see him back in 1960?
Saw him quite a bit then.
Okay. How? How would you see him?
My grandmother's.
Okay. And how often was that?
For a while, it was just about every weekend.
Okay. And do you remember him being gone for long periods of time?
I remember when he was at Carnival.
And during that time, would he be gone for long periods of time?
He was a part of the forestry department, firefighter, California, Oregon.
Now, do you know Miss Janie Myatt?
Yes.
Okay. Did you hear her testimony?
Yes.
Do you believe she was telling the truth?
It sounds like she's telling the truth as far as she knows.
Do you know of any reason she has to lie? Let's see. So you would have become an adult around 1971.
Yeah.
Which would have been about 11 years after Kathy Rundle was born. And do you believe your uncle would have ever talked about this with you?
It looked like he'd have talked to somebody.
But you said you believe Miss Janie. He did talk to her about it though, didn't he?
According to her, he did.
Now, was it true that she cared for him before his death?
Yes.
Took care of him? Did Charlie have a good relationship with your mother?
Yes.
When did your mother pass, sir?
2019.
2019. How old was she at that time?
86.
86. Nothing further, Your Honor.
Roberts?
Just briefly, what does it matter to you whether Kathy Rundle is declared your cousin or not?
Well, if she's not, she shouldn't get the money, but if she is.
She should. Okay.
If she is.
Now, again, a lot of this family history things that you said wasn't disclosed. Did you know some of the stuff that, seedier stuff that's come out today, did you know that your uncles were swapping a 13-year-old child for sexual favors?
I've heard Sam talk about it before.
You did hear him talk about it before? And that they were having sex with a 13-year-old, sharing a 13-year-old?
Yeah. Just from him, I don't.
Beg pardon?
Just from him, I don't know anything else.
Just from who?
Sam.
Just from Sam. When did you hear that from Sam?
A few months ago.
Just a few months ago. After Mr. Richard died and all this started coming up is when he started talking about his sexual exploits.
Yeah.
That's all.
Franklin? Redirect?
Just briefly, so to your knowledge, your uncle Sam was telling you that, but he would have been 14 at the time? correct?
I think so.
Yeah, he was 14, she was 13, correct? Okay.
Charlie was 19.
Your mother was, you were asked about Miss Janie's, if she was being truthful or not, but your mother was there making the arrangements with her, to your knowledge, for their funeral arrangements. And if it was an issue that your uncle would want this child to have been found, your mother, would she have known about that if it was a family member?
I'm gonna object.
Stan, I think you're calling for him to speculate what his mother would or would not have thought. So.
I'll rephrase, Judge. Did your mother ever tell you after the funeral arrangements we need to find a daughter? No. Ever bring it up to you that was an issue for your brother that had been disclosed because it was his daughter? No. Okay. That's all I have, Judge.
Any further recalls?
No, Your Honor, nothing from me.
All right. Thank you, sir. You may stand down. Mr. Vandervoort, you may call your next witness.
Judge Sheila Woodard.
Stand right here, turn to face the clerk, raise your right hand, please.
This is the last of the cousins to testify.
State your name for the court.
Sheila Marie Buchanan Woodard.
And who is your parent that is related to Charlie Myatt?
Edith Myatt Buchanan.
Edith Myatt Buchanan. And did you and your mother have a good relationship?
Yeah, definitely.
Okay. Did you live with your mother for quite a period of time other than your childhood?
Yes.
Okay. From when to when?
From 93 to 2011 when she passed away.
And from, what was the relationship between your mother and your Uncle Charlie? They had a close relationship, or?
Yeah, I mean, he didn't ever come down to the house, but yeah, I mean, I think I don't know if they ever talked that much on the phone either.
Okay. How about her relationship with your aunt, Janie Myatt?
Yes. Janie used to call her all the time.
Okay. Close relationship?
Yeah.
Kind of relationship that with family history be disclosed?
Oh, yeah.
Okay. In your lifetime, have you ever known your Uncle Charlie to have a child?
No.
Okay. Did your mother ever discuss with you that your Uncle Charlie has a child? You have a cousin?
No.
Did your aunt Janie ever discuss that with you?
No.
Ever, to your knowledge, ever discuss it with your mother?
I don't know if they discussed it, but, like I said, Mom never disclosed it to me.
Okay. Is that something?
And, yeah, we talked, yeah.
Was that something she would have disclosed to you and talked about the family history?
Yes.
And was it ever?
No.
Is that something that, to your knowledge, that your mother and your Aunt Janie would have talked about the family history?
It's possible.
Okay.
Because, I wasn't there. I worked, so I wasn't there, The family's always talked.
Okay. Is your
Especially
aunt,
the women.
Gotcha. Your Aunt Janie, is she that type of person that would talk about those type of things?
Yes, I believe so.
And you have heard her testimony.
Mm-hmm.
Was any of her testimony like that ever disclosed to you?
Any of what she was talking about?
Yes,
no.
ma'am. How about, did your mother ever relay anything like that to you?
No.
Those are all the questions I have.
No.
Miss Woodard, is that correct? Miss Woodard, what was your relationship with Charlie Myatt like?
Well, me being a female, it was nothing after we got, I got of age and moved out. When we was kids, still at home, we'd go down to grandma's every week or every other weekend.
So from the time you was 18 on, you didn't have any dealings with him or some communications to amount to anything? Okay. When were you born?
1955, July 2nd.
When did your mother pass, Miss Woodard?
December the 11th, 2011.
After Charlie passed, did you ever learn about Miss Catherine Rundle?
No, sir.
When did you first learn about her?
And after my Uncle Richard passed away and the proceedings started, the first letters we got sent out about his estate, her name was listed and everybody was wondering who she was.
Okay. So did your mother have a relationship with Eugene Mike?
Yes.
Okay, so he, to your knowledge, he never told her about these phone calls that happened in 2009?
No.
Now, would this have been something you and Charlie Mike would have discussed? Him having a child?
No. He was gone a lot. I mean, he was with the Carney and he was gone even when we were kids. He was gone a lot except for when he was working at the forestry. And that's what all of us kids used to laugh about. He was a Carney and he was gone.
Sure. Yeah. So you don't know if he was gone with Miss Kathy Rundle and her mother as a family? You don't know what was going on, do you?
No.
And I'm going to assume you don't remember 1960 when you were 5.
Okay, so
That's all I have, Judge.
Was it Charlie's money?
Roberts?
Or
It
was it
wasn't
his
discussed
parents'
about
money?
these other two potential children that Charlie fathered either, was it?
No.
I mean,
Never heard, no.
Sam never brought that up during the course of anything and said, you know, do you know these two people that he said?
Yes.
Okay.
I never would have thought, I didn't know it until.
Yeah, until just now. That's all. Thank you, ma'am.
I took a test through Ancestry.com with one of those DNA tests. Found out I got relatives all over the world and everything. I was, there's some of whom I've never met in my whole life. They're distant cousins. Have you taken any sort of test like that?
No, I'm scared too.
I'm scared too.
There's a lot of people that I have talked to that get on Ancestry and have traced back family lineage,
This is what I was trying to do. I understand after today why you might not want to take free blood. All right, thank you.
I'm scared too. I might see connections that I hope were not there before.
Mr. Robert Vandervoort, you may call your next witness.
Senator, that is our proof. Go for the witnesses.
All right, Judge.
Any rebuttal proof by anyone? Ms. Roberts, do you have any other proof you wish to offer? Mr. Knowles is.
I do not, Your Honor.
Just tagging along, Judge.
So, let me ask this question. Mr. Sam Myatt says he'll take a DNA test. Why can't we do that?
Never been offered in my estimation.
Do what?
It's never been offered.
Judge, well, it has, not formally has it been offered, but the conversation that she said she overheard in the same breath, Mr. Mott said, well, I'll take a DNA test. So, but if the court orders that, that's what we'll do. We're ready and willing to do that.
It seems like to me, I mean, these are all good folks. I don't have a problem with them. It seems to me that what they just don't know, they never heard of this person, and they say if they're blood relatives. I mean, I've got relatives out there, as I said, that I have found out through Ancestry.com that I didn't know I had. I'd like to meet some of them and get to know them, but it seems like all I do is appear here in court. So anybody have an objection to me ordering some sort of testing that would determine one way or the other about this issue?
Make it happen, Judge.
Well, I really do, because I've been volunteering this now for 3 years.
So you'd be willing to take one of these things where you swab?
I mean, why would they wait 3 years, all this argument going on when they know when it first
I can't
started?
answer that, Mr. Sam. I can only tell you that I'm trying to find a solution to your problem that's fair to everyone. And if this woman happens to be the daughter of your brother, by biologically proving that, would you be okay with that?
Well, I would, but I'd rather see it by Tennessee law. Why did it take so long? Jamie told you that
the girl was living in Dixon, but she put down in Charlie when Norton was born, so living in Burns.
Judge, may I have a chance to talk to Mr. Burns?
One of the family members just joined Sam on the
Judge,
table.
Mr. Meyer is willing to do it, as soon as the court orders it and have it, we will order it.
Judge, it's purely your decision. This whole thing started out as to whether or not Ms. Rundle had standing. There has never been, I found out and included her when I asked this estate to be open. I included her name because Ms. Janie, who I'm representing in opening this estate, said that she was an heir. When I discovered that this was going on, we brought it to the court's attention, and then that's when Mr. Sam Myatt, through his counsel, said, no, she's precluded by law from claiming. So it was never an issue. A DNA test seems the most logical thing to do. And
I'm going to fix the problem. And you remember a judge that we used to have, what was his name? Leonard something. Leonard. When I was trying a Ada Whittemire murder case, he told me, when I was objecting to some evidence coming in, that he says, young lawyer Wolf, a trial is a search for the truth. I never really understood that at that point, but I do think that this is a case where the trial should be about what is the truth. I think that's what Mr. Sam wants. I think that's what all these family members want. I think that's what Miss Janie wants. I think that's what Miss Rundle wants. If Miss Rundle's not the biological child of Charlie, I think she'd like to know that so she can keep looking for her biological father. So it seems to me that everyone, I'm going to rule that she has standing to assert this claim, because of the fact that I don't think she was given proper notice the first go round. She filed her claim within the statutory period after the renotice. And for this court's consideration, I'm granting her that opportunity. The rules allow the court to expand in certain instances those things. But let's figure out, and I want Mr. Vandervoort and Mr. Knowles and you and Ms. Franklin and anybody else who has a dog in this hunt to get together and determine a manner in which DNA testing can be done that would determine, a lot of times these cases, as you know, are that you've got a deceased individual and there's no way to test that without exhuming the body. But my understanding of DNA is that testing a brother, a close biological relative of a brother, or even a sister should, but the brother would certainly be almost exactly the same as having the same. It wouldn't be an identical, but it would be close enough that you can determine if she's excluded, then she's out. If she is included because of the familial relationship, then it substantiates the claim. And I think that satisfies all the folks on the other side of this situation. So this court is going to rule that she has standing to assert a claim, and that the parties will coordinate to determine if Mr. Sam Myatt says he will agree to a DNA testing, and now it doesn't require blood transfusion or anything like that. They swab the inside of your chicken. That's brachial
swab test is what they...
Buccal swab or something like that. But it is a test that they can take, and they can determine whether or not there is a familial relationship. So we're going to order that, and we'll reserve ruling on any of the other aspects of it until that time. Mr. Knowles looks like he wants to stand up. So
My DNA is on.
Not you yet. Hold on. I'm not certain, but we will have to check. That may require female DNA.
May require female.
To show the.
You know what? Do it all. Let's do Miss Janie. Let's do Mr. Sam, and let's do your client. Let's do one of each, all three of them, and have them all compared. Anybody else who wants to submit a DNA, they can do that. All I'm looking for is to determine what scientifically can be proven from that. So we're going to reserve everything else in this case until such time as quickly as we can get these tests done. It ought not to be that difficult to get done. She's wherever she is in Oregon. She can she can go someplace, they can submit it, send it to the same lab by a certified, means, and have the testing all done at the same lab by having her DNA sample taken at a lab, having it transported to the lab where Mr. Sam Myatt and Miss Janie are going to have theirs done. You go from there. So.
And I think that's it. My position and what I understood is that Mr. Sam Myatt, through his counsel, were contesting that, which
matter
we didn't even
whatever
have the right to ask for DNA testing because the statute had changed. And so now you're saying she does have standing and we can do the DNA testing, and it will be accomplished. And then depending on the outcome, again, we're doing familial DNA.
I think it really just boils down to, we all know that the significant results. If Ms. Rundle is found to be an heir, then she stands to inherit a couple of $100,000. If
There it is.
she is not an heir, then that is divided between the remaining heirs, and they each get about another $28,000. Mr. Myatt does not strike me as being in it for the money, and nor do I think Ms. Jane was in it for the money. She just says what is right, and we're going to try to figure it out the way that everybody can be satisfied. I can't tell you, Mr. Sam, why it's taken 3 years to get to this point, but I can only tell you that now that we're here, let's fix it so that everybody knows.
Mine done on 2030 me and Ancestry.com. Both of them got my DNA.
Well, you and I might be related.
You and I get
I'm on Ancestry.com. You and I might be related, so I don't know. So
I don't know.
Sounds like I've done them both.
You see
I might have had some relatives who were carnival workers too. I think one of my relatives was a barker for the yak lady. So.
You see on the news where this morning, a half sister basically for a half brother didn't know it.
All right. We are going to, anybody else have anything else before we?
Yes, Judge. I just want to point
That
out.
was really a rhetorical question. Go ahead, Ms. Franklin. What?
So it has come to the attention today.
And you're going to, if that microphone's on, you can use that microphone. Otherwise.
Sure. We turned it off earlier, Judge. With there being potentially 2 more heirs that were testified to today, I believe I need to do some further investigation. In the partition action, I was appointed as the guardian ad litem both for Henry Eugene Myatt as well as any unknown heirs. And at that point in time and until today, no one knew that there could potentially be 2
You
more
have
heirs.
leave to contact those individuals and find out if they want to assert a claim. My opinion is if they don't want to assert a claim for obvious reasons they may have, then they have waived any claim that they may have.
Like that's
But
not
I
my
think that's
family.
something you need to explore is in that particular
So
situation.
2 more heirs as well.
All right. Anybody else have anything else?
Everyone's pieces of the pie are getting smaller and smaller.
No? All right.
Good job.
The order is that all y'all will cooperate on how you're going to get this testing done, and then we'll reserve everything until that result is back. And that being our last case for the day, since our other case was continued, we stand adjourned.
There you go.
All rise.
The order is.
Court's now adjourned.
The order is, and if you read it, is that all y'all are going to go get your DNA testing done. Oh my goodness! What a great trial! What a great wow! I don't know who's going to act and play the different roles on this when this gets made into a movie, which it should be made into a movie. Should happen. Maybe we need to get with Rob up at Law and Lumber. He does family law. We've got Matthew Harris as well. He deals with a little bit of family issues as well. I think we need to find out just how normal what we just watched is. Does this happen all the time? Oh my goodness! I want to get. What was it? Was it Kathy? Who was it? The first lady that testified? Was that Kathy? I want to get her on the show. We need to talk to her. She is amazing. She's like, I don't care about the money. We're doing what's right. We need her. Oh my goodness. That was amazing. Wow. Every family has a few secrets, I guess, and theirs was no exception. Apparently back in the day, age was not as important when you were looking at starting relationships with people.
Is it okay to leave the Zoom?
Yes, you can. Sorry. Who is that? Who's on Zoom? Who's on Zoom? Bailiff's just going to come in.
Officer.
He's just going to.
Yes, you're good to leave.
Thank you so much. I appreciate it.
Well, that's what
All right. Is it okay to leave the Zoom? Anyway, that's funny. That was Janie or Kathy. Janie. Aunt Janie. Kathy was still on Zoom, just hanging out. Wow, I feel better having watched that. That was just amazing. What a incredible thing. You should definitely hop on over to Friday Night Frenzy tonight and tell Rob about this case. This is nuts. And just this judge, by the way, this Judge Wolf here, as he's he's ditched his robe, probably taken a whole handful of Excedrin to try to get rid of the headache he had. He's done for the day. He says he's actually going to be testifying before the legislature. He's trying to get help to cover his workload. He's like, we need another judge here. I'm supposed to testify before the Congress, before our legislature, and I can't. I don't even have time off to testify. That's how busy I am. So he's back at work there. Oh my goodness. A quick recap. Okay, here's what we had. This is, if you just joined, you need to go back and rewatch this, and I'm going to tell you why. Okay, we have what would appear to be just a little family estate settling dispute, where we've got a family with 12 children, and some are living, some have passed away, and their descendants there. We've got cousins, and anyway, but the one who had the money passes away. And the money is supposed to be dispersed evenly amongst the heirs because I don't think there was a will. So they're trying to assert their position and say, hey, this is I get a piece. I'm the heir. I get a piece of pie. Some heirs are there. The brother's there, and then on the list of people who are heirs, there's this name that nobody recognizes except for one sibling. And she's like, yeah, I found a birth certificate in my my brother's documents when he passed away. And he had an illegitimate child with this lady, and we found her, and here she is, and she gets a piece. And everyone's like, wait. Well, Sam particularly says, the coveralls guy says, wait, that's not right. We're not going to. Turns out, I don't mean to spoil it for you, but I'm going to. So spoiler alert, Sam and Sam's brother shared the same girlfriend who was 13 years old at the time. Sam was 14. His brother was, I believe, 5 years older, which would be 19. Crazy. And anyway, good people. They're good people. They've got messed up history. They lived a hard life. Somehow they came into some money. I think the family farm was sold, which, the family farm originally was probably very cheap when they bought it, and now it's appreciated to a considerable sum, and then it was sold. Ends up being a couple $100,000. If this lady who was the child of this relationship with the older brother, we think not Sam, if she does have standing, if she's an heir, she might get a couple $100,000, and that that could be life-changing for her. She's had a terrible life. Her mom hated her. She was bounced around from foster homes around the world. Her grandfather was wanted by the FBI, and they were always on the run. Just crazy stuff. You need to listen to this. We need to go back and have somebody, and I'm not sure who's going to be, but one of you has to just step up and take the responsibility. We need a family tree. Include all the pertinent data. We don't need like the day of birth, but I've already started. I've gone out here. Let me see what I can show you. I've got. Let's see what we've got here. I'll put this on screen 3. I've got Charles Roy Myatt's gravestone right here. This is gravestone. Rest peace in the valley. It says we've got flowers and everything on there. We've got that. I've also found his mom that we knew was Martha Elizabeth. We've got some of her information. She's out there, so we can find that. Some of this should be pretty easy to find. Some of it might be a little bit more difficult, especially with living relatives. But do your homework. We're going to switch from perusing court dockets and things like that to digging in Ancestry.com and find out where everything is. Can we figure out how to follow up on this one? I don't know how long it's going to take. I don't know how long it's going to take for, first of all, for the players to agree on the platform, whether they're going to go 23andMe or whether they're going to go on Ancestry.com to get their DNA testing, and then all get the testing done, and who's going to pay for that. I think that's all going to be sorted. The lawyers will sort it out. Then the testing goes out. Then it all comes back. It takes a couple of weeks, I think. And then we have the problem of the judge is a rotating judge. He has several different places he goes to take care of his workload. And so I don't know what his schedule is because he's like booked up. So this might be like 3 months out. It might be, 1 month out. I don't know. We'll need somebody to dig up on that side. Amber, maybe you can do that, find out what that case is, and put a little flag on it in case it comes up again. Oh, wow. Lots of fun. We have to follow up. Honestly, I'm rooting for the new unknown child, the unknown heir. I believe it would warm my soul to find out that she, in her older age, where she has a little bit of health concerns, and makes things difficult. Life is difficult. If she just comes into some money and just makes it a little bit more cushy for her, that she's able to do some things or take care of some health concerns that she has, that would be awesome. All right, that was cue the Benny Hill music. I've only got this one. Wow, what a case, right? That was amazing. All right, I think it's 2:00. It's Friday. It is Friday. All day. We're waiting for this all week, but I think we're going to let everyone go this afternoon a little bit early. I think we might. Let's see, is Brandy on? Let's see. Brandy. Where's Brandy at? Brandy Churchwell. Oh, she's live right now. Okay, so Brandy has an interesting case going on with the Draconis case. I think there's developments in that one that might be fun to watch, even if you haven't followed the case up to this point. So that'll be good to go check out. Tara-ized, my email is mdrecoveryaddict, like Dr. Recovery Addict, but really it stands for metal detecting, mdrecoveryaddict@gmail.com. That will get to me. You should be able to find that on the YouTube page as well. All right, so yes, long weekend. Oh my goodness. Here's the situation on that. It's President's Day here in the U.S., which means President's Day is a holiday we celebrate. Not because it's a certain president's birthday, more than it's just like there were lots of presidents who had birthdays about this time, and we just celebrate all of them together today. And we do that by not working, because what else would they want, right? So we take the day off. So we have a long weekend. We have a great trial to start the weekend off of. We had an amazing podcast last night. Thank you very much, Thomas. That was so much fun. Appreciate all you guys who went there. If you haven't watched that, that would be a great thing to watch as well. We're going to portal people over to Brandy Churchwell now, because Brandy is doing her live stream, catching up on the trial this weekend. So if you missed it during the week, she's doing catch up now. And this was good. Thank you. I can't take credit for this. Who was it? Was this Amanda? Who was asking? I don't remember. Somebody told me and said, hey, Judge Wolf has one right now. You've got to check out. I don't remember who it was, but thank you very much for tipping us off on this one. I'm glad we could watch the rest of it here. They can use a specialty lab instead of Ancestry or 23andMe. Those are probably going to be a little more expensive. There was someone in chat yesterday that tipped us off. They're amazing. Where's the dancers? Nosy Rosie, you are part of the dance team. I expect you to be dancing to this one. Have to work on Monday. I'm sorry, Lisa. I'm sorry. Guys, thank you very much. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again Tuesday morning about 8:45-ish. We're hoping to have a new case, so if you see something coming up, let me know. We'll see if we can get it on the docket for everybody. You guys have a good weekend. We'll see you. Bye. We're portaling to